In the name of each petitioners, okay. ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಶೇರ್ ಅಂತ ಬಂದಿಲ್ಲ. ಆಮೇಲೆ remaining
Who are
amount.
these people? Petitioner number 1 is the mother.
Petitioner, first petitioner is the wife.
Ah.
Second, third, fourth petitioners are
Are
children.
Are
Children of the deceased. ಆಮೇಲೆ remaining amount ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇಲ್ಲ.
Cool. Peruse the order dated 31/8/2023 passed in this petition. It is seen that though this court determined the compensation, but there was not but there was no mention about the apportionment of the compensation amongst the claimants. Hence, it is ordered that 25% of the compensation shall be apportioned to each of the claimants. Full stop. This order shall be read in conjunction with the order dated 31/8/2023.
For non-compliance office objection, first time, serial number 226.
Serial number 5, my lord.
1 week.
Serial number 5, my lord. Objection is annexure B, D, and J. Xerox copies are not filed. B and D are the applications. I filed the office copy. J is the written statement of defendant number 3.
You not filed the photocopy into there.
Other photocopy, whatever, B and D are the application. Office copy I filed. J is the written statement of defendant number 3. Whatever served upon me, I filed before this.
Whatever served upon
This
Namga.
is the correct written statement.
No, but
Annexure J is page 50.
no, if it is legible,
It is legible. Page 50. It's a written statement of defendant number 3.
Merkel, office objections at serial number 1 is overruled. List the petition for preliminary hearing on
Wednesday, my lord.
Wednesday.
Grateful.
Serial number 6, I beg your lordship to kindly take it up because there is some urgency in this matter. Court commission application, though I filed my objections to the FDP and informed the final degree court that in 2005 itself, the Muslim gentleman who
There's some
got-
OS judgment to be furnished until the end.
have furnished, my lord, I have furnished the certified copy itself. ಸರಿ, A1 ಅಂತ ಮಾಡಿದ್ದೀನಿ. That this matter arises out of a partition suit filed amongst the family members of Nazir and others. They had already sold the property to me in 2005. I have narrated in my written objection statement as well.
What is the stage before the final decree report?
Commissioner has to bifurcate the property and give the report on Monday.
Good. Office objections shall be complied during the course of the day. If office objections are complied, list on date. Good.
5th December.
Yes.
Interim order I have sought for.
Second.
Comply, Madi. There are so many cases where we have,
I'll undertake to comply.
sir,
Interim
there are so many cases where we have granted interim order, but office objections are not complied for 2 years.
No, my lord, we have whatever.
Everybody, ಅದು ಎಲ್ಲ ಯಾರೋ ಒಬ್ರು ಮಾಡೋದ್ರಿಂದ ಎಲ್ಲರಿಗೂ
Appeared, my lord, lordship direction has been
ಏನ್ ಮಾಡೋದು
sacredly followed.
ಸೀಕ್ರೆಟ್ಲಿ ಇಲ್ಲ ಎಲ್ಲರೂ ಮಾಡ್ಬೇಕು ಯಾರೋ ಒಬ್ರು ಮಾಡಿದ್ರೆ ಎಲ್ಲರಿಗೂ ಬರೇ ಬೀಳುತ್ತೆ.
Monday, my lord, they will
ಆಯ್ತು.
give the bifurcation
ಯಾವತ್ತು ಬೇಕು?
order.
5th December.
5th December, yes.
But till that
So
time,
second
the
time-
No,
interim
sorry.
order will be granted.
Non-compliance, second time, serial number 7, KP Bhuvan.
One week time is granted to do the need. Yes, next.
For list number 1 for orders.
Serial.
Last occasion, it has been overruled, my lord, it's honorable court.
But yeah, ತಿರ್ಗಾ ಬಂದಿದೆಯಲ್ಲ.
Office objection,
ಏನ್ CM 13 ಭುವನ್
office objection overruled, my lord. Yes, some urgency in this matter, lord. ಏನಾಗಿದೆ? We are erecting the construction of a restroom, toilet.
ಇದೇನೋ ಓತ್ ಕಮಿಷನರ್ ಸೀಲ್ ಟು ಬಿ ಫಿಲ್ಡ್
ಹೌದು.
ಎಲ್ಲ ಖಾಲಿ ಹಂಗೆ ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂತ ಹೇಳ್ತಿದ್ರು.
Page 101 may be seen, short.
101.
101. But this is the area where I am erecting a restroom. The bottom photograph number 4. This was the earlier restroom. And I am erecting a restroom there. This is not the suit schedule property. This is the property of my mother across the road. Suit schedule property is the property of my father, which is opposite side. Now, my lord, what the defendant did, I am the plaintiff in the suit. Yes. The defendant produced a memo of containing photographs. And he simply produced that photograph and said construction is taking place on the suit schedule property. Which actually is not. And then on that basis, he has obtained a status quo order. This, my lord, your lordships will get at page 83 without an IA. Just a memo is filed with photograph. The court takes cognizance of that and immediately issues an order. 83 of status. Page 83. In this case, learned counsel for defendant number, there was no interim order in this case. Learned counsel for defendant number 1 has produced photographs showing that the plaintiff has taken up construction in front side of the house premises. Said photographs produced show that from 31/10/2024 to 3/11/24, construction work completed substantially by erecting brick wall. And of course, that previous photograph showed the erection of structure. That is not the suit schedule property. Learned counsel for D1 contended that the plaintiff, having obtained order of injunction restraining the defendants from putting up any further construction, has taken up construction in the property which is suit schedule property. Hence, he seeks to direct the plaintiff to stop construction. Learned counsel for plaintiff submits that the construction taken up by the plaintiff is not the suit schedule property. Plaintiff, who is not having toilet facility in his house, has put up construction. Said construction is not related to subject matter of the suit and does not cause harm or loss to the
But in the application, dispose agilvalla.
application ಏನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೆಮೊ ಮೇಲೆ ಆರ್ಡರ್ ಇವರು
Sorry.
ಕೋರ್ಟ್.
ಆಯ್ತು.
Then, Lord, what happened? We insisted that this is not the suit schedule property. This is opposite the suit schedule property, which is apart. The suit schedule property nela. That property belongs to my mother, where the construction is going on. Is status quo itkondo, they are coming and preventing me from erecting the structure outside the suit schedule property.
ಇದೇನು photos produce, ಅದ್ಯಾವ photos, ಎಲ್ಲಿದೆ photos?
Photos ತೋರಿಸಿ explain.
Defendant number 1 has produced photographs. ಅದೆಲ್ಲಿದೆ?
D1 photographs. Yes, yes. Produced before the court. 43.
43 mile.
Annexure E, page 43.
Annexure E na?
E, page 43. ಅಂದ್ರೆ ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಆರ್ಡರ್ ತಗೊಂಡು.
ಅವ್ರು ಇದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದಾರೆ. ಬಟ್ ಆಕ್ಚುಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನಡೀತದೆ.
ಇದು ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್.
ಮತ್ತೆ ಇದನ್ನ ದಿಸ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಸ್ಟಾಪ್ ನೌ.
ಇಲ್ಲ,
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ವ್ಯತ್ಯಾಸ, ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋ ಫೋಟೋಸ್ ವ್ಯತ್ಯಾಸ ಇದೆಯಲ್ಲ.
ಅದೇ ಇದೆ, ಇಲ್ಲಿ ಕ್ಲಾರಿಟಿ ಸಿಗುತ್ತೆ. ಐ ಜಸ್ಟ್ ಲೆಫ್ಟ್ ಸೈಡ್
ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ.
Left side scheduled property. Across small road in the village. Left side is the scheduled property where there is a stay. Left side. Right side is the property where I am erecting structure. Now I undertake that in the scheduled property, I will not erect structure. I will undertake that.
No, but then you have to go for the same court.
But again, ಮಾಡ್ಬಿಟ್ರು ಮೆಮೊ ಮೇಲೆ court passed order. IAನೂ ಇಲ್ಲ.
Correct.
At least an IA was necessary.
The court says after obtaining an order of injunction, within 4 days you have put up some
Yes.
construction.
ಇಲ್ಲ ಇಲ್ಲ.
We are not.
ಆ ಜಾಗದಲ್ಲಿ ಮಾಡಿಲ್ಲ. We have stopped that construction. We are erecting in the other portion. But one ಮಾಡ್ಬೋದು ಇಲ್ಲ. What has happened is I am instructed to say that they have filed a MA against this order. MA is posted to January. But since memo is filed, they have advised the client to, it's the lawyer's mother is the plaintiff. MA, the marriage is the family money. MA, since it was filed on a memo, we have filed this WPCPC. We undertake to withdraw the memo. One issue is that if it is not in the suit schedule property, let them not come and stop this. It's a grievance. We'll undertake not to erect in the suit schedule property. Apart from the suit schedule property, I must not be prevented.
What is the suit for?
Suit is for
Mandatory and declaration and mandatory.
declaration and mandatory injunction against my father's property. Another plaintiff is the father of
Under schedule note, what is the suit schedule?
suit.
And under construction house.
ಹೊಸದುರ್ಗ ತಾಲೂಕು ಕಸ್ಬಾ ಹುಬ್ಳಿ, page 17 is the schedule. ಹಳೆ ಕುಂದೂರು ಗ್ರಾಮದ ಅನಿವಾಳ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ so and so 89. ಹೊಸ ನಂಬರ್ 73/64 ಇದ್ದು ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ ಪೂರ್ವ ಪಶ್ಚಿಮ 17.5, ಉತ್ತರ ದಕ್ಷಿಣ 40 ಅಡಿಗಳು. ಇದಕ್ಕೆ ಚೆಕ್ ಬಂತು.
But ಇದರಲ್ಲಿ what this? No, please wait.
ಇಷ್ಟರಲ್ಲಿ I will undertake, I will not.
What about this counterclaim?
Counterclaim.
Here defendant has mentioned some schedule.
And under
We are not.
dismiss the suit of the plaintiff with exemplary cause.
ಅದೇನು schedule ಕೊಟ್ಟಿದಾರಲ್ಲ.
Schedule on joint, joint, ನಮ್ಮ plaintiff joint schedule. ಇದು concept opposite.
Paragraph number 19 ಓದಿ.
19.
Statement ಅಲ್ಲಿ, page 22.
The submitted description of property given by relative is nowhere exists, and the plaintiff by giving wrong property number and also having a old house in the said property has falsely claimed that there is a vacant site towards eastern side, which is to the western.
ಅದು ಅರ್ಧಂಬರ್ಧ ಕೊಟ್ಟಿದ್ದೀರಾ.
My brother ಅಷ್ಟೇ.
Well, plaintiff is my brother.
ಅಲ್ಲ defendants.
Defendants is my brother, cousin brother.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಈ ತರ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ, ಇಲ್ಲೇನೋ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅರ್ಥನೇ.
ಇದೆ ನಮ್ದು.
ಎಲ್ಲಿದೆ?
So even if you say suit property, according to the defendant, suit property does not exist.
Not assuming it is so, Lord. One issue is that they file a memo and seek stoppage of construction. At least on the IA ಹಾಕಿದ್ರೆ swearing in.
151 ಇರೋದು ಅದಕ್ಕೆ ತಾನೆ, ಬರೀ ಬಾಯಿ ಮಾತಲ್ಲೂ ಕೊಡ್ಬೇಕು ಇಂಜಂಕ್ಷನ್.
ಅಲ್ಲ, ಈಗ our request is, if it is outside the suit schedule property, it may be permitted. I will undertake not to erect the structure within the suit schedule property.
He says the defendant says suit property does not exist and he gives a separate schedule.
Then he should have filed a counterclaim seeking an order, see a declaration or injunction.
My lord, defendant and
ಈಗ ನೀವು
plaintiff-
ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಬಿಡಿ, ಸೂಟ್ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳೋದು ಒಳ್ಳೇದು. That is the case.
plaintiff and defendant entered a division, my lord, 17.5/40 ಅವ್ರಿಗೆ allot ಆಯ್ತು, 17.5/40 ನಮ್ಗೆ allot ಆಯ್ತು. Other
Correct,
neighbors.
Mr. I can't decide the application.
So this is opposite property, my
Lord, can we seek this to you? Let the proper application be filed and let the court decide this. And within a time bound manner, 15 days, ಯಾಕಂದ್ರೆ ಮದುವೆ ಇದೆ ಅಷ್ಟಾದ್ರೆ ಸಾಕು.
Correct, but ಏನ್ ಮಾಡ್ತೀರಿ?
ಏನಾಗಿದೆ, ad hoc prima facie photographs ನೋಡ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. While keeping this order in abeyance, or it could be kept pending, let the court decide.
I
Proper.
direct that, but you will not put up any construction till then. No construction.
ಆಯ್ತು.
schedule.
ಯಾವ್ದು?
Let statement.
ಅದೇ ಮಾಡಿದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಅದೇ ಮಾಡಿರೋದು.
Yes.
Don't put up construction.
Correct.
I can only direct the trial court to consider the applications early.
Pending ಇದೆ application.
ಇಲ್ಲ, ಇಲ್ಲ, 39(1) allowed, my lord. In our favor allowed. I produced.
I am the plaintiff. It is allowed in my favor. He files a memo saying I am erecting structure.
Evidence has been completed. Commissioner was appointed.
At that stage, he has filed this application. Nange, I have a subsisting injunction.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಆಫ್ ಇಂಜಂಕ್ಷನ್?
ಎಲ್ಲಿದೆ? ತೋರಿಸ್ತೀನಿ. Page 31. Annexed.
ಅದಲ್ಲ. ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
ಇದೇ but the order of injunction ಹೆಂಗಿದೆ? Order passed with this court dated 6/11/24 directing the plaintiff to maintain status quo without proceeding with further construction is extended till the dispose of the suit ಅಂತ ಇದೆ.
My lord, injunction obtained in my favor in the
You
2023.
have to challenge it, mister.
ಅಲ್ಲ,
Go on.
my favor ನಲ್ಲಿದೆ.
That is my
Like
favor.
next para ಓದಿ. Page 99.
ಅಲ್ಲ, 41 ನಲ್ಲಿ consequently defendants are, the injunction granted to me is, defendants are hereby restrained by way of ad interim temporary injunction from further construction of their house, thereby causing interference to the plaintiffs in possession and enjoyment of the suit property. Idu, the original injunction that is secured by me.
Now you please go to page 99.
90. We filed a 39 rule 4 on the memo order.
This order has been passed.
Then this order has been passed over. It is not to be known. This court on 6/11/2000 has directed the plaintiff to maintain status quo. Para 15, I'm reading. 98. But the photographs produced by the defendant certainly goes to show that even after passing order, the plaintiff has proceeded with the construction and completed structure substantially. The appeal challenging the said order dated 6/11/2004 is also pending before the honorable appeal. In such being the case, the plaintiff cannot take dual benefit by questioning the same order before this honorable court and also before the honorable appellate court. There is a likelihood of disposal of the suit on merits within a span of less than a month. Under the circumstances, this court is of the view the plaintiff must 6/11/2004 maintain status quo till dispose without proceeding with further construction. On that particular point of the case, this court comes to the conclusion that the instant application filed by the short point that we had made out was they are, I am seeking in the injunction against the suit schedule property, mandatory injunction, demolition of his structure. The court has directed him not to erect structures. But if he wants to seek an injunction against me, he must file a counterclaim and then seek an injunction. But he has treated himself as a plaintiff in the suit. And he has sought a memo seeking status quo over the schedule, his
That's
scheduled
some-
property.
The court cannot allow the status quo of the property to be changed. Now, there's some reference to some PDO being appointed as a commissioner. Para 10, page 95.
Yes,
Panchayat Development Officer and a commissioner appoint ಮಾಡಿದ್ದಾರೆ. He has submitted some report.
yes.
All these things you not produced.
ಅದಕ್ಕೆ ಶೆಡ್ಯೂಲ್ ಇದಕ್ಕಲ್ಲ
ಅಲ್ಲ ಅದು ನಮ್ ಶೆಡ್ಯೂಲ್ಗೆ.
ಇದು
ಅದೇ ನಿಮ್ ಶೆಡ್ಯೂಲ್ ನೋಡಿ.
But
Para
not-
10 ಓದಿ.
Yes. ಅಲ್ಲ, assuming this is so also, how could he maintain a written statement schedule blood and seek an order of status quo or injunction
Okay, but
restraining? He has to file a fresh suit
After getting an
on
order
that
of
cause of
injunction,
action.
after getting an order of injunction, you cannot put up construction and change the nature, status quo of the property.
Andre, it is not the scheduled property, it is across the road. Assuming he has a different schedule blood, he says it does not exist, he has a different schedule. Even assuming if
But
that is
then
so.
please take out notice.
ಹೋಗ್
Please
ಬರ್ಲಿ.
take out notice
ಆಯ್ತು,
over.
ಆಯ್ತು, ಆಯ್ತು. But can I say dusty service also?
Issue emergent notice to the respondents. In addition, the learned counsel for the petition is permitted to serve the learned counsel who represented the respondent before the trial court. ಯಾವತ್ತು ಬೇಕು?
Blood, as soon as dusty service is. done,
ಯಾವತ್ತು
we'll-
ಬೇಕು? ಇಲ್ಲ ನೀವೇ ಮೂವ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, sixth ಗೆ.
List on 6th.
Please.
List number 1 for orders matter, serial number 6, Mahesh YL.
1 week time is granted to do the needful. Are the respondents 2 and 3 necessary parties?
No, my lord.
File a memo then. Please file a memo.
Yes, my lord.
Learned counsel for the petition has filed a memo stating that the respondents 2 and 3 are not necessary parties to this writ petition. Hence, notice to the said response is dispensed.
My lord, responding number 2 to
Huh?
4.
2 and 3.
It is 2 and 3. Notice to R4 is already served.
Serial number 7, G Balakrishna Shastri.
Please file a memo.
For the respondent.
The last occasion, my lord,
Ah,
I have talked to my client. The market value of the site as per the guidelines is 3 lakhs. Bit higher. My client says, my lord, he will prepare to pay, my lord, 8 lakhs towards the site.
No, my lords. My lords, the sale deeds have been not questioned. My lords, his father has executed a sale deed in my favor. My lords, at the time of I putting up a construction, it was at the lintel level of the first state. My lords, suit was dismissed, application was dismissed. Subsequently, my lords, I filed an appeal. My lords, see, they trespasses into my property and carries on to construct the ground and first floor.
so he has
Lords.
completed the construction.
No, he has not completed as on today.
Completed construction,
Lord, not
house
at complete.
inauguration. There I am residing in the house.
My lords, it is not ಇದರಲ್ಲಿ
ಆಯ್ತು, ಎಷ್ಟು ಬೇಕು ಹೇಳಿ. You
ಮಲರ್ಸ್
please-
ಮಲರ್ಸ್ ಮೈ ಪಾರ್ಟೀಸ್ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಮಲರ್ಸ್ ಏನಿಲ್ಲ ಮಲರ್ಸ್ ಲೆಟ್ ದೆಮ್ ಅಲಾಟ್ ಎ ಸಪರೇಟ್ ಸೈಟ್ ದೇ ಓನ್ಸ್ ಅದರ್ ಸೈಟ್ಸ್ ಆಲ್ಸೋ ವೈ ಶುಡ್ ಐ ಪರ್ಚೇಸ್ ಇಸ್
ಬೇರೆ
ಪ್ರಾಪರ್ಟಿ
site ಇದ್ರೆ ಹೇಳ್ತೀನಿ.
Huh?
ಬೇರೆ ಸೈಟ್ ಇದ್ರೆ ಹೇಳ್ತೀನಿ, ಅದು
ಹಾ.
ಬೇಡ.
ಹೇಳ್ಬಿಡಿ.
ಅಲ್ಲಲ್ಲ ಅವ್ರ
You
ತಂದೆ
please point out if he has got any other site, he will replace or substitute this with another site. ಬೇರೆ ಯಾವ ಸೈಟ್ ಇದ್ರೆ ಕೇಳಿ, ಕೊಡ್ತಾರ ಅವರು. He is ready.
ದೇ ಸೇ ದಟ್ ಮಲರ್ಸ್ ದೇ ಆರ್ ಪುಟ್ಟಿಂಗ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇವಾಗ ಅವರು ಟ್ರೆಸ್ಪಾಸ್ಡ್ ಅಂಡ್ ಮಲರ್ಸ್ ದೇ ಆರ್
ಆಯ್ತು, ಇವಾಗ ಆಗೋಗಿದೆ, ಮನೆ ಕಟ್ಟಿ ಅವ್ರು ವಾಸ ಇದಾರೆ, ಗೃಹ ಪ್ರವೇಶ ಮಾಡಿ ಅವ್ರು ಏನು ಅದ ಸೈಟ್ ಇದ್ರೆ ಕೇಳಿ ಕೊಡ್ತಾರ ಅವ್ರು. ಹಾ?
ಅದು ವೆರಿಫೈ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಿದ್ರ ಬಟ್
ಯಾವತ್ತು
ಕನ್ಸ್ಟ್ರಕ್ಷನ್
ಬೇಕು ಹೇಳಿ. When do you want it?
ಮಲರ್ಸ್ ಮಂಡೇ ಮಲರ್ಸ್
Monday. ಏನೋ ಸೈಟ್ ಬೇರೆ ಇದ್ರೆ ನೀವು ಕೊಡಂಗಿದ್ರೆ ಕೊಟ್ಬಿಟ್ಟು
ಇದ್ರೆ
ಬೈ
ಹೇಳ್ತೀನಿ
ಪೀಸ್.
ಅಲ್ಲ ಇದೆ ಮಲರ್ಸ್ ದೇರ್ ಆರ್ ಅಬೌಟ್
I-
16
I
sites
offer-
as per their own
offered the market price.
ಮಲರ್ಸ್ ಐ ಆಮ್
But
ನಾಟ್
that, let him not, my lord, what has happened was. there
ಅಲ್ಲ
was-
ಮಾರ್ಕೆಟ್ ಪ್ರೈಸ್ ಕೊಡ್ಬಿಟ್ಟು ನಿಮ್ಮ ಹತ್ರ ಒಂದು ಸೈಟ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಯಾಕೆ
I
ಮಾರ್ಕೆಟ್
will, I
ಪ್ರೈಸ್?
will, I will,
ಒಂದು ಸೈಟೇ ಕೊಟ್ಬಿಡಿ
I
ಅಷ್ಟೇ.
will,
So that you can salvage the house that you have constructed.
please.
Learn counsel
One
for
more
the.
thing, Mallards, the house was initially, Mallards, constructed, foundation was laid by me. Mallards, first floor or go, Mallards, ground floor was completed initially.
ಯಾವ ಫೇಸಿಂಗ್ ಇದು?
Mallards, this is facing, north facing.
ಯಾವ್ದು ನಾರ್ತ್ ಫೇಸಿಂಗ್ ಸೈಟೇ ಕೊಟ್ಬಿಡಿ
Well,
ಅವ್ರಿಗೆ.
ಇದ್ರೆ ಹೇಳು.
ಅಲ್ಲ ಇದ್ರೆ ಅಲ್ಲ 1987 is my Mallards, the
ಆಯ್ತಪ್ಪ, ನಾರ್ತ್
2003.
ಫೇಸಿಂಗ್ ಸೈಟೇ ಕೊಡ್ತಾರ
Only.
ಅದೇ ಲೊಕ್ಯಾಲಿಟಿ ಇನ್ನೇನು The learned counsel for the petition respondent seeks time to explore a settlement. List on
Monday,
Monday.
my lord.
Monday agutta.
Next week, my lord.
My lord,
How
Tuesday,
ಬೇಕು ತಗೊಳ್ಳಿ.
Tuesday ಹಾಕೊಳ್ಳಿ, my lord, so
Right, Tuesday,
I'll intimate.
Tuesday.
Interim undertaking to continue.
Interim interim undertaken, the undertaking given by the respondent,
Not to precipitate.
Not a precipitator.
which is recorded by this court is continued till the next date of hearing.
Much obliged.
Mr. M.S. Varadarajan,
Serial number 8.
list after service of notice to respondents 1 and 2.
Serve the copies, but there's no instructions for the parties, my lords. A week times may be granted.
What about 1 and 2? Are they necessary parties?
Please, my lords, we are the applicants.
One response 1 and 2.
Please, my lords, defendant 1, we have filed the application.
What is your name?
My lords, Divya,
You represent response 1 and 2.
please, my
Are
lord.
you sure?
Yes, ma'am. Please, my lord.
Ratnam and Rajkumar,
Please, my lords, defendant 1 and 3.
1 and 2 or 1 and 3?
Defendant 1 and
3.
3.
What about
Respondent 1, 2.
Rajkumar?
He's respondent 2, my lords. Defendant 3,
Madam, whom
respondent.
do you represent?
My lords, here, respondent 1 and 2, my lords.
What is your name?
Divya, my lords, but
Miss Divya undertakes to appear for response 1 and 2.
to take instructions on the claim.
Respondents 1 and 2 here are respondents, defendants 1 and 3, the original.
Right.
You will undertake to appear for,
So, my lords, I have to take instructions on the claim. We have tried calling them, they've not given it, they've not.
have you given the NOC before the trial court?
No, my lords, we
Then-
appear there. I'll take instructions. and-
No, no question of taking instructions. We will mention your name in the cause list. Miss Divya undertakes to appear for the response 1 and 2. Office is directed to show her name in the cause list. List on, when do you want it?
Next week, my lords.
On date good. Mr. Narasimhan,
Interim order to be extended.
interim order is extended till the next.
December serial number 9, Kevin.
Though the service is awaited, there is a connected petition, my lord.
There you
among
are they necessary parties?
the necessary parties and they are represented in WP 21233, which
List-
my lord is among the
List
very
this
same parties.
petition, list this petition along with WP number
21233 of 23.
23.
Please.
Yes.
My lord, may request on Monday, my lord. We are trying to.
ಯಾವತ್ತಾದ್ರೂ
alienate-
ತಗೊಳ್ಳಿ.
2 weeks.
Monday.
Serial number 10.
Monday, ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟು?
My suit is of the year 2008. My lord,
List on,
all suits are stayed now.
list on Tuesday. Yes.
Please, wait.
Manmohan.
Serial number 9. 10, serial number 10, Manmohan PN.
Lord,
Hmm.
the same matter wherein Lord, the last occasion Lord said, permitted Lord the respondent Lord to give a new entrance. I think Lord, I made a mistake of not making a specific request. But for them to point out what is a measurement, etc. Not know what has been done is, can I just request Lord, so please turn to the application Lord. ಈಗ ಒಂದು ಟಾಯ್ಲೆಟ್ ಡೋರ್ ತರ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನನಗೆ I can't take anything inside.
ಎಲ್ಲಿ ಫೋಟೋಗ್ರಾಫ್ ಇದೆಯಾ?
Yes, Lord. Can I request Lord, so please turn to my application Lord, IN number 3 of for direction.
Court is virtually running your business.
But if she had complied with the order, there's no problem at all.
Page number
Page
13.
12, if not, please turn to.
Ah,
But this is a door that is affixed now.
My lord.
I'm not, kindly just permit me to just show me Lord, the next page 13. Lord, my lord said only permitted them not to give a new entrance, not block the existing Lord entrance. Now what they have done is page 13, she affixes a new door there and closes the entry.
yes.
My lords, I'll furnish there is a passage on the main door of the respondent house. Through that passage, he has to get into his tenement and
Now,
again. there
whatever
is a-
whatever it is. This court passed an order on
Yes,
14
my lords,
11.
kindly these photographs may
Please,
be looked
please,
into. my
please
lords.
look at the photograph at page 12.
My lords,
Can
the
any human
passage-
being
my lords,
can
the
any
passage
human
itself,
being
it's,
carry a sack of any commodity?
my lords, kindly these photographs may be looked into, my
Good.
lords.
Lord, may I also see page 15, Lord, for a moment. Item copies.
I'll give you. Yes.
Yes, please.
The passage which your lordships would see in the second photograph, that is a passage which has gotten access to his place, my lords, his business place. So that passage is facing the road and we have installed a gate in that passage. Earlier, he would take the passage through my house and get into his the passage
Madam,
that
give
has
a
gotten
better
access.
entrance is all I am saying. Keep it at least
It's
about
2
5 feet
2
wide.
meters, my lords. The passage itself is 2 meters, my lord.
Madam, at least 5 feet. 2 meters is 6.6 feet. At least keep the door at least 5 feet wide or 4 feet.
It's already, it's
But
about.
I
she
will do
states
it myself.
I can say it is only about 2.5 feet.
How much this?
The door is only about 2.5 feet.
I would kindly, it may be taken up on Monday or Tuesday. I would ask her to get a sketch done about the.
Don't
alteration.
worry. If you want, I'll appoint a commissioner at your cost to go and see what is the width of the door of this door.
No, we would, ourselves will file it. my
I would
lords.
see.
It is 57 centimeters by 197.
What is the width of this passage?
Passage is about 2 feet, 2 point,
Huh?
2.2 feet.
Passage ಎಷ್ಟಿದೆ
Not
ಅಷ್ಟೇ
illa,
First
but
take
what,
it
what
to
is, can I just request not please see the sketch? A sketch in the application
i-
file not I have for permission ಅಲ್ಲಿ ಒಂದು sketch ಹಾಕಿದ್ದೀನಿ.
Uh,
So show them Lord, there are 2 doors Lord. I'll just explain Lord how it is. The passage
Sir.
Lord, the width of the passage is different. Lord, kindly see Lord the sketch at page 12. Page 12 Lord have it of my application IA number 4. Lord, can I request Lord to turn to the bottom of the left hand side. Lord would see a passage Lord. A passage Lord in the our door ಬರುತ್ತೆ. That door is little wider. ಅದರ ಎದುರುಗಡೆ there is another door. That is how I used to take all my materials Lord. This passage Lord is another passage to the other door which I have.
Where is the alternate passage that she can provide? Please point out.
Lord,
ಇದು ಬಿಟ್ಟು ಬೇರೆ ಏನು? Okay, this passage, she has closed it.
she has closed it now.
Now, which is the other passage that she can provide?
Lord, she can give me a bigger door entrance not here itself. But that's why Lord, I have prepared a sketch. I will do it myself at my cost. Please turn to page 14 for a moment. Lord, this is the door that she has fixed on the left hand side, the toilet door. On the right hand side, Lord, is the door which I propose to fix. But I'll fix the door at my cost.
Yes.
Therefore, Lord, the problem, Lord, will be sorted out.
Yes.
My lords, the passage itself is about 2.2
But anyway,
feet.
he says that he'll fix a door on his own.
Yes.
But again, that he'll encroach upon the passage which I've been using, utilizing
No
it.
question of using the passage that he was earlier provided with.
Yes, my lords.
ಈ ತರ page 14 ಅಂತಿದೆ ನೋಡಿ ಇದು. ಈ ತರ.
Yes, that he says it is 2 meters. Yes,
Let
my
him do
lords.
whatever he wants. ನೀವು 2 ಅಡಿ ಕೊಟ್ರೆ 2 ಅಡಿ ಬಿಸ್ನೆಸ್ ಹೆಂಗ್ ಮಾಡೋದು 2 ಅಡಿ
2 ಅಡಿ passage 2 ಅಡಿ ಇದೆ
ಆಯ್ತು,
ಸ್ವಾಮಿ.
2
ದಿನ ಅದ್ರಿಂದಾನೇ
ಆ
ಅವ್ರು
passage
material ಎಲ್ಲ
close
ತಗೋತಾರೆ.
ಮಾಡ್ತಾನೆ. That passage he will close.
Yes,
He will open one more door next to that door that you have installed now.
but without interfering, obstructing the passage
Obviously.
which I've been using, my lords.
Obvious.
Yes, my lords.
Lord, the old passage, Lord, she has already closed it. Lord, I'm only saying, Lord, this door, I will open. And this door, Lord, which she has now put.
You know, both the premises should be separate.
I got what Lord says.
Can't do, disturb or cause any
I got
nuisance
what
to
Lord
her,
says.
and she cannot enter your business premises. ಆ ಥರ ಏನಿದ್ರೆ ಹೇಳಿ.
Lord, can I request, Lord, have it at 2:30, Lord? I'll seek instructions and Lord, get back to the court.
Current
Yes.
counsel for the 2:30, yes.
Grateful.
Sublation.
Serial number 11, Devraj AS.
Ila, you please, why don't you get out of this premises, mister? Why you want to fish in troubled waters?
Building,
It looks like a small place.
Lord,
Looks like a small place. Why don't you get out?
Lord, the building is constructed not by my client. That is not the issue.
That you work it out in some
And
other
Lord,
way.
that Lord, we are taking steps. Lord, therefore, Lord,
ತಿರ್ಗಾ ನಿಮ್ ಪ್ರಾಬ್ಲಮ್ ಇದ್ದೇ ಇದೆ. Don't
I
enter the
understand,
impression
Lord.
that you
I
can.
have informed this to the client.
Please get out of the premises. Allow her to use the premises.
Please.
You have had a field day. She says that you did A, B, C, D, and he has made all kinds of wild allegations against
He has
you.
made not everything.
ಮತ್ತೆ? Quid pro quo. You got something, she got something.
I didn't get anything. I only got not blasting sets.
Arre, you knew what you got. Only your client knows what he got.
Earlier, there was no problem, Lord, because she was also working, Lord, in my company.
Sure it is, Mr.
But anyway, but I'll come back at 2:30 and see this.
There's some kind of a ego clash ಇನ್ನೇನಿಲ್ಲ.
ಹೌದು.
Serial number 11, Devaraj AS.
Happy for the respondent.
It's regarding the lease agreement.
Week time is granted to do the needful. ಯಾರಿದು?
Only one respondent is in.
ನೀವಾ? You appear for the respondent.
Yes.
Since the learned counsel, since the respondent is now
Already shown.
represented, the petitioner is exempted from paying the process. Yes. Suit is filed in which year?
18.
ಏನಿದು?
Yes.
Suit
I had
filed
filed a
by-
suit for ejectment, bro.
Hmm.
Where he had filed an application to refer the complaint regarding where my wife has entered into a lease agreement with him. Where the property belongs to the respondent, husband.
What is this 340?
340, he had filed an application, refer the complaint already to the registrar of the city civil court.
Pay.
Page number 21.
What false evidence?
Where already a criminal case is filed and it is pending adjudication before the magistrate court.
It is.
What is this for 340 business?
Proceedings where the complaint based on the
What is the perjury that this lady has committed?
owner is husband, wife is entered into a lease agreement.
Ah,
On that basis, he had given the evidence before the court. For that, he is asking for to take this action against criminal action. Where the complaint is filed and matter is pending before charge sheet has been.
complaint is filed against the wife.
Yes, no, not by he himself had been filed the complaint.
Huh?
Complaint is filed by the petitioner itself has filed the complaint.
Private complaint.
Private.
ಏನಾಯ್ತದು?
It's pending adjudication, charge sheet has been
Different
filed.
matter. We are entering into the lease agreement by paying the 5,50,000 to the respondent and his wife. ಇದ್ರ ಸಂಬಂಧಪಟ್ಟಂಗೆ we got the FSL report, the expert given report in our favor. They confirm the signature of the lease agreement, it is of the respondent and his wife. With regarding that, CC is filed criminal cases pending. ಅದು police station complaint ಕೊಟ್ಟಿದ್ವಿ, based on the FIR, it is registered. ಇವಾಗ ಬಂದಿರ್ತಕ್ಕಂಥ ಮ್ಯಾಟ್ರು ಸ್ವಾಮಿ, I called the wife of the respondent as a witness, ನನ್ನ lease agreement prove ಮಾಡ್ಲಿಕ್ಕೆ. ಅಲ್ಲಿ ಬಂದಾಗ
Lease agreement in the-
signatures.
Where is your lease agreement?
It is page number 40. ಇದರಲ್ಲಿ ಹಸ್ಬೆಂಡ್ ಬಂದ್ಬಿಟ್ಟು ಮಾಲೀಕರು ಇರ್ತಾರೆ ಸ್ವಾಮಿ. ಈ ಕೇಸ್ ಹಾಕ್ದಾಗ ನಮ್ಗೆ ಈ ಕೇಸ್ ಹಾಕೊಂಡ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತು, ಹಸ್ಬೆಂಡ್ ಬಂದ್ಬಿಟ್ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಂದ್ಬಿಟ್ಟು ಓನರ್ ಆಫ್ ದಿ ಬಿಲ್ಡಿಂಗ್, ಆದ್ರೆ ವೈಫ್ ಬಂದ್ಬಿಟ್ಟು ಓನರ್ ಅಂತ ಸೈನ್ ಮಾಡ್ತಾರೆ, ಬಿಲ್ಡಿಂಗ್ ಓನರ್ ಬಂದ್ಬಿಟ್ಟು ವಿಟ್ನೆಸ್ ಜಾಗದಲ್ಲಿ ಸೈನ್ ಮಾಡ್ತಾರೆ. ಈ ತರ ಫ್ರಾಡ್ ಆಗಿರೋದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ದೇರ್ ಇಸ್ ಎ ಸಪರೇಟ್ CC ಕೇಸ್ ಇಸ್ ಪೆಂಡಿಂಗ್. ಇವಾಗ ನಂದು ಗ್ರೀವೆನ್ಸ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಮೈ ಲಾರ್ಡ್, ಆಸ್ ಎ ವಿಟ್ನೆಸ್ ಬೈ ದಿ ಓನರ್ ಸಿಗ್ನೇಚರ್ ಹಾಕಿದಾರಲ್ಲ ವೈಫ್, ಅವ್ರನ್ನ ಕಾಲ್ ಮಾಡಿದೆ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಅಲ್ಲಿ ಕೇಳಿದಾಗ ಅದು ಡಿನಿಯಲ್ ಮಾಡ್ತಾರೆ. FSL ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ. ಜೊತೆಗೆ ಈ 2015 ಅಲ್ಲಿ ಅವರು ಒಂದು ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ. ಆ ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧಪಟ್ಟಂಗೆ ನಾನು ಸಜೆಸ್ಟ್ ಮಾಡ್ತೀನಿ, ನೀವು ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ 2015 ಅಲ್ಲಿ ಅಂತ.
So what do you think this proceeding is? It's a eviction case. And ಏನಕ್ಕೆ convert ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದೀರಾ ನೀವು?
ಅಲ್ಲ, ಅವರು ನನ್ನ ಯಾವ್ದು ಪ್ರಾಪರ್ಟಿ
Tenant. You are a tail. You can't wag the doll. You're only a tail. ನೀವು ಬಾಲ ಮಾತ್ರ ನೀವು. You're only a tail, mister.
ನೋ ಮೈ ಲಾರ್ಡ್.
Then
ಅವರು ಇವನ್
you're the owner of this premises. Are you the owner?
ನೋ ಮೈ.
Then
ನನ್ನ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಓನರ್ ಅಂತ ಸೈನ್ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತಪ್ಪ, you are a tenant. That's it.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ಸರ್, ನಂದೇನೆಲ್ಲ ನಂದು 5,50,000 ರಿಟರ್ನ್ ಮಾಡಿದ್ರೆ ನಾನು ಪ್ರಿಮಿಸಸ್ ಖಾಲಿ ಮಾಡ್ತೀನಿ.
I got to get the instructions.
Hmm?
I had to get the instructions on
ಯಾವಾಗ?
Wednesday.
ಏನ್ ಈ ತರ ಎಲ್ಲ ಲಾಯರ್ ಆಗಿ ಈ ತರ ಎಲ್ಲ ದಯವಿಟ್ಟು ಅಡ್ವೈಸ್ ಕೊಡ್ಬೇಡಿ.
ಅಲ್ಲ ಸರ್,
Being a lawyer,
14 ಅಲ್ಲಿ scheduled property purchase
no,
ಮಾಡಿದ್ದಾರೆ.
sorry.
15 ಅಲ್ಲಿ ಒಂದು ಮಾಡಿದ್ದಾರೆ.
ಲಾಯರ್ಗಳು ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು ಅಂತ ಅಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಈವನ್
No, no,
ವಿಟ್ನೆಸ್
no,
ಬಾಕ್ಸ್
I'm
ಅಲ್ಲಿ
sorry.
The application is
I'm
filed
suggest
after, he had filed 32 applications, madam. One or the other matter, the matter is dragged on in the proceedings.
I'm going to take serious action against you, mister.
ಅಲ್ಲ ಸ್ವಾಮಿ,
Lawyer doesn't get a license to do anything.
ಅಲ್ಲ ಅವರು ಮೋಸ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಯಾಕಂದ್ರೆ 2015 ಅಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ
Where's the question of 340 in this case is what I am asking you. Where's the question of 340? ಅದು
Giving
PCR
false
ಬೇರೆ
evidence before
ಹಾಕಿದ್ರೆ
the court.
ನೀವು ಬಾಡಿಗೆ ಕೊಟ್ಟಿರೋ ತಪ್ಪಿಗೆ ಅವ್ರು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬೇರೆ ನಡೆಸ್ಬೇಕು. ಏನ್ ಕರ್ಮ?
ನಾನು ಅವ್ರದ್ದು their contention is ನಾನು
What kind
oral
of
agreement
advice you are
ಮೇಲೆ
giving,
we are indebted the tenants ಅಂತ ಹೇಳ್ತಾರೆ.
Mister, what kind of advice you are giving? You know what will be the consequence on the society?
ಅಲ್ಲ ಸ್ವಾಮಿ
ಅಲ್ಲ
ಅವ್ರು
ಸೊಸೈಟಿ ಮೇಲೆ ಏನ್ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಆಗುತ್ತೆ? ಲಾಯರ್ಗಳದ್ದು ಇಂಪ್ರೆಷನ್ ಏನು? ಲಾಯರ್ ಇಮೇಜ್ ಏನು ಅಂತ ಯೋಚನೆ ಮಾಡಿದ್ರೇನ್ರಿ?
ಅಲ್ಲ ಸ್ವಾಮಿ ಮೈ ಸಬ್ಮಿಷನ್ ಮೇಲೆ ಅವ್ರದ್ದು ಸೂಟ್ ಬಂದ್ಬಿಟ್ಟು ಈ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
ಸರ್ ಅದಕ್ಕೆ ಹೇಳ್ದೆ at the end of it you are a tenant.
ಹೌದು ಸ್ವಾಮಿ
You're only a tenant. You don't try to prosecute the owner for the mistake of renting out the premises to you. ನೀವು ಈ ತರ ಅಡ್ವೈಸ್ ಕೊಟ್ರೆ ಲಾಯರ್ಗಳ ಬಗ್ಗೆ ಜನ ಏನ್ ಅನ್ಕೋತಾರೆ? ಒಬ್ಬ ಅಡ್ವೊಕೇಟ್ ಬಗ್ಗೆ ವಾಟ್ ವಿಲ್ ದ ಪೀಪಲ್ ಥಿಂಕ್?
ಡಿಪಾಸಿಷನ್ ಇದೆ ಸ್ವಾಮಿ ನೀವು ಹೇಳ್ತೀರಿ
ಅದಕ್ಕೆ ಎಲ್ಲೋ ಗೌರವ ಸಿಗಲ್ಲ ವಕೀಲರಿಗೆ.
ಲೀಸ್ ಅಲ್ಲಿ ಅಮೌಂಟ್ ಕೊಟ್ಟು ಬಂದ್ರು ಕೂಡ ಓರಲ್ ಅಗ್ರಿಮೆಂಟ್
No, no, no.
ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಹಣದ ಅವಶ್ಯಕತೆ
Better
ಇತ್ತು.
withdraw all these things. Otherwise, I am going to take stern action against you. ನೀವಂತೂ ವಕೀಲರ ಪ್ರೊಫೆಷನ್ ಬಗ್ಗೆ ಗೌರವ ಕೊಡದೆ ಅಟ್ಲೀಸ್ಟ್ ಕೋರ್ಟ್ ಆದ್ರೂ ಗೌರವ ಕೊಡ್ಬೇಕಲ್ಲ.
ಹೌದಾ ಸ್ವಾಮಿ? ಇಲ್ಲಿ
Please withdraw all these things. First you withdraw it, otherwise I am going to take stern action against you.
ಕೈಂಡ್ಲಿ ಔಟ್ ಆನ್ ಮಂಡೇ.
Withdraw ಮಾಡಿ ಬರ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ you will end up in bar council, I am telling you.
ಮೈ ಲಾರ್ಡ್ ಒನ್ ಸಬ್ಮಿಷನ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ 2015 ಅಂತ ಕಾನ್ಫಿಡೆಂಟ್ ಮಾಡ್ತೀನಿ.
That's okay, mister. That's all okay. Fight the case. ರಾಯಲ್ ಆಗಿ ಫೈಟ್ ಮಾಡಿ, ಬೇಡ ಅಂತ ಹೇಳೋದಿಲ್ಲ. ವಾಮ ಮಾರ್ಗ ಉಪಯೋಗಿಸ್ಬೇಡಿ. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕೋದು.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅವರು ನನ್ ಮೇಲೆ ಹಾಕಿರೋದು ಸ್ವಾಮಿ. ಅವರು ನನ್ ಮೇಲೆ 2 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. ನೀರು ಟ್ಯಾಪ್
ಅವ್ರು 2 ಹಾಕಿದ್ರು.
ಹೌದು ಸ್ವಾಮಿ.
ಅದೇನೆ
ಅದು ಡಿಫ್ರೆಂಟ್
ಬೇಕಾ ಇದು?
ಅಲ್ಲ ನನ್ಗೆ ಲೀಸ್ ಅಮೌಂಟ್ ಕೊಟ್ರೆ ನಾನು ಹೋಗ್ತೀನಿ ಸ್ವಾಮಿ. FSL ರಿಪೋರ್ಟ್ ಬಂದ್ರು ಕೂಡ ಅವರು ನನ್ನ ಅಮೌಂಟ್ ಕೊಡದೇ
ಅಡ್ವೊಕೇಟ್ ಆಗಿ ದಯವಿಟ್ಟು ಈ ತರ ಆಟಿಟ್ಯೂಡ್ ಇಟ್ಕೊಂಡ್ರೆ ಇಟ್ ನಾಟ್ ಟೇಕ್ ಯು ಟೂ ಫಾರ್.
ಆಗಲ್ಲ ಸ್ವಾಮಿ. ವೈಫ್ ಬಂದ್ಬಿಟ್ಟು ಹೌಸ್ ವೈಫ್ ಅಂತ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಂದ್ಬಿಟ್ಟು ಸ್ಕೂಲ್ ಟೀಚರ್ BA ಓದಿ ಸ್ಕೂಲ್ ಟೀಚರ್ ಅಂತ ಹೇಳ್ತಾರೆ. 2014 ಅಲ್ಲಿ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ, 15 ಅಲ್ಲಿ ವೈಫ್ ಒಂದು ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ. ಇಷ್ಟೊಂದು ಅಮೌಂಟ್ ಅವ್ರು ಒದಗಿಸಕ್ಕಾಗಲ್ಲ. ನಾನ್ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಲೀಸ್ ಅಮೌಂಟ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಅವ್ರು ಕೊಡಕ್ ಆಗದೆ ಇದ್ರಿಂದ ನೀವು ಓರಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮೇಲೆ ಬಂದ್ರಿ, ಲೀಸ್ ಮೇಲೆ ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಇದನ್ನ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ನಿಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
ವಾಟ್ ಆಲ್ said and done, why do you advise this kind of ಇದು ಓನರ್ ಮೇಲೆ ಒಂದು PCR ಹಾಕು, ಓನರ್ ಮೇಲೆ ಕೇಸ್.
PCR ಹಾಕಿರೋದಲ್ಲ ಸ್ವಾಮಿ, FIR ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಗಲಾಟೆ ಆದಾಗ ಹೋಗಿ ಕೊಟ್ಟಾಗ ಅವರು ಲೀಸ್ ಸಂಬಂಧ
ಯಾಕೆ ಇದೆಲ್ಲ ಅಡ್ವೈಸ್ ಮಾಡ್ತೀರ ವಕೀಲರು?
ಅಲ್ಲ ನಮ್ಗಿಂತ ಮುಂಚೆ ಅವ್ರದ್ದು CC ಕೇಸ್ಗಳಿರೋದು 2 ಕೇಸ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ. ಆಮೇಲೆ ನಮ್ಮವರು
ದಯವಿಟ್ಟು ಸಾರ್ಟ್ ಔಟ್ ಮಾಡಿ, ಯಾವತ್ ಬೇಕು ಹೇಳಿ, ಸಾರ್ಟ್ ಔಟ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದು ಹೇಳ್ಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ಟೇಕ್ ಸೀರಿಯಸ್ ಆಗಿ ಆಲ್ ದ ಲಾಯರ್ಸ್.
ನಮ್ಗೇನು ಲೀಸ್ ಅಮೌಂಟ್ ಏನಿದೆ ಅದು ಕೊಟ್ರೆ ನಾನು ಖಾಲಿ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
I'll get to.
ಆಮೇಲೆ ಈ ತರ ಈ ಕಾಂಟ್ಯಾಕ್ಟ್ ಬಿಡಿ. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಸಿಗಾಕೊಂಡ್ರೆ ನಿಮ್ಗೆ ಸರಿಯಾಗಿ ಬರೇ ಬೀಳುತ್ತೆ.
ಅಲ್ಲ ನಮ್ಮ
ವಕೀಲರು ಏನ್ ಬೇಕಾದ್ರು ಮಾಡಿ ಯು ಕ್ಯಾನ್ ಗೆಟ್ ಅವೇ ಅನ್ನೋದು ಅದು ರಾಂಗ್ ಇಂಪ್ರೆಷನ್. ಇಫ್ ಯು ಆರ್ ಅಂಡರ್ ದ ಇಂಪ್ರೆಷನ್ ನಾನು ಏನ್ ಮಾಡಿದ್ದೆಲ್ಲ ಸರಿ ಅಂತ ನೀವು ಇಟ್ಕೊಂಡಿದ್ರೆ ಪ್ಲೀಸ್ ಶೆಡ್ ದಟ್ ಇದು ಇಂಪ್ರೆಷನ್. ಅದು ಬಿಟ್ಬಿಡಿ, ಅದು ಕಳ್ಚಿಬಿಡಿ ಅದನ್ನ.
ಅಲ್ಲ ನನ್ನ ಕೇಸ್ ಪ್ರೂಫ್ ಡಿಫೆನ್ಸೇ ಆ ತರ ಇದೆ.
ಅಲ್ಲ ಮುಂದೆ ಆದ್ರೂ ಈ ತರ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳ್ತಿರೋದು. ಕೇಸ್ ಏನಿದೆ ಕೇಸ್ ರೈಟ್ ರಾಯಲ್ ಆಗಿ ನಡೆಸಿ, ವಾಮ ಮಾರ್ಗನ ಉಪಯೋಗಿಸ್ಬೇಡಿ ಕೋರ್ಟಲ್ಲಿ.
ಅವರು ಫಾಲ್ಸ್ ಎವಿಡೆನ್ಸ್ ಇದೆ ಸರ್.
ಯಾವತ್ತು ಮಂಡೇನಾ ಟ್ಯೂಸ್ಡೇನಾ? ಟ್ಯೂಸ್ಡೇ.
Serial number 12, Manu Prabhakar.
ಇಲ್ಲ ಭಾನುವಾರ ಹೋಗ್ಬೇಕಾಗ್ತದೆ ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ ಎವಿಡೆನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ
ಒಟ್ಟು 2 ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ ವಿತೌಟ್
ಊಟನೂ ಸಿಗಲ್ಲ ಅಲ್ಲಿ.
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ, 2 ಪ್ರಾಪರ್ಟಿ ಮಾಡ್ತಾರೆ. ನನ್ಗೆ ಲೀಸ್ ಅಮೌಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಭಾನುವಾರ ನೀವು ಹೋಗ್ಬೇಕಾಗ್ತದಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ದು.
ಕ್ಲೈಂಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅದನ್ನೇ ಫಾಲೋ ಮಾಡಿ.
ಕ್ಯಾಂಟೀನ್ ಓಪನ್ ಆಗಿರಲ್ಲ ಅಲ್ಲಿ.
ಪಾಪ 5,50,000
ಬುತ್ತಿ ಕಟ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ನೀವು.
5,50,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Yes, please.
Serial number 12.
For the petitioner, my lord.
What is your name? Devraj, ನೀವೇನಾ? Yes, Manu Kulkarni.
Appearing for the petitioner, my lord.
This after service of notice to respondent number 3.
To respond to one.
Notice issued to the respondent number 1 and 2 is not claimed. The address of the said respondents corresponds with the address mentioned in the cause title of the trial court. Hence,
Yes.
notice to the said respondents is held sufficient. Office is directed to show their names in the cause list and also indicate that notice to them is held sufficient. Yes, list on
Interim order may be extended, your lordship.
interim order is extended till the next date of hearing.
Much obliged.
Number 13, Rajeshwar PN.
1 week.
We were filing memo for dispensation in respect
Memo.
of respondent 2 to 4, my lord. They
A
are not
memo
the
is filed by the learned counsel for the petitioner seeking dispensation notice to response 2 to 4. In view of the memo, notice to the said response is dispensed.
For
1
R1,
week
we
time-
have,
1 week time is granted to pay proceed and deposit
is-
other
it
requisites.
is paid, my lord.
The learned counsel for the petitioner submits that he has paid the process to issue notice to R1. Office is granted to check, verify and proceed to issue notice. Yes. Interim order idya?
No, my lord. There's no interim prayer.
Yes.
Serial number 14.
Lords, for the petitioners in this case, minutes.
Yes.
Lords, this is a matter arising out of commercial suit. Lords, wherein there was an
Take notice.
application.
I appear for the respondent.
All the respondents.
All the
What's your name?
Nishan GK.
Nishan?
GK man.
Mr. Nishant
Nishan man.
Nishan GK undertakes to appear for the response 1 to 3. Yes.
Lords, this is a matter where an application was made by the plaintiff petitioner before your lordships, seeking permission to produce the original of the office copies of the invoices and the affidavit under section 65B of the Evidence Act as his exhibits. My lords, the reason for not having submitted these documents, apart from 65B, only the office copy of the invoices, was that the invoices were not in the custody of the plaintiff at the time of filing of the suit, for the reason that it was in the custody of the statutory auditor who was performing the audit of the company at the time of that particular. Now, that being the case, my lords,
Have you mentioned that in the application?
my lords, in the application, I have mentioned it, my lords. My lords, may please come to annexure. Lords, may please take up.
Annexure E, page 65.
Annexure, please. ಇದರದ್ರಲ್ಲಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
Lords, page 65 is IA number 4, my lords. ಇದರದಲ್ಲ, ನಂದು ಇನ್ನೊಂದು, this is IA number 6. My lords will get it at annexure G, page number 72, my lords. ಅಲ್ಲಿ this thing I have stated at page 74, paragraph number 3, my lords, of my affidavit. Page 74, paragraph number 3. I state that the delay in filing the office copies of the invoices is unintentional, since I was unaware of the fact that the same were in the custody of my statutory auditor, who had collected the same at the time of finalization of books of accounts and audit for that financial year. I further state that the summary statement of invoices and the details of emails sent to the defendant company and the emails were all part and parcel of the plaint.
My lords, there are two stands taken, my lords. IA number 4 and IA number 6 are the applications under challenge, my lords. The same invoices were requested to be allowed in IA number 4, my lords, where the contention was, my lords, if I can take you to page number 67, my lords. The second paragraph, my lords, in 67. I state that while filing the above suit, I had filed the photocopies of the documents and filed a memo seeking permission to file the originals at the time of evidence. In IA number 6, my lords, he takes a contention saying that it is with my CA. Apart from this, my lords, order 11 rule 1(3), my lords, is not complied, where in the statement of truth, he had to disclose whether it was in his possession or not. That has not been done. The same application which was mentioned in IA number 4 was rejected.
Barcode.
And the same prayer is made in IA number 6, my lords.
The plaintiff in commercial OS 570 of 2021 is on pending trial before the 86th Additional City Civil and Sessions Judge Bengaluru has filed this petition challenging the correctness of an order dated 7/8/2024, by which IA number 6 filed by him.
Please.
And order 11 rule 1(5) of CPC was rejected. Next para. The suit in OS number 570 of 2021 was filed for recovery of
The rental amounts for having supplied the computers and systems, my lords.
Recovery of rupees 85 lakhs 80,290 arising out of what are this towards?
My lords, these are computers and systems, my lords.
Arising out of a contract relating to supply,
Please, illa supply alla rental,
No,
leasing of
relating to-
the systems. my lords.
relating to leasing of computers and other ancillary instruments.
Please.
Full stop. The suit was contested by the defendant who denied the claim. Full stop. When the suit was set down for evidence, the plaintiff filed an application under order 11 rule 1.
My lords, IA number 4 was 11 rule 1-3, my lords. 1-4, my lord.
1-3 alla 1-4.
Order 11 rule 1
One,
filed an application bracket IA number 4. Where are the invoices in this?
My lords, invoices, so original when I had filed the statement of invoices, my lords. That is what I have mentioned.
In IA number 4, what is?
IA number 4 nalli, IA number 4, my lords, I have
number 6 ಏನಪ್ಪ? What is?
please,
serial number
ಅದು ಇದ್ರದ್ದು office copy of the invoices ಅಂತ ಇದ್ ಮಾಡಿದ್ದೀನಿ.
Hmm.
Original of the office copy of the invoices. That is what I am stating. Adana, that I have clarified in my affidavit which I have
No,
filed
I'm
along
asking-
with.
What I am asking you is,
Please,
in IA
please.
number 4, you attempted to produce the same document.
Yes. I am not denying that at all. my lords.
This, you did not challenge this order.
no, my lords.
Illa, Swami.
Uh,
I have it.
ಆಯ್ತು.
My
Order
lords,
1,
ಅಲ್ಲಿ
rule 4
the
of
reason,
CPC.
please.
Order 11 rule 4 of CPC to produce certain documents. Full stop. The said application was rejected in terms of the order dated.
Lords, order dated. My lords will find that time.
My lords, 15 September 2022, my lords.
15 September
Please.
2022.
2022 at Annexure B, my lords.
Full stop. Long thereafter, the plaintiff filed another application under order 1 rule 11.5, order 11 rule 1.5
Please.
to produce the very same document. To produce one of the documents
One of the
which the plaintiff intended to in IA number 4. The reason for the delayed production of the document was that it was lodged with the statutory auditor of the plaintiff who had collected it at the time of finalization of books of accounts and audit for the financial year. So the trial court, after noticing that the plaintiff had taken two different stands for non-production of these documents in IA number 4 and IA number 6, rejected the application in terms of the impugned order.
That's a rejection, different stands anta ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ, res judicata ಅಂತ ಇದ್ ಮಾಡಿದ್ದಾರೆ.
That is in IA number 6, my lords.
It also
Please,
held
please.
that- It also held that the court, it also held that IA number 6 was barred by the principles of res judicata. Being agreed by the said order, the plaintiff is before this court. Next, for learned counsel for the plaintiff contended that the photocopy na ಏನು PM produce ಮಾಡಿದ plaintiff ಜೊತೆ.
ನಾನು plain ಜೊತೆಗೆ statement of these invoices I had produced it, my lords.
Counsel for the plaintiff submits that the plaintiff had produced a statement of the invoices when the suit
Please.
was filed. And therefore, the defendant had sufficient notice of the basis of the claim. He contends now the attempt made by the plaintiff is to place on record the originals of the invoices that were mentioned in the statement.
Please.
He thus contends that no prejudice would have been caused to the defendant if he was permitted to produce these documents. Next, per contra, the learned counsel for the defendants submitted that the plaintiff had taken an inconsistent stand. While in IA number 4, he mentioned that he was in possession of the originals of the invoices. But in IA number 6, he claimed that the same were lodged with the statutory auditor. Therefore, he contends that the plaintiff is not sure as to why he could not produce the documents when the suit was filed. Besides this, he contends that the plaintiff must have challenged the order passed on IA number 4. And hence the principles of res judicata would apply. Full stop. Next, I consider submissions of the learned counsel for the plaintiff and the learned counsel for the defendants. Expara. The documents which are sought to be produced by the plaintiff in along with IA number 6 are material documents which were referred to by the plaintiff in the plaint. The details of which were furnished in a separate list appended to the plaint. Full stop. Ideally, the plaintiff must have produced these documents when the suit was filed. So as a matter of fact, there is no reference to in the plaint as to what happened to the originals when the suit was first instituted. Full stop. Therefore, it can only be said that the plaintiff was negligent at the time of filing the suit in not disclosing the whereabouts of the documents. Full stop. Now that the plaintiff has attempted to produce the documents which are the suit, produce the documents which are the basis of the suit claim, it is appropriate to grant an opportunity to the plaintiff to produce these documents, lest the suit would fail on account of an inadvertent error. Full stop. Under the circumstances, this petition is allowed and the impugned order passed by the trial court is set aside. The plaintiff, IA number 6 filed by the plaintiff is allowed and the plaintiff is permitted to produce the documents. This is, however, subject to payment of cost of rupees 5,000 payable to
Very
the
well, my
defendants
lords.
before the trial court on the next date of hearing. Yes.
Grateful, my lords.
Serial number 15, Purna Prasad KR.
Yaru? Purna Prasad.
Notice
After
is
service of notice to the respondents. Is there an interim order?
interim order.
Interim order granted earlier is extended till the next date.
Much.
In December.
Raja L.
Raja L.
List after service of notice to the respondents. Interim order the Andre.
Yes, sir.
Interim order granted earlier extended till the next date. Right.
Serial number 17.
My lords, for petition,
Diya.
Until further orders and Tidiyalli. Yes.
for petitioner, my lords.
Bharat Gowda.
Yes, my lords.
Hmm.
The petitioner, the respondent had, petitioner filed a suit in OS number 405/24 before the only court, my lords, wherein the trial court, without entertaining the IA number which
Some
is,
office objections, why don't you comply it?
my lords, there is a urgency in the suit, my lords.
Hmm.
They have granted an emergent, they have issued an emergent notice, my lords, wherein the respondent, who are my parents, have executed the sale deed to another third party. They are constructing the building during this emergent notice period within 2 months, my lords, using this as a due advantage.
Interim order is not to alienate.
They have not granted, the trial court did not entertain.
Building katta idre alienation ಏನು ಸಂಬಂಧ?
My lords, they are also trying to alienate the property, the third party.
So comply ಮಾಡಿ. List after complaints of office objections.
List number 2 for orders matters. Serial number 8.
For the respondent, my lord, in this matter,
Commissioner Opasi.
I am appearing for the respondent in this matter. I have filed the objections.
Parameshwarappa.
For petitioner in this case, your lordship.
Hmm.
Passing on the medical records of the petitioner.
Medical records.
She is paralyzed and having brain stroke.
Good
Okay,
idea,
short
good.
extension of some time, little time to vacate the premises, your lordship.
Yes, madam.
My lord, as per the records, they were aware of her medical condition and 10th grade magu grandson irodu 9th grade last year avrige gottittu, my lord. So this is all the conditions which was very well known to them.
So anyway, ಎಷ್ಟು time ಕೊಡಕ್ಕಾಗುತ್ತೆ?
At least till March kotre exam ಮುಗಿಯುತ್ತೆ. Not seek further
And
extension.
rents pay madilla, my lord.
Rent.
It is,
Is there to show that you have paid the rent?
your lordship,
They have
it
not
is the-
paid a single penny and
Rent
arrears
Don't pay the
kattilla,
rent, I'm
Swami.
sorry.
illa, rent is 230 rupees per month, your lordship.
Whatever it is, whatever is the rent,
building
have
is
you
of-
paid it?
A building is of trust property. They're not receiving the rent is what the petitioner is.
No, if you
Quoted
want,
as-
you can challenge the order passed by this court before the.
We are ready to deposit any day, your lordship, rent, but they're not receiving. They
Arrears
saying that-
kottilla.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Any day, your lordship, I will deposit.
230.
Yes, your lordship, I will deposit.
Produce ಮಾಡಿ. Deposit ಪಡ ಒಂದು DD ನ ತಗೊಂಡ್ಬಿಡಿ.
Yes, your lordship.
Whatever is the arrears, 230.
Yes, your lordship.
9, Murthy K.
For petitioner, madam. Not R3 service notice ಸಂಬಂಧಪಟ್ಟಂತೆ there is a direction to R1 and 2 to furnish the address. R3 is residing in out of country, my lord. R1 is the mother, 2 and 3 are her children.
Raghavendra Miskin.
Raghavendra L. Miskin for respondent.
Next matter is not claimed anta bandide. It is written with the shara that unclaimed. Idralli innond petition.
He is abroad.
Yes, my lord. Therefore, this honorable court directed the council to furnish his address.
There is no representation for the response 1 and 2. Notice issued to the respondent number 3 is connected petitioner. Notice issued to respondent number 3 is not claimed. Means notice to the said respondent is held sufficient. Office is directed to show his name in the cause list. List down date put.
Lord,
Gujaraj or
interim order.
interim order granted or is extended till the next date.
13 December, serial number 10, Gururaj R. Waiting.
List after service of notice to respondent. Interim order, yeah.
Yes,
Interim order is extended to the next date.
13 December.
Urdu Mariappa.
11,
Petition, my lord, for the direction of the Sound Court, I serve the copy of the learned counsel for the
Where is the trial court?
Tiptorson.
Tiptur. Tiptur lawyer ಇಲ್ಲಿ ಬರಲ್ವಲ್ಲ. List after, ಇದು.
I will take
1
one
week
time,
time, 1 week time is granted to do the needful.
my lord, interim order.
Interim order ಇದೆಯಾ?
Yes, sir.
Interim order granted or is extended till the next date of the hearing.
serial
Only
number,
the,
serial number 12, KV Narasimhan.
Peruse the letter dated so and so issued. Peruse the letter dated 21/8/2024. Addressed by the principal district and sessions judge Mysuru. The time for disposal of OS number 588 of 2018, 788 of 2012, 22 and OS number 54 of 2019 is extended by 3 months from the date of receipt of a certified copy of this order.
Serial number 13, Balakrishna V.
I've explained the correct address of the eighth respondent.
For respondent number 1 and 2 this case.
I may be permitted to take hand summons, my lord.
Respondent,
The correct.
Mr. Tadiyappa. Eighth respondent is a necessary party to this petition.
Yes, my lords.
Who is eighth
Because the
respondent?
The petitioner's aunt, that is P.S. Kusma, she had executed a will and then they
This is
have,
some administrator to Blossom Multi-Speciality Hospital. Huh?
because she was admitted there and all the records are there, my lords, medical records.
What is the relief sought for in this?
My lords, over here in this piece of petition, my lords, the trial court had passed an order for production of a will. And that petition, that application was rejected. Subsequently, another application was filed by the respondents, the defendants, 1 and 2, and the same very court has again reviewed the order, my lord. They cannot review, that is my contention before this honorable court. The very court cannot pass.
How is respondent number 8 necessary?
My lords, respondent number 8 is necessary because they are. she
For
was-
this writ petition, how is he necessary? For this writ petition?
This petition, she is not necessary.
ಮತ್ತೆ?
They're all parties over here. my
Barkole,
lords.
the impugned order is passed on an application filed by the defendants 1 and 2, who are respondents
1 and 2.
1 and 2. Therefore, notice to respondent number 8 is not necessary, hence the same is dispensed. Yes, Yavat ready? Ready na?
Ready this. Ready.
Sir,
Ready.
Are you ready?
No, my lords, one date may be fixed and.
ಯಾವತ್ತು
another may be-
Trial court proceedings, evidence ಎಲ್ಲ ಕ್ಲಾಸ್ ಎಲ್ಲ ಆಗಿದೆ ಸರ್ ಅಲ್ಲಿ ಸ್ಟೇ
ಯಾವತ್ ಬೇಕು ತಕೊಳ್ಳಿ, ಎರಡರಲ್ಲೂ ಹಂಗೆ ಮಾಡಿ, R80.
ಆದ್ರೆ ಡಿವಿಷನ್ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಲ್ರೆಡಿ ಸೇಮ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೆ ಸರ್ ಆಲ್ರೆಡಿ
ಏನಂತ?
18 ಅಲ್ಲಿ ರಿಗಾರ್ಡಿಂಗ್ ವಿಲ್ ದೇ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ದಿ ವಿಲ್ ಈಸ್ ಕ್ರಿಯೇಟೆಡ್ ಅನ್ಸರ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಸಿವಿಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಅದರಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಆಲ್ರೆಡಿ
Probate-
ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ
Some order,
Lord, probation
some order is
was-
reviewed. Earlier, the trial court had rejected your request to summon a will.
Yes,
Oh,
my
sir.
lord.
Now the court has reviewed it, whether we have to see whether that will is required or not.
Yes, my lord. Probate or.
ಯಾವತ್ತು ಬೇಕು?
we are the
Stranger to the will. my
ಯಾವತ್
lord.
ಬೇಕು?
ಅಲ್ಲ ನಾವು ಪರ್ಚೇಸ್
ಯಾವತ್ ಬೇಕಪ್ಪ?
Convenient.
ಮಂಡೇ ಸರ್ ಮಂಡೇ
Monday better, your honor.
ಯಾವತ್- Courier.
7th December,
Rent deposit ಮಾಡ್ತಿಲ್ಲ sir.
serial number 14.
Yeah,
13 BS,
TM may be extended, my lord.
Entry model is extended to the next date of law.
serial number 14.
13 BS.
Yes.
That's
Here
appearing
for
for
the
the petition.
impleading applicant, my lord. I filed the IF for impleading, my lord.
Then 1 and 4 are the necessary parties.
Please, my lord.
But this petition become infractious. my lord.
Lord's petition does not become infructuous, my lords, because Lords, the facts are this, my lords. They are the purchasers, my lords, in an auction.
Sir, I asked whether response.
Please,
1 and
they are
4
necessary parties, my lord.
Yes.
4 is not necessary, my lords, 1 is necessary.
But I am for respondent number 2 and 3, my lord.
Whether respondent 1 is necessary.
Yes, my lord, but the petition become infractuous now, my lord.
The learned counsel for the petitioner submits that the notice to respondent number 4 may be dispensed. He undertakes to pay the process to issue notice to respondent number 1 during the course of the day. The process is paid, office is directed to proceed to issue notice to the respondent number 1. Here again, how does it become infructuous?
But respondent number 1 filed suit for specific performance against the respondent number 2 and 3, my lord. After obtaining decree, my lord, the respondent number 1 filed execution petition against the respondent number 2 and 3, my lord. Meanwhile, my lord, the petitioners being children to the respondent number 3, my lord.
Petitioners being?
Respondent number 3 to the present respondent number 2. I am sorry, 3, respondent number 3. Petitioners are children to the respondent number 3, my lord.
Children's of to the.
Yes, I am sorry.
Respondent
Children
two
of
and three.
respondent, no, yes, my lord. But they are claiming that they are sons of first wife of the respondent number 3 in the petition. They have filed an application before the execution.
3, 4 petitioners.
Yes, my lord. Yes, my lord.
4 petitioners. my
All
lord.
the 4 petitioners are sons of the respondent number 3.
Yes, my lord. Claiming that, my lord, they are children of the respondent number 3 filed suit for partition before the trial court, my lord. For that reason, order in the execution proceedings grant the stay on the attached property, my lord. That application came to be rejected, my lord. Thereafter, the petitioners approached this honorable court, my lord. Meanwhile, the suit filed by the present petitioner for partition came to be dismissed, my lord. The only contention of the
Lords, we have
petition.
filed RA for
This
which
is
is
judgment
noticed,
of the
my lord.
OS, my lord. Only contention of the petitioners is, my lord, they have filed a suit for partition. According that,
ಆಯ್ತು RA pending ಇದೆಯಾ?
RA pending in
notice ಕೂಡ ಏನು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
notice has been issued.
ತಗೊಳ್ಳಿ.
RA number 5028 of 24.
I am the impleading applicant, my lord. I purchased this property in court auction. There is a dispute, there is a suit for performance, my lord. That was my alternative remedy, my lord, to pay that amount, because that amount was granted. Even that amount is not paid, my lord, before to the purchaser. Then he filed the suit for execution, my lord, executing the decree. When, my lord, that amount is not paid to him, my lord, that the trial court-
Anyway, he has filed a suit for partition which
That is, my lord, I am the purchaser, entire amount is deposited before the trial court, my lord.
Yes.
Executive court, even sale certificate is issued.
that is okay, but then if he suit, everything is subject to the outcome of that suit.
That is, my lord.
They are not
because-
they are not parties in the suit for specific performance.
Even there is a finding, my lord, he has no got any share in the property, my lord, that is only independent right.
ಆಯ್ತು RA ಡಿಸೈಡ್ ಆಗ್ಬೇಕಲ್ಲ.
I may be permitted to come on record, my lord, because I am the auction purchaser, my lord.
ಬರ್ಕೊಳ್ಳಿ. IA 124 is filed. Any objection?
No, please.
IA 124 is filed by the applicant who intends to come on record. It is stated in the affidavit accompanying the application that the applicant is an auction purchaser at a auction held by the executing court, and that he is interested in the outcome of this writ petition. The learned counsel for the petitioner fairly does not oppose this application. Hence, IA 124 is allowed, as any outcome, as any finding in this writ petition would affect the auction purchaser. Hence, IA 124 is allowed, and the applicant is permitted to come on record as respondent number
Respondent number 5.
5. Counsel for the petitioner is directed to amend the cost title. Yes.
Lords, interim order may be extended.
Interim order. ಏನಂತ interim order ಕೊಟ್ಟಿದ್ದು?
Lords, interim order.
Entire proceedings is stayed, my lord.
Entire proceedings in the execution is stayed, my lords.
The execution ಆಗೋಗಿದೆಯಲ್ಲ. Everything is over.
Lords, execute, my IA, my lords, which was,
Sale confirmation ಆಗೋಗಿದೆಯಾ?
R6, my lord.
Whether sale confirmation is already done.
Yes, my lord, this is a sale certificate is issued, my lord.
What
Lords, next week, my lords, I'll seek instruction on that and
Yes. Interim order granted earlier is extended till the next date. Yes.
Any
Sit
date
down,
may be
date.
fixed, my lord. This reason, my lord, I am not.
We'll fix a date if you allow us to do it.
Because but I am not entitled, even I not taken the back that amount also. for
You said
property.
fix a date, you please wait for us to fix a date.
10th December,
Uh,
serial number 15, Chandraya.
R7 and R9. Chandraya,
Appearing for petitioner, my lord. I'm giving memo that respondent one is expired.
what about 7 and 9, madam? Are they necessary parties?
Yes, my lord, that also I'm giving. My lord.
Jayamma and Yashoda. ಎಲ್ಲಿದೆ ಜಯಮ್ಮ ಯಶೋದ ಕಾಸ್ಟ್ ಶೀಟ್ಲಿ ಇಲ್ವಲ್ಲ ಅವರು?
There, so respondent one is there in the hospital, my lord. Legal aids are there. sir.
Madam, who are respondents 7 and 9? ಸ್ವಲ್ಪ ನೋಡ್ಬೇಕಲ್ವಾ ನೀವು? ಯಾರು ರೆಸ್ಪಾನ್ಸ್ 7 and 9 ಯಾರು? ದೇರ್ ಪ್ಲೈಂಟ್ ಕಾಪಿ ಹಾಕಿಲ್ಲ ನೀವು. And ಈ ಕಾಸ್ಟ್ ಶೀಟ್ಲಲ್ಲೂ 7 and 9 ಇಲ್ಲ. Who are these people?
Jayamma and Jayamma.
ಜಯಮ್ಮ ಅಂಡ್ ಯಶೋದ ಯಾರಮ್ಮ ಅದು? ಜಯಮ್ಮ, ಕಮಲಾ, ಯಶೋದ. R4, LRs of R4. One week time is granted to do the needful. ಬರ್ಕೊಳ್ಳಿಲ್ಲ. R7 and R8 were the LRs of defendant number 4. Full stop. No relief is sought for against them in this writ petition. Hence, notice to the said respondent is dispensed. The notice issued to respondent number 3 is refused. Hence, notice to the said respondent is held sufficient. Office is directed to show his name in the cause list as served. 1 week time is granted to take steps in respect of respondent number 1. Yes.
Serial number 16, B. Sharat Kumar.
ಏನಿದೆ maintainability? Kindly have a ಏನ್ maintainability ಏನು? Maintainability, why do you say, why does the office say it's not? Compromise petition, no? Pass over. Maintainability ಎಲ್ಲ pass over. Pass over.
Serial number 17.
ನೀವು ಫಸ್ಟ್
Pradeep
ಫೈಲ್ ಓದಿ.
Kumar.
ಫೈಲ್ ಓದ್ರಿ ಫಸ್ಟ್. ಫೈಲ್ ಓದಿ.
Serial number 17, Pradeep Kumar RH.
Petitioner, I pray for weeks time.
1 week time is granted to do the needful. R5 necessary party. now.
Necessary party, my lord. Necessary. The interim of my kind.
What about R2? R2 and ತೀರೋಗಿದಾರಂತಲ್ಲ.
I'll bring the legal aids on record.
They are already on record?
No, wife has to
Wife
be
has to.
got on record.
1 week time is granted. Saka,
Sack.
1 week time is granted to do the needful.
The interim of my kind.
Interim order is extended till the next date of hearing.
13 December.
Ravish,
Number 18, Ravish, party in person.
this-
And the party in person, the bona fide reason ಕೊಡಿ ಅಂದ್ರೆ medical records ಕೊಟ್ಟಿದ್ದೀನಿ submission. ಅದ ಏನು
the
bona fide
petitioner has
reason
not
ಕೊಟ್ರೆ
explained the delay in not filing the written statement and also, ಎಷ್ಟು ವರ್ಷ ಇದು?
2018 9 ಇಂದ ಇದೆ. So still now I am suffering from the same disease. So considerations.
Counsel for the petitioner seeks, the petitioner seeks time to comply the order dated 14/11/24. List on date put.
17th December. Serial number 19, Naveed Ahmad.
Appearing for petitioners.
Hmm.
Filing memo to dispense the
A memo
notice
is
to
filed.
respond number 2 to 18, my lord. Only the respond number 1 is contesting party.
A memo is filed seeking dispensation notice to respondents 17 and 18. 17 and 18.
2 to 18, my lord.
ಅಲ್ರಿ ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದಾರಲ್ರಿ. ಮಂಜುನಾಥ್ಗೆ ಇಂತ R1 to 16 ಇದಾರಲ್ಲ.
ಹೌದು.
ಮತ್ತೆ ಇದು ಅವ್ರಿಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳ್ತೀರಿ?
Reissue ಮಾಡಕ್ಕೆ reissue the notice ಇದೆ.
1 to 16 Manjunath is appearing. So why do you seek for dispensation? A memo is filed seeking dispensation notice to respond 17 and 18. Memo is taken on record and notice to respondent 1718 dispense. It's on. Interim was extended to the next date of hearing. ಸರಿ ಮಾಡ್ಕೊಡಿ ಅದನ್ನು.
ಮಾಡಿಕೊಡ್ತೀನಿ. Serial number 20, Venkatachalapati SK.
List of
Petitioner, really, I have been served only with a copy of the writ petition. The annexures have not been served. May request that
ಏನಿದೆಲ್ಲನು ವೆಂಕಟಾಚಲಪತಿ
ಕೊಟ್ಟು ಕಳಿಸಿ.
ಪಿಟಿಷನ್ ಕಾಪಿ ಫುಲ್ ಕೊಡ್ಬೇಕಲ್ವಾ?
Please, I'll supply.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಇಲ್ಲಿ ಬಿಡ್ಬೇಕಿಲ್ಲಿ. 1 week time is granted to serve complete set of the writ petition to the learned counsel for the respondent.
Serial number 21, Narayan MR.
Interim order granted early is extended to the next date.
obliged.
13 December. Serial number 21, Narayan MR.
List
I
on
appear for the respondent in this case, my lord. I
Number
accept
23.
notice for the respondent.
Mr. Narayanan. Postal, yes, respondent, who is the
I
lawyer?
appear for the respondent in this case, my lord.
What's your name?
December.
Gaurav Singh Gaur. I undertake to file wakalatnama as well, my lord.
No, in whose name the cause list should be entered?
In my name itself, my lord.
Mr.
Gaurav Singh Gaur. It's coming up as my name.
Gaurav Singh Gaur.
Please, my lord.
Gaur.
GAUR, my lord. It's appearing on the screen as well.
Gaurav Singh.
Mr. Gaurav Singh R. Gaur
Gaur, my lord.
undertakes to appear for the respondent. Yes. You are ready?
Ready.
ಏನಿದು?
My lord,
2017 ಇದ ಸೂಟ?
they have filed a suit for recovery of the money payable to them on account of the works contract executed Noida. The tender was accepted in Delhi. They have a branch office in Delhi. They have filed it in Bangalore. The plaint, they do not say anything. But when I filed the IA for rejection of the plaint, they say that they encashed the check in Bangalore. I have missing the check there. They are encashing.
Where was the contract entered into?
In Noida, execution of works contract in Noida.
Yes.
Page
Yes, what is the cause of action in Bangalore, mister?
No, only because they have encashed the check in Bangalore, they say,
What encashed the check?
which I am giving there. They have given the check, they encashed it, but they have got branch office
So
in
what-
Delhi.
For what purpose did you give the check?
Towards the contract payment payable by them.
Yes, mister. What is the cause of action in Bangalore?
My lord, if I may. If my lord may kindly peruse the impugned order itself, it starts at page 19 and 22. Indeed, there was a works contract entered into. The contract was entered into at Bangalore. The defendant, I stand corrected, my lord. The respondent and the plaintiff before the trial court.
Where have you mentioned in the plaint that the contract was entered in Bangalore?
Please, my lord. My lord, paragraph 3 and 4 are the mentioning of the plaintiff addresses, and at paragraph 6A and B are the mentioning about the purchase orders. That, my lord, may find it at page 38 and 39, my lord. I just have the petition which was served on me before the trial court, my lord, not the exact. So that's the page number in the plaint.
What is there to show that the contract was entered in Bangalore?
My lord, in the sense, the defendant company, the petitioner before this honorable court, has always been functioning from this very place, Bangalore. They also had a branch office as well as, of course, their registered office. Their defense is that it was shifted and the ROC records were changed later on. Now, my lord, may I kindly highlight, it's a matter of 2017 wherein I had a decree in my favor.
I asked you a simple question. You're beating around the bush.
My lord, I'll answer it to the point.
What happened in Bangalore for you to claim that a cause of action arose in Bangalore to file a suit in Bangalore?
My lord, all the payments were realized at Bangalore. I do not have any other bank account. The plaintiff.
Does it give you a cause of action?
My lord, part cause of action indeed, because all the transactions, there's certain parts of the contract which were performed from Bangalore and
Where is
supplied
it
from
mentioned in
Bangalore.
the plaint? Where is it mentioned in the plaint?
My lord, I had already mentioned the paragraphs 3 and 4, and even at the time of examination and cross-examination.
Please
that
go through the file and come back
I will. My lord,
pointedly.
also,
When a pointed question is put to you, you give a pointed answer to the court.
I'll try to give
Don't
even
beat
a
around the
detailed
bush.
answer, my lord. May I also request my learned friend to
List down
serve
when do
the
you want
copy
it?
after compilation?
When do you want it?
Interim order may be granted because that they are going with
For
the
interim stay of further proceedings before the trial court till the next date of hearing.
any day.
List down on date code.
17th
Ajesh Kumar,
December number 22, Vishwanath Kanvi.
I appear for petitioner, your lordships. Your lordships,
Rajesh
the copy has been served on the counsel of the respondents, your lordships. To serve on the respondents, a week's time may be given, your lordships.
the learned counsel for the respondent seeks time.
For the petitioner, your lordships.
Number 22 now, huh?
Please, your lordships.
Vishwanath Kanvi.
Please, your lordships.
1 week time is granted to do the needful.
Much obliged, sir.
Interim order is extended till the next date.
Please.
In December. Serial number 23.
Manoj 23, I beg to appear
Yes,
on
Kumar.
behalf of the petitioner, Manoj. Manoj, there's a counsel submission, Manoj, wherein we have stated that the copy has applied, the claim petition has applied before the city civil court has been produced, Manoj.
Where have we produced?
Manoj, Annexure Q, Manoj.
Learned counsel for the petitioner submits that he has Annexure Q is not a claim statement, mister.
Manoj,
That is a reference.
Manoj, this is what has been applied
It's
for.
only intimation regarding deposit. Only intimation regarding deposit. Where's the claim statement made by you?
Manoj, the
1 week time is granted to do the needful. Yes.
okay.
Number 24. Girish B. Bandare.
1 week time is granted to do the needful. Interim order, yeah?
Yes, interim order.
Yes, next.
Serial number 25. Shravan S. Lokre.
Petitioner in this matter, my lord. Order of this code, it's complied, my lord. Yesterday, my lord.
25.1, your senior said religiously you are complied.
My lord, yesterday it's complied, my lord.
ಯಾವುದು serial number 25.1.
25.1 to total 11 cases, it's complied, my lord.
Learned counsel for the petitioner in 25.1, learned counsel for the petitioner submits that he is complied the office objections. List after service of notice to the respondent. ಎಲ್ಲ ಕೇಸಲ್ಲೂ ನಾ?
ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಅಲ್ಲ ಸರ್. Except 25 and 3.
Yes, list these petitions
kindly
after
extend the
complaint,
interim
after receipt of service of notice to the respondent. Yes, next.
Kindly extend interim order.
Interim orders granted in all these petitions are extended till the next date of hearing.
Right.
List on date.
17 December.
Anisha,
Serial number
I appear for the
26.
petitioner.
yes.
Lordships, in this case, on the last occasion, your lordships had directed us to serve the counsel in the trial court. We have done so. Your lordships had also issued emergent notice. My respectful submission is respondents 2 and 3 in the writ are non-contesting respondents, your lordship. They are co-defendants along with me in the trial court.
Then file a memo.
Please, it may be passed over, I'll file a memo.
The learned counsel for the petitioner has filed a memo seeking dispensation of notice to respondents 2 and 3.
Please.
Arjun Rao appears for R1.
R1 minutes.
Hence notice to R2 and R3 is dispensed.
Lords, I have one more submission to make. There are office objections which are kept open. The registry has raised an objection that we have not been able to provide the PIN code and the complete address.
That's
of
okay. Yes, next.
That may be overruled. That is my.
The office objections are overruled. Then what?
May I make one request, my lord? There are 2 other writ petitions which may kindly be connected with
Put
this
the number
same
for it.
facts.
List this
Got it.
petition along with the
My lords,
number.
I have one submission. The 2 writ petitions are entirely unconnected to the present case. Those 2 writ petitions arise out of an order issuing emergent notice in a specific performance suit, which is entirely different from the present suit
Facts
that is before them.
entirely the same. They are a
No,
purchaser.
Same.
Please wait. If it is not connected, we'll impose cost on him. Don't worry. The learned counsel for the respondent submits that 2 other writ petitions are interrelated to this writ petition. And hence praise that this writ petition be called along with the 2 writ petitions. Hence list this petition along with WP number so on, so on. Sorry. If it is not connected, then we'll penalize him for making a wrong statement.
Yes.
Everybody should be responsible in making a statement.
The 3 volumes, my lord, the facts. are
Whatever it
entirely
is,
the
I do
same.
not know, mister. You say it is connected, I'm connecting it. Tomorrow it is found not connected,
Yes, my lord, I'll point out it.
then you will be in trouble, Aster.
Yes.
I was just putting you on notice.
Yes, my lord.
Serial number 27, Devaya.
No, serial number 26 may be had on the 11th of December. subject
Whichever
to your
date,
lordship.
ಯಾವತ್ತು ಕೊಡ್ರಿ ಒಂದು date. ದೇವಯ್ಯ what office objection?
12th objection. Certificate I have furnished, my lord.
Office objection is overruled. This is the
Petition copy also I have furnished and.
This is the petition for preliminary hearing on date.
There's an urgency because there's only that ex parte order has not been granted.
In
It's a very
December?
limited scope.
ಯಾವತ್ತು
9th December.
Monday ಕೊಡಿ Monday.
Monday, my lord.
ಶಾಮೇಗೌಡ.
Great.
December. Serial number 28.
Some urgency in the matter. Office objection, some allows minor except office objection number 3. I have filed a memo, my lord, seeking deletion of respond number 2 and 3. If they are dead prior to filing of this.
There are half a dozen office objections. What do you want me to overrule?
My lord's office objection number 3, my lords, I have filed a memo seeking deletion of R2 and R3 because they have died prior to filing of the writ petition itself.
Office objection serial number 2 is overruled.
My lords, I am the
List
objector. my
after
lords.
complaints of other office objections on
There is
Monday.
extreme emergency. Today, my lords, the delivery warrant has been issued. Court commissioner warrant has been issued before the FDP court. My lords, I am the objector, my lords, before the FDP proceedings. My property, my lands, my lords, have been clandestinely included and a decree has been obtained way back in 2015 and my lords, FDP.
The order, where is the order
My
issued?
lords, the
Delivery
order
order.
is at page number 32, my lords, ink page number 32. It's just a single page order wherein without conducting an inquiry, my lords, my objector's application is rejected.
No, where is the order issuing delivery warrant to be executed today?
My lords, court commissioner warrant has been issued.
ಎಲ್ಲಿದೆ?
The last annexure, my lords, annexure N, my lords. Commission warrant has been issued. Annexure N.
Commission warrant for what?
My lords, what had
Commission
happened?
warrant for what?
Earlier, my lords, commissioner warrant had been issued to, my lords, measure the property, my mates and bounds. Then, my lords, I came to, when they came near my property, my lords, to measure my properties, I came to know that these proceedings are pending.
So whether the commissioner submitted his report.
He has not furnished it yet.
ಮತ್ತೆ delivery warrant ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ, commissioner warrant.
List for preliminary hearing on ಯಾವತ್ತು ಬೇಕು?
My lords, any date, my lords, day after tomorrow, my lords.
You don't make this false, wrong submissions, mister. You said delivery warrant, delivery
My
ಕೊಟ್ಬಿಟ್ಟೆ,
lords, I
ನಾಳೆ
could correct
ಕೊಟ್ಬಿಡ್ತಾರೆ.
it. By mistake, I mentioned delivery warrant, then my lords, I mentioned.
Don't do this mistake is what I am trying to tell
Please,
you.
my lords.
You will carry a bad impression. Yes, Abhinay.
List number
Monday, my lords, my.
3rd December, list number 1 for hearing on IA, serial number 18, R. Chandrana.
These are the two LR applications. First petitioner is dead and first respondent is dead. LRs of the petitioner want to come to the court.
Petition.
No, sir. Until now.
Applications is in time.
IA 1/23 is filed by the applicants who are the legal heirs of the deceased petition number 1. Since the cause of action is survived the death of petition number 1, IA 1/23 deserves to be allowed. Hence, IA 1/23 is allowed and the applicants are permitted to come on record as the LRs of petition number 1. What about IA, LRs of
In
R1?
respect of respondent number 1, yeah, it may be allowed, please.
IA 1/21 is filed to bring the LRs of R1. Since the cause of action is surveyed against the LRs of R1, they are liable to be brought on record and proceeded with. Hence, IA 1/21 is allowed. Counsel for the petition is directed to amend the cause title.
Copies of the writ petition, please, my lord. Kottila
ಕೊಡಿ,
LR
copy
application.
ಅಂತ ಕೊಡಿ.
2008 suit, please, my lord, stay ಆಗಿದೆ.
ಎಲ್ಲರಿಗೂ ಕೊಡ್ತೀನಿ.
Next week, please.
ಯಾವ ಕೊಡ್ತೀರಿ? 2008 suit
2008 suit,
ಯಾವತ್ತು ಬೇಕು?
2019 it is being,
ಆಯ್ತು, ಯಾವತ್ತು ಬೇಕು
Few days
ಹೇಳಿಪ್ಪ.
by
next week,
Monday.
please, my lord.
Monday, list on Monday. In the meanwhile, learned counsel for the petition is directed to serve a complete set of the writ petition to the learned counsel for the LRs of R1.
R1A,
R1A.
please.
Play ಮಾಡ್ಬೇಕಾ?
ಇದು R1 ಅಂತಿದೆ ಇಲ್ಲಿ.
R1A, R1.
Only one
zero, my lord.
one LR.
For R1.
Wife is the LR.
R1A. Yes, next.
Serial number 19.
Amendment ಮಾಡಿದ್ದು.
ಆಯ್ತು.
Sriram Timappa Nayak, serial number 19.
I am applying for the response 1 and 2 months.
For the petitioner in this case, lords. Challenge the writ petition with respect to an order under for filing application under 1 Rule 10, your lords. In pleading
The suit
application,
for,
it was partition, your lords.
who are you?
I'm the family member.
You're a family member.
Yes, your lords.
Why is it rejected then?
It is rejected on the ground that there is another suit which is pending, your lords. And that got disposed of.
And I'm filed the application just to delay the proceedings, Your Lords.
No, that suit was filed by you.
No, I was the defendant number 3 in that suit as well. I was placed ex parte.
Yes.
But there's already a compromise between his family members. But might I take my lordship's attention to statement of objections, Milords? Are 3 for a moment. Milords, they file a suit for partition. He files a suit for partition against his family members. That is compromised. He suppresses all those things, but despite that, these have been brought to the notice of the trial judge.
Where is the suit? Where is the plaint?
The plaint in the current writ matter.
Manas, plaint is at page, Manas.
Because Manas, the current
26, Manas, page 26.
Current petitioner and the other respondents, Manas, barring me, are in
Page
collusion
26.
with each other in this matter.
Page number 2742 is the plaint.
To simplify Marbeku, Sunil.
Please, Manas.
You should simplify it and break it down. We are complicating.
Manas,
No, Manas.
one submission, Manas.
Here.
In a suit for partition separate possession filed by respondents 1 and 2, Manas, in which Manas, the impleading applicant has filed an impleading application seeking he is a necessary party, saying that he is the son of second respondent of Ayyappa Reddy. Manas, this government of Karnataka has denotified 1 acre for and on behalf of joint family.
Ayyappa Reddy,
Ayyappa Reddy is original propositor, he is no more. This Hemant Reddy is the son of petitioner, he is the son of second respondent Muni Reddy. So therefore, in a suit for partition, he wanted to implead as a necessary party. That application was rejected on the ground that he is not a necessary party. Again, a switch one as present petition is fine.
That is
So
the
therefore,
argument of the petitioner.
petition
not
is to be allowed.
That is the argument of the petitioner and the
Respondent
concurring
is
respondents,
opposing
not
the
because they are
petition.
in collusion
Please,
with each other.
please.
Now, my lordship may kindly see. Milords, there were 4 branches, Milords, and there was a registered partition way back in the year 1974 between the 4 branches. Subsequent to which, Milords, the property which fell, Milords, in the said registered partition to the branch of 1 Krishna Reddy, Milords, was notified, later on denotified. The said property has been purchased by me, and Milords, a suit has been filed as against that property, Milords, by one of the said family members there too. That is a matter which I will have to handle out on my own. Now, Milords, the current impleading application, Milords, has been filed, Milords, by a person, Milords, who had released from the joint family, Milords, by virtue of a partition deed of the year 1974. His son, Milords, files application. Now, Milords, insofar as the properties which were allotted to, Milords, the father of the current impleading applicant, Milords, I just request for one moment, Milords, annexure R3 for a moment. Milords,
Just a moment.
Yes, Milords.
Where is this suit filed in OS number 2407 of 2002?
Milords, annexure R3, Milords, is the compromise petition. I have not, the plaint is not there.
2407 of 2002.
Yes, Milords.
Where is it pending?
Milords, it's been compromised.
It's compromised.
May I take my lordships to annexure R3 for a moment? Statement of objections. ಇಲ್ಲೇ ಬಿಡಿಸ್ಕೊಡ್ತೀನಿ ಇನ್ನೊಂದು ಸೈಡ್ 23 for a moment. Impleading applicant petitioner, Mr. Hanmant Reddy is there.
Who is this impleading applicant?
The petitioner,
Hanmant Reddy.
Hanmant Reddy. He is the plaintiff there in the said suit. He files a suit for partition, intra-family suit for partition between
Who
himself.
are the parties in this suit?
His brothers, sisters, mother, everyone included there.
Not the plaintiffs in this suit?
Not the plaintiff in this suit. He is clearly not concerned. And that suit was filed, Milords, to allot the shares which they had received in a joint family partition. Milords, it indicated that this property was nowhere it was not involved there. And my lordships could see the schedules, Milords, which starts at 26. We are concerned with survey number 222. It was not a parcel of that at all, which meant, Milords, that they did not have any interest with this property. And what was allotted to them separately, Milords, distinctly, was, Milords, made a part and parcel of the said suit.
That's Hanmant Reddy again, Bantu.
Milords, Hanmant Reddy is scheduled C, Milords. So 28. One site at survey number 19/2 Kacharapalli, and my lords, 5 guntas of land in Chokanalli. Clearly, my lords, he is in no way connected with the current suit schedule property where the list of partition is pending.
Yes, Mr.
Your Lords, as per the facts, the present survey number is 222, Your Lords.
No.
And that survey number was acquired by
Please
the
tell
BDA.
us 2407, the properties in, how did you acquire the properties in OS number 2407 of 2002?
Your Lords, as partition itself, through a
1970. Partition deed.
through a partition deed itself, Your Lords.
Where
And
is that
for-
partition? Where is that partition deed?
I have not produced the partition deed, Your Lords.
No, if you have got it under partition deed, and if you have acknowledged that these are the only properties available to the family,
Even this subject matter property is also involved in that partition, Your Lords. And subsequent share was allotted to the petitioner.
and therefore I'm asking you, in the partition deed, to whom did this property belong or was granted?
Krishna,
The property which is involved in the present suit, ಅದು ಯಾರಿಗೂ ಹೋಯ್ತು? 1 acre in survey number 222.
Yes, sir.
As per the partition deed, ಯಾರಿಗೂ ಹೋಯ್ತು ಅದು?
Krishna Reddy.
Huh?
Krishna Reddy.
ಕೃಷ್ಣ ರೆಡ್ಡಿ.
Krishna Reddy.
ಕೃಷ್ಣ ರೆಡ್ಡಿಗೂ ಮತ್ತೆ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಏನ್ ಸಂಬಂಧ?
And even Muni Reddy, Your Lords.
Krishna Reddy.
And even plaintiff's father, petitioner's father, Your Lords. Equally, it was allotted. And subsequently, this property, this property was acquired by BDA. And subsequently, in 2009, it was denotified.
Mr. Your father's name is Muni Reddy,
Muni Reddy.
not Muniraj Reddy.
No, Your Lords.
ಎಲ್ಲಿ the partition deed ತೋರ್ಸಿ?
Your Lords, partition deed, I don't have. I will get the partition deed and I'll produce.
You have a copy?
Copy there. I might have to handwritten. Sir.
ಆಯ್ತು ಕೊಡಿ, I can read, ಕೊಡಿ. ಯಾರಿಗೋಯ್ತು ಈ ಪ್ರಾಪರ್ಟಿ? 222.
222. One, I'll just underline it and send it across.
Pass over, ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Please, not please.
Serial number 20.
Vachan.
Vachan HU.
Vachan.
Blood.
Yes.
Blood, your lordship passed an order on the last occasion regarding
What are you pointing?
The Holla is representing us.
Lord, the 37 has been dismissed, my lord.
the review no vaja.
What happened to the Supreme Court then?
Supreme Court, my lord, matter is filed. In fact, Supreme Court had directed us, my lord, that, though, my lord, we had filed one petition. Liberty to, my lord, file a substantial petition, my lord, challenging that. Huh? They filed.
Your lordship's order was challenged before the Supreme Court.
Yeah.
Hello, Navan.
Nama.
ನೀವೇ ಹಾಕಿದ್ದು. And Supreme Court said, you
Which
better
order?
start
The
paying.
order dated 2810.
Your
28.
lordship passed an innocuous order
You have filed.
that if
You
the
have-
review petition is dismissed, the execution proceedings should continue. Now they filed against your lordship's order before the Supreme Court. In the meanwhile, review is also dismissed.
So the review petition filed before which court?
My lord, before
Delhi-
Delhi High Court, my lord.
Division bench
It's also dismissed.
Yes.
Review. have
What
filed.
remains?
Nothing.
Supreme Court ಹೋಗ್ಬೇಕಷ್ಟೇ ಹಾಕಿದಾರಂತೆ.
But what they do is,
In another 2 weeks, ಇಲ್ಲ 10 ದಿವಸದ ನಂತರ ಕರೀರಿ. In fact, we have a DD for that principal amount, but principal amount was 6 crores. Interest ಎಲ್ಲ ಸೇರಿ 1000 ಕೋಟಿ. Anyway, it doesn't matter. We have a DD for 6 crores.
blood,
Because on the
the
last occasion-
execution court, blood, after perusing your lordship's order, blood, the interim order is already vacated as on today. There is nothing service in the petition. Your lordship had clarified that if the review petition is dismissed, then I have liberty to proceed with the execution. Now the execution court says there is some word in the order of the your lordship that the interim order is continued. If it is clarified, I'll proceed. That's all. As
I
on
filed,
today,
but not
the
before the
order is already
No,
vacated.
now that the review petition is dismissed.
Yes.
And
Your
what
lordship
about-
has already said that the execution can proceed. Now the trial court says one sentence is the interim order should continue till next date. And ಅದೊಂದು clarify ಮಾಡಿದ್ರೆ ಮುಗಿತಷ್ಟೇ.
My submission to your lordship is, my lord, Supreme Court order may be please, my lord.
No, this
see, my lord.
2810-2024 was challenged.
Yes, my lord. Your lordship.
What happened? What happened?
That is, they withdrew. They withdrew after arguing for some time because the,
Copy.
that I was there, my lord, the Supreme Court said, you better start paying the amount.
Copy, my
Forget
lord.
about all this litigation.
But cool.
Last paragraph, my lord, page tav nodidre.
ಹಾ.
They have given, granted us liberty to move the Supreme Court, my lord, by a substantial petition.
That's against 37 order.
Whatever.
Yeah.
Therefore, your lords may call this after 10 days, my lord, if
No,
Supreme
but
Court
now that
dismisses
the
it,
review
nothing
petition
remains.
is dismissed, let them take action, whatever action that is.
As a matter of fact, there is an earlier judgment of the, there is an earlier order which says that execution should
It is
continue.
submitted by the learned senior counsel for the respondent that the petitioners had challenged the order dated 28/10/2024 passed by this court in SLP 26856 of 2024, which was dismissed, which was withdrawn on 18/11/2024. He further submits that the review petition filed by the petitioner before the High Court of Delhi was also dismissed on
But it was dismissed on 18/11.
18/11.
I'm sorry, madam. 18/11/2024.
18/11/2024.
Yes, it's along with the memo I filed.
In that way, this is not disputed by the learned senior counsel for the
Only thing
petition.
is, my lord, we have filed a substantial petition before the Supreme Court, my lord, matter is coming up.
Against
in
the
10
review
days.
petition,
No, against 37 also they should file.
against 37 also.
Yes, ma'am. That is coming up. Your lords may call this after 10 days.
In that view of the matter, the interim order of stay granted by this court, which is extended from time to time, stands dissolved automatically.
Please.
Yes.
21, Mamta Kulkarni.
Mamta
Yes,
Kulkarni.
for respondent number 1 to 8.
Ah,
Filed vacating application, my lord.
vacating. Lord.
It was understood that the matter is to be heard on merits.
No,
I am ready.
please. You also ready, please. Suit is filed in which year?
It's not a suit, it's a land acquisition matter. The land was acquired in the year 1990.
Now, if it requires detailed hearing, we'll take it some other day.
Indeed.
Lord, my respectful submission, my lord. Only short question, my lord. They are claiming, my lord,
But the senior counsel says it requires detailed hearing. You say it's a short question.
not more than 10 minutes.
Yavat ಬೇಕು ಹೇಳಿ? ಯಾವತ್ತು ಬೇಕು?
Monday, my lord. Post.
ಮಂಡೇ ಮಾಡ್ಬೋದು, ಇವತ್ತೇ ಮಾಡ್ಬೋದಲ್ಲ? ಇಷ್ಟ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
13 December, serial number 22,
13 December.
Mahantesh S. Hosmat.
Yes, Mahantesh Hosmat. Correct.
State of hearing in court has been directed not to secure a survey. Interim
Interim order is extended, C number 21. Learned counsel for the petition, seek time, list on last week.
17 December,
Yes.
serial number 23, K. Ravi Shankar.
The last occasion, your lordships have recorded that they are also agreeable for 50 lakhs. In lieu of that, I will file an affidavit by way of an undertaking.
Ready to purchase.
ಯಾವಾಗ?
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡಿ, ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಡ್ತೀನಿ, ಅದರ ಎಫೆಕ್ಟ್ ಅದೇ ಎಫೆಕ್ಟಿಂಗ್.
The pursuant to the order dated 19/11/2024, the learned counsel for the respondent submits, the respondent is also willing to purchase the property for a sum of rupees 50 lakhs.
Right.
List on ಯಾವತ್ತು ಬೇಕು?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟು ನಾನು ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀನಿ.
ಯಾವತ್ತು ಬೇಕು ಅಂತ?
I have to send it to Sulya and get it back.
ಎಲ್ಲಿಗಾನ ಕಳಿಸಿ, ಬಟ್ ಯಾವತ್ತು ಬೇಕು ಅಂತ? ಯಾರ ತಕೊಂಡು ಹೋಗ್ಬೇಕಾ ಅಥವಾ ಮೇಲಲ್ಲಿ ಹೋಗುತ್ತಾ?
ಇಲ್ಲ ಮೇಲ್
ಇಮೇಲ್ ಅಲ್ಲಿ ಹೋಗ್ಬೋದಲ್ಲ?
ಹೋಗುತ್ತೆ 5th or 6th.
5th. Yes.
Serial number 24, Revanna Bellary.
Mr. Revanna.
Appear for respondent number 1 to 5. In this case, I challenged the impugned orders of IFI filed by the objector to adjudicate their rights over the property, which is
But you took time on the last date to verify whether you can remove the articles.
ಅದೇ ತಾವು ಹೇಳಿದ್ರಿ.
I also contacted my party.
Any articles?
My lord,
actually, tenant respondent number 5, sorry, 6 is staying in the premises. He is the tenant. My respectful submission is,
petitioner in no way concerned with the scheduled property. He is a stranger to the scheduled property. We are the owners of the scheduled property. Our respondent number 6 is our tenant. There was adjournment of tenancy from 1st July 2009.
Respondent number 6 is the tenant.
Tenant.
This
Who is
case,
this petitioner then?
In this case, I am the objector, madam. I challenged the impugned order.
What is the impugned order?
In both the cases, sir. Impugned order is at the annexer. At the annexer J, madam.
Annexure J.
Annexer J, madam. The relief sought in the application IA number 5. Under section 47 of CPC, madam.
Annexure J, na?
J's, annexer J's. Pagination 49s.
Page number?
49s.
49.
49s. There in the page number 2, it is shown and described that what are all the relief sought for by the applicant to declare him as absolute owner over the application property and to restrain the JDA from handing over the possession of the application property. And further, my lord, on the basis of the application and the objections filed by the other side, the respondent number 1 to 5, the points have been framed from the trial court at page 55. Whether the objector proves that he is the absolute owner in possession of the application property, whether the objector proves that the DHR is causing interference over the application property, and third, whether the objector proves that the possession shall not be handed over to the DHR, whether the objector is entitled for reliefs of declaration and mandate injunctions, permanent injunctions. My lord, instead of suit filing another suit by any of the person or representative of the parties of the in the suit below, that even another person also can hesitate the application under section 47 of CPC, subsection 3 of CPC. There in the subsection 3 of CPC is very much clear. Even any stranger can be hesitate the proceedings and decree for adjudicate the rights of him. Under these circumstances, my lord, the property was earlier belongs to the parents Gafur Saab, my lord. The property came into the Gafur Saab from his father, and Gafur Saab has constructed the house property, and the loan has been taken from the loan one person, Abdul Jabbar Saab, among the 14 members of the joint family member. Therefore, the evidence of the PW2 has been completely ignored from the trial court, my lord. And there they have the rights over the property from the others also. PW2 Abhibunisa was examined also in the trial court.
We will get the records.
Please.
Office director to secure the records.
My lord, actually, my referable submission is the learned counsel for the petitioner sought redemption of the mortgage after sale of the property.
That record
The
also
property
taken
was
into
sold,
court.
the property was
get
sold,
the-
My suit is
property
earlier,
was
my
sold to us on 21st.
Office is directed to secure the records from the
In this
executing
case,
court.
the records are already.
And OS 423.
TCR is kept below.
What about
that suit proceedings also required.
Yaudu?
OS 423/09.
How is that required?
That the suit is filed by the present applicant earlier to the suit filed by the purchasers. ಅದಕ್ಕೋಸ್ಕರ ಆ ದಾವೆ ಬೇಕಾಗುತ್ತೆ.
That is already
Record.
decided by this honorable court, my lord.
Not required. Just
My lord,
list on-
that is.
When
is
will you
all-
argue?
Please.
On date, put a list on date. Yes, next, Mr. MJ Alva.
Sir.
Defendant's petition against the rejection
I
of,
said MJ Alva.
but
Yeah,
now
MJ
it has
Alva.
to be heard, my lord.
Pardon?
They have filed the application for vacating the stay granted by this honorable court. It virtually amounts to disposal of the petition itself.
Aye, sir.
Therefore, the matter has to be
Sir,
heard.
suit is filed in which year?
Suit is filed in 2014.
Yes. What is the application?
My lord, the defendant has filed an application for amendment of written statement.
What is the suit for?
Suit for bare injunction.
What's that?
We have disputed the title, identity of the property and the boundaries. The property is 32 gunta land.
At what stage you filed?
My lord, it is in the stage of evidence of the plaintiff, my lord.
At
The
what
stage of,
stage did you file the application for?
at the stage of evidence of plaintiff, my lord. The application was filed on 27/6/2018. Subsequently, my lord, the first plaintiff died, LRs were brought on record, and IA was filed for IA was filed for appointment of commissioner after 5 years. For 5 years, my application was pending before the trial court.
Why
There-
these facts were not pleaded at the earliest point in time?
My lord, these are the true facts, my lord. He could not plead it at the earliest point of time. Therefore, my lord, immediately after the framing of the issues, these things.
Therefore, I am asking you, why did you not plead it at the earliest?
My lord, he has informed the learned counsel, but
You
due to some,
virtually replaced your statement. Virtually replaced your statement.
it is not replacement, the statement, my lord. He has, he wanted to bring in the true facts.
Yes, Mr.
Not my lordship.
If your lordship
Not
could
true
kindly
fact.
turn to page 27. your lordship.
Another case fact, my lordship. Not relevant in this case, my lordship.
What way it prejudices them, my lord? Your lordship will find it at page
Suit for
27.
injunction is based on title or on possession?
Based on title, they claim.
Title and position.
Suit is in the primitive stage, my lord.
Whether the suit is
Suit is
based on-
evidence stage, my lordship.
whether suit
Evidence.
No, it is not over. It is in the stage of cross-examination. Because before filing the written statement, the chief examination was recorded. Subsequently, the issues were framed.
suit is based on title.
Please, my lord.
Ah.
Therefore, we have brought these true facts before the court through
What
this
are the true
amendment.
facts? What are the
True facts, my lord. Your lordship will find it at page 27, my lord.
Hmm.
May I read, my lord?
Hmm.
These defendants humbly submit that the true facts is that, in fact, a partition took place between Srimati Parvatamma, grandmother of the first defendant, her son, one Malegowda, father of the first defendant, and Chikka Hunnamma, mother of the first defendant, through an unregistered parikat dated 30/4/1967. As per the said Palupatti, the suit property measuring 1 acre 15 guntas in survey number 244/4 fell to the share of the father of the first defendant. That the first defendant's father by name Malegowda had 2 wives by name Chikka Hunnamma, first wife of first defendant's mother, and Madamma alias Manakamma, second wife. That after the said partition, first defendant father left the village with his 2 second wives and continued to live at Madihundi village. While they were so leaving the village, the first defendant's father and his second wife have sold land bearing survey number 244/4 measuring 1 acre 15
Yes,
hectares.
Why can't they be permitted to plead all these facts?
Lordship, ಇದರಲ್ಲಿ 224/14 ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ನಾವಾಗೆ 224/5 my lordship.
ಯಾವುದು?
ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ,
Matter of
ಇದರಲ್ಲಿ
evidence.
ಇವ್ರ ಫ್ಯಾಮಿಲಿದು ಜಮೀನ್ ತಂದ್ಬಿಟ್ಟು ನಮ್ಮ ಫ್ಯಾಮಿಲಿಗೆ ಸೇರಿಸ್ತಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಅಲ್ಲಪ್ಪ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ 244/5.
ಎಸ್ my lordship.
ಇವ್ರು ಕ್ಲೈಮ್ ಮಾಡ್ತಿರೋದೇನು?
ಇವ್ರು ಕ್ಲೈಮ್ ಮಾಡಿ 224/4 my lordship. ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ತಾ ಇರೋದು ಅದನ್ನ.
Please come to page number 28. ಓದಿ. As per the said Palupatti, suit property measuring 1 acre 15 guntas in survey 244/4.
Fell to the share of the father of the first defendant.
/4 ಅಂತಿದೆ, /5 ಅಂತಿದೆ.
That the first defendant father by name Malegowda had 2 wives by name Chikka Hunnamma and Madamma alias Manikamma. That after the said partition, the first defendant father left the village with his second wife and continued to live at Mandihundi village. While they were so leaving the village, the first defendant's father and his second wife have sold land measuring land bearing survey number 244/1 measuring 1 acre 15 guntas, which is the subject matter of the suit in favor of one Basavegowda of Doddahundi village through registered said deed dated 31/68. Thereafter, the said Basavegowda has sold the same in favor of the first defendant's mother for valuable consideration through registered said deed dated 4/5/1974. Thereby put her in possession and enjoyment of the same as its absolute owner. Thus,
ಮತ್ತೆ ಬಸವೇಗೌಡರದು ಇದು ಓನರ್ಶಿಪ್ ಅಂತ ಇಬ್ರು ಒಪ್ಕೋತಿರಲ್ಲ.
ಸೊ ಇದರಲ್ಲಿ 32 ಗುಂಟೆ ಒಬ್ಬರಿಗೆ ಬರುತ್ತೆ, 23 ಗುಂಟೆ ಒಬ್ಬರಿಗೆ ಬರುತ್ತೆ.
ಆಯ್ತಪ್ಪ, ಅವ್ರು ಹೇಳೋದು ಅವ್ರ ತಾಯಿಗೆ 1 ಎಕರೆ 32 ಗುಂಟೆನೂ ಬಸವೇಗೌಡರು ಮಾರಾಟ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ 32 ಗುಂಟೆ ಇವ್ರು ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇವ್ರು ತಗೊಂಡು ಇವ್ರ ಹೆಸರಿಗೆ ಖಾತೆ ಆಲ್ರೆಡಿ ಬರ್ತಿದೆ ಸ್ವಾಮಿ.
ತಾರೀಕಿಗೆ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು 28/9/74 ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು.
ಎಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡೋದು ಯಾವಾಗ್ರಿ? 4/5/74. ಮತ್ತೆ why do you say it's not relevant? Huh? Why do you say it is not relevant? ಬರ್ಕೊಳ್ಳಿ. ಎಷ್ಟು ಕಾಸ್ಟ್ ಹೇಳಿ? ಕಾಸ್ಟ್
ಇಮಿಡಿಯೇಟ್ಲಿ ನಾವು ಫೈಲ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. ಕೋರ್ಟಲ್ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ
ಕಾಸ್ಟ್ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ. ಕಾಸ್ಟ್ ಎಷ್ಟು ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ. ಕಾಸ್ಟ್ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ. It has to be visited with cost. Any attempt to delay the suit has to be visited with cost.
nominal cost may be imposed.
Yes, ಬರ್ಕೊಳ್ಳಿ. Now that you have given me the liberty to decide what is nominal, I will decide. The defendants in OS number 1735 of 2014 on the file of so-and-so court have filed this petition challenging an order dated so-and-so by which an application filed by them under Order 6 Rule 17 of CPC was rejected. Next para. The suit in OS number 1735 of 2014 was filed for perpetual injunction in respect of a land bearing survey number 244/5 of Ayyarahalli, Varuna Hobli, Mysore Taluk, measuring 32 guntas. Full stop. In short, the facts were that the plaintiff, in short, the facts as pleaded in the plaint were that the suit property belonged to one Basavegowda and that he sold it to the plaintiff on 28/9/1974. Consequent to which, the name of the plaintiff was entered in the revenue records and that he was in possession of the suit property. Full stop. The defendant contested the suit and filed a written statement contending inter-alia that ನೀವು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಸೇಲ್ ಡೀಡ್ ಬಗ್ಗೆ ಹೇಳಿದಿರಲ್ಲ, contending inter-alia that the suit property
Para 2 we have stated,
contending
page 23.
You have given some date, isn't it?
20, yes.
Contending that they owned lands adjacent to the land of the plaintiffs and taking undue advantage of the said fact, the plaintiffs had illegally got their names entered in the revenue records and attempted to dispossess them. Full stop. Later, when the suit was set down for evidence,
It was set down for immediately after framing of, because at the earliest point
when
of
the
time.
suit
before
was set down
filing-
for evidence of the plaintiff,
Please.
the defendants, defendant number 1 filed an application under Order 6 Rule 17 to incorporate a set of facts wherein it was inter-alia contended that the mother of the defendants had purchased the suit property from Basavegowda in terms of a sale deed dated 4/5/1974. And that another suit in OS number 65 of 2023 was filed in respect of survey number 244/4. Full stop. The trial court, this application was opposed by the plaintiffs on the ground that the same was filed after issues were framed and and the case was set down for evidence. And that no reason was mentioned as to why the said application was not filed at the earliest point in time. Next, the trial court in terms of the impugned order, rejected the application on the ground that the that the defendants had kept quiet from the year 2014 and had filed the application after nearly 9 years. It held that the reason assigned for the delay in seeking for the amendment was not satisfactory. Being agreed with the said order, the defendants are before this court. Next, the learned counsel for the defendants contended that the suit for injunction was based on the title. So suit for injunction was based on title, and therefore the defendant was entitled to place on record the fact that the defendants had a better title than the plaintiff. He submits that due to reasons beyond the control of the defendants, the facts could not be placed when the written statement was initially filed. However, it was contended in the written statement that the plaintiffs had illegally got their names entered in respect of the suit property which belonged to the defendants. He therefore contends that the application for amendment was only to amplify the pleadings, which did not in any way prejudice the defendant, prejudice the plaintiffs. He therefore prays that the impugned order passed by the trial court be set aside and the application for amendment be taken on record. Learned counsel for the plaintiffs, on the other hand, contended that the application is highly belated, and no reason is mentioned in the affidavit accompanying the application justifying the delay. Next para. I have considered submissions of the learned counsel for the plaintiffs and the learned counsel for the defendants. I have also perused the plaint, the written statement as well as the application for amendment. Next para. As rightly contended by the learned counsel for the plaintiffs, the suit, contended with learned counsel for the defendants, the suit for perpetual injunction was based on title, based on a sale deed executed by one Mr. Basvegowda. The defendants disputed the claim of the plaintiff and claimed that they were the owners of the suit property. However, they did not set out in detail as to how they claimed ownership over the suit property. Ideally, the defendants must have pleaded their title to the suit property when they filed the written statement. Full stop. The reason for not filing the not pleading these facts at the earliest point in time is not justified. Is not justified. Nonetheless, since the defendants have only attempted to place on record the manner in which they derived title to the suit property and also particulars of another suit filed, the trial court must have considered the same, as it did not prejudice the defendants in any manner. However, the delay in filing the application would have been suitably visited with costs so as to ensure that the defendant does not indulge in similar such delaying tactics. In that view of the matter, this writ petition is allowed. The impugned order passed by the trial court is set aside. The application filed by the plaintiff defendants to amend the written statement is allowed, subject to payment of cost of rupees 10,000 payable to the plaintiffs on the next date of hearing. Yes. It is open for the since the suit is filed in the year 2014, the trial court is requested to dispose of the suit as early as possible, at any rate within a period of 6 months from the date of conclusion of evidence of the parties. Yes.
Serial number 26. Pradeep Naik.
First respondents counsel. 5,000 and ಸ್ವಲ್ಪ.
Sorry, you gave me the liberty. Yes, next.
Only question here is.
Petitioners, Manoj. The question of the impugned order is an order passed by the trial court. directing that the plaintiffs should pay a court fee on the basis of cancellation of a deed, whereas the prayer that has been sought in the suit is one of declaration.
Yes.
If I, just the simple fact.
What is this petition filed against?
The writ petition is filed against the impugned order, which my lords will find.
Obviously against the impugned order only, but. what
Page
is the
7, my
58.
lords, page 57.
Page 58.
Page 57. The suit is one for declaration, my lords, to declare that two deeds, two documents are void ab initio.
Yes, please.
The Honorable Trial Court Judge has instead directed that the court fee ought to be paid under the provision for cancellation or under section 38(1), if I may read, my lords, page 58. Office has raised objection stating that the court fee has to pay under section 38 of Karnataka Court Fee and Suit Valuation Act. Peruse the records, the suit is filed for declaration and mandatory permanent injunction. The plaintiff sought relief.
Are you a party to this hypothecation?
I am a party, my lords. However, my lords, there's a subtle distinction here. If I may just state the facts, my lords, the facts are fairly straightforward. The plaintiff here is the landowner. The plaintiff entered into a JDA with respondent number 3, who is a group company of 1-3 group of developers, to develop a certain plot of land. In fact, the plaintiff is a company under ISKCON, my lords, the charitable trust, to develop a Krishna Leela Park and certain residential towers. Subsequent to this, in 2018, the developer indicated that they needed more money for development of the project. In fact, they informed the landowner about a week before the events that occurred and said that they are taking a loan from respondent number 1 of 650 crores, and that to secure that loan, they needed the hypothecation of the receivables from the landowner as also the land, the memorandum of title deeds. These are the two documents that are in question. Subsequent to that, my lords, audit was conducted by PwC. It was discovered that the very loan, the basis of that loan itself was fraudulent. And in fact, respondent number 1, which is Piramal, was involved in perpetuating that fraud. Money under the loan was diverted. Piramal knew about it. That the loan was initially projected to be loan for the sake of constructing the development. What was projected to the landowner was that if this money does not come in, we cannot complete the project. Many buyers were already there. There was already litigation. In fact, it was a religious part of the development was a religious thing, a Krishna Leela theme park. Therefore, the landowner agreed to mortgage their assets for the purposes of loan taken by the developer in order to complete the development. But subsequently, when an audit was done, it was realized that all of the money had been
Anyway, this one
siphoned off.
limited
Therefore, my lords.
question whether the
Indeed,
hypothecation deed falls within section 38.
Indeed, my lord. The reason these facts are relevant are because there's a trail of judgments, I'll place it before my lords, that when the relief sought is for declaration of a document to be void ab initio because of fraud and not just voidable, then the relief that ought to be claimed is of declaration. You do not need to ask for cancellation. Accordingly, court fees of cancellation need not be paid. That's the first limb of my argument. I'll place those judgments. The second limb of the argument is that even if this court were to consider that the plaintiff ought to have asked for a consequential relief of cancellation of the document, it is not something that can go to at the stage of court fee. It must read the plaint. It must see what relief the plaintiff has asked for.
Where is the plaint?
The plaint, my lords, is in volume 3. It has been annexed at the end, page 733. In fact, the hypothecation and the memorandum of title, it's not limited to my security. I'm one of the securities in it.
But this so many documents are really not necessary. Why did you produce so many documents?
My lords, they filed
Take
all
it.
of the
The
documents. in
plaint
the
and it
plaint.
appears they filed after the office objection complaints.
Correct, but we are not doing any weightlifting here.
My lords,
Therefore, don't force us to do it.
please, my lords. The documents.
Where is
So
the, where is the,
Valuation slip ಹಾಕ್ಬೇಕಾಯ್ತು ಅದನ್ನ ಹಾಕಿಲ್ಲ.
where is the relief sought?
Prayers, my lord, page
53,
52,
page 7.
internal page 52.
Letter argument.
I'm sorry.
Page 783, my lords, are the prayers.
Where is the relief sought for?
The relief sought for is in page 783. Declare that the deed of hypothecation dated 5/6/2018, executed by plaintiffs number 1 to 4 in favor of defendant number 2 is null and void, not binding on the plaintiffs and not enforceable against the plaintiffs. There are two securities given both under the deed of hypothecation and the memorandum of deposit of title. Declare that the memorandum of title of deposit of title deeds dated 5/6/2018, executed by plaintiffs number 1 to 4 in favor of defendant number 2 is null and void and not binding on the plaintiffs and not enforceable against the plaintiffs. These are the contested prayers, my lord.
Yes.
Therefore, my lords, my argument at the first instance is that when I'm seeking that it be set aside void ab initio, because the nature of the very document is challenged. I did not agree to give my security for a document.
No, you are a party to this document.
Party to this document. Indeed, my lord.
So you can
Just
only
make
avoid
the
it,
judgment.
you can only avoid, it becomes voidable at your option.
In fact, my lords, if
How
I
can
may
you say
place
it
the
is null and void?
judgments, if I may place the judgments on. Courts, my lords, have made a distinction between documents that are sought to be considered void on the basis of the contents of the document, because they're alleging fraud as to the contents of the document, versus fraud that is alleged as to the very nature of the document. Whether I am entitled to that relief, whether they'll hold that the fraud is at the nature of the document, whether they'll hold that the lender himself was involved in the fraud, that is to be seen on maintainability.
Yes.
Please, my lords, judgment number 1, if I may go to paragraphs 4 and 5 at page 4, my lords, if I may read paragraph 5. The legal position will be different if there is a fraudulent misrepresentation, not merely as to the contents of the document, but as to its character. The authorities make a clear distinction between fraudulent misrepresentation as to the character of the document and fraudulent misrepresentation as to the contents thereof. With reference to the former, it has been held that the transaction is void, while in the case of the latter, it is merely voidable. In Foster versus McKinnon, the action was by the endorsee of a bill of exchange. The defendant pleaded that he endorsed the bill on a fraudulent representation by the acceptor that he was signing a guarantee. In holding that such a plea is
So
admissible.
where do you fall? Is it misrepresentation as to the character of the document?
Character of the document is my allegation, because
Where
I
are we-
was told, my lords, that the loan is for construction, 650 crores.
What does the document say?
The
What
The-
is
the documents for security.
The plain governments may be something
Please,
else.
please.
Plain governments could be something.
The documents are
What
straightforward.
does the document say?
The document is for security. The loan, my lords is aware that the security, the consideration is the main loan.
Yes.
The loan agreement merely says, in fact, I've also indicated, I have drawn out a chart of all the fraudulent transactions under the loan. The money did not go to the account it was designated for. The money did not go to pay the persons it was designated for. In fact, the money was paid to group companies of respondent 1, unsecured loans. Why, my lords, any reasonable man will give security of property to clear other unsecured loans?
Madam, that is on merits of the case.
Indeed, my lords. That's
Now, you
exactly.
please only tell us, where do you fit in? Is it the character of the document you misled? Character of the document?
Character of the
Where
document.
have you said that? Where have you said that in the
Please,
plaint?
my lords. In the plaint, my lords.
So you are aware of the contents.
I'm aware of the content.
You are aware of the contents.
I am aware of the contents. It was expected to be used for
Where have you said that the character of the documents was not known to you?
Page 762.
Page?
762, my lords.
Please tell me the internal page number.
Internal-
Page nation illa. Just please tell me the internal.
Paragraph number 50.
Paragraph number.
Paragraph 46.
Thank you.
46, yes.
Where I've alleged that it was a lender who was fraudulent. The plaintiffs further submit that defendant number 1 lender has not only actively connived with defendant number 3 borrower developer, but also has been perpetrator of the fraud by facilitating the diversion of funds by defendant number 2 in disbursing loan amount to other bank accounts of defendant number 1 and or defendant number 3 borrower developer or to parties which find no mention anywhere in the escrow agreement. So I've said what was represented to me in the loan.
After the execution.
Correct.
In fact, the allegation, subsequent facts also have brought on record by way of an amendment.
As on the date of entering into this agreement,
Please.
were you induced to execute this agreement fraudulently?
That is what I have alleged, because I have said that I have laid out the facts and I have said that this fraud could only have been done from the initial stages, because my allegation is that the loan amount was diverted to group companies of the lender. Therefore, I have said, I may not have said it in exactly those words as character of document. But my allegations, even in para 59, if my lords were to see. page
Anyway, you read
763,
46 for your satisfaction.
Please.
46 is the paragraph where you mentioned, isn't it?
Please, my lords.
Please read.
The plaintiffs further submit that defendant number 1 lender has not only actively connived with defendant number 3 borrower developer, but also has been a perpetrator of the fraud by facilitating the diversion of funds by defendant number 2 in dispersing loan amount to other bank accounts of defendant number 1 and or defendant number 3 borrower developer or to the parties which find no mention anywhere in the escrow agreement. Such diversion of funds from the project escrow account has been fraudulently done instead of transferring the funds to operating account maintained with the HDFC Bank Richmond branch, Bangalore, for the project in terms of the escrow arrangement, from where the funds should have been used for completion of the project. Thereafter, I talk about the various transactions, my lord. But my allegations are that when this loan, I was informed 1 week before, if my lord should read the whole plate. The very reason for this loan was that to use to pay defendant number 1. Therefore, from the get-go, I was in fact, another email I may show, my lord, which the basis of why I entered into this transaction is found in an email where it was projected to me what the revenue from the project would be. It is at page 155 in volume number 1. These, my lords, they had in fact represented to me, both the lender and the developer, that the money will be used for development of the building, subsequent to which the realizable revenue from it will be 1,000.
You have valued the suit under 24D.
Value the suit under 24D, my lords, for declaratory relief. That the value of the stock is 1,657 crores.
Yet there be an issue regarding valuations.
I'm sorry.
There be an issue regarding valuation. Why
But
should
can
we-
I just point out 2 other aspects?
My lords, one more thing I just want to point out. It's not in case, just on the issue of 38 itself, that even otherwise, if just so that for the sake of completeness, even if this court were to find that in fact it is 38, the hypothecation and the memorandum of title deeds is to the extent of 30% of the receivables, which is not yet valued. Those receivables have not come, they're not completed the construction, they're not sold all the units. There is a second security as well of a second land. What the Honorable Trial Court has said is the value of the loan is 650 crores. Therefore, you value it at 650 crores. In fact, what section 38 says is that even if, just in an arguendo argument, even if it were found that it's under 38, it is the value of the relief that you're seeking. The value of the relief to that extent is significantly smaller because my 30% of the receivables is nowhere close to 650 crores and I'm only part of the security. Therefore, even to that extent, this order does not stand. Whatever the conclusion of this court is, I just wanted, because that is a slightly secondary argument to that, then my lords will.
No, but then this issue will have to be gone into.
My lords, there are some.
Yes.
3, 4 very short crisp points. Point number 1, if your lordships have the plaint, please be kind enough to take the plaint internal page 10. I'm sorry, my lord, I don't have the continuous page number of the plaint. It appears to have been filed after the Wakalatnama. They extract in the plaint from the agreement. So for my learned friend today to argue is contrary to the plaint. Volume 3 alli adeno hedidru. Begins at 733 or so. You have an extra copy? Please.
No, this is not the one. Volume 3.
Volume 3 alli 733 it begins, plaint alli internal page 10, where they extract it. Paragraph 15 begins at internal page 9. Adralli page 10 dayaviಟ್ಟು ತಗೊಳ್ಳಿ. This is an extraction from the document.
Paragraph number 10 is it?
10 alli, I'm sorry, page number 10, my lord. Paragraph 15. Paragraph 15 begins at page 9, internal page 9. Adralli dayaviಟ್ಟು page 10 ಗೆ ಬನ್ನಿ. Under that 14.1 utilization of the loan and ಕೆಳಗಡೆ there is a table. Tranche 1 from out of the 650 crores. Tranche 1, please see the right hand side column. B, an amount of 100 crores for lending to the landowner. So they were to benefit from the document. Today for her to say that the whole thing is void ab initio does not stand to reason. And this Ningava's judgment stands on the footing of a lady who was virtually duped into entering into an agreement because she was not literate or so. That cannot be equated with this case where she was to get the benefit under the document. So the second point that I wanted to place is that under the hypothecation agreement, page 454, they are a party to that document 10 lakh rupees of stamp is paid, they gain benefit under that document too because of what I just pointed out to your lordship. So therefore that argument does not stand.
So 100 crores went to the landowner.
Yes, that is what the document would say. For her to today say, and your lordships would please see what has two other aspects which are important. Please now be kind enough to see the impugned order at page 58, which I showed your lordship at the beginning. What the petitioner has done, perhaps it's a transfer brief, so I'm not saying anything about any counsel. I don't want to also. Page 58. Now, I'll just show the impugned order. Something important in this. Office has raised an objection stating court fee has to pay under section 38. Peruse the record so and so. Please see page 59, second paragraph. Plain government discloses that plaintiff paid court fees of 300 and valuation slip discloses plaintiff has not made any valuation of the subject matter of the suit. Valuation slip is not filed in this writ petition. May I just pass it on, my lord, through the court master. How this should be treated another ಬಗ್ಗೆ ಹೇಳೇ ಇಲ್ಲ ಅವರು. That is the most crucial document as far as they are concerned that has not been placed at all. Basis the fact that they have not let in a valuation slip at all on this, the court would direct them to pay. That crucial fact has, my lord, not been brought to your lordship's notice.
Yes.
My lord, more importantly, there's a division bench judgment of our High Court. I'm sorry. Sorry.
File a fresh valuation slip.
That's the point.
Please, ma'am.
File a fresh
Without that,
valuation.
and my lord, one other subsequent fact.
File a fresh
They-
valuation slip and pay the court fee according to you,
Please, ma'am.
whatever you want to value. Then
My
you
lord, in this
consider-
judgment,
The order stands.
Ah,
paragraph 28, my lord, of this judgment. That would be at page 2700.
no, the impugned order is extremely innocuous. It doesn't say anything.
Quite right, my lord. That is my submission, that it is only saying that they've not offered valuation. And that's why I showed you a lot of the valuation slip. Clear, distinct and well-marked distinction between a suit for cancellation of a deed affecting certain property and a suit for declaration that a particular document is inoperative against a plaintiff. A suit for cancellation must be brought by a person who was a party to the deed or by a person who's otherwise bound by it in law, but a person who's neither a party nor bound by it need not sue for cancellation. So she's a party to it, therefore she has to sue for cancellation only, no option. Cancellation has to be valid under 38. This is, my lord, the second limb of my submission. Third is that now what they would try to do is to file an amendment. My learned friend did mention there's an amendment application pending before the trial court. I am told that it runs into almost 60 pages, be that as it may, whether that is permissible or not.
Crores, it should be run into.
Allah, there they would try to modify the relief to say void ab initio anta, which essentially, therefore, my position would be.
Therefore, I asked you the first question, whether you are a party to this document.
Correct, absolutely, my lord. That's why. This is the judgment that supports that contention. With that view of the in that view of the matter, my lord, my respectful submission is that without paying the court fee, they would not be able to
You
advance.
file a fresh valuation.
That
slip.
is my submission.
And you also let the court decide what the
My
valuation.
only submission is the court says that it should be under 38, which is what I have a difficulty with. Because my lords have placed on record about 6 judgments which state that when you say void ab initio,
Yes.
like my learned friend said, whether I'm entitled to it. In fact, that 100 crores was paid to me for overdue amounts, not as a loan. All of that I have challenged. I have said that what was represented to me was not what was done. Therefore, the nature of the document was misrepresented. Otherwise, why would I give a security? I have
Because you are
my
getting
land
benefit
and
under it.
receivables. Therefore, my lord,
This is still at the stage of
Indeed.
section 11.
please, my lords.
Still at the stage of section 11.
Therefore, my lords, my humble submission, in fact, the courts have held that whether it is maintainable, whether you ought to have sought for cancellation, whether you can get the relief you pleaded for, it is a matter, that is a risk I take as the plaintiff. It is a matter of maintainability. The question that this court is concerned with, is your relief one of declaration? Have you paid the court fees for declaration? That is it. That is my humble submission, my lord. Whether it's maintainable, whether I've got relief under it, whether in fact it's void ab initio is of no concern.
Yes.
The courts have arrived at a conclusion that if your case, rightly, wrongly, is that it is void ab initio, that you were misrepresented at the outset that this document seeks to achieve X purpose, but actually you realize later that it sought to achieve Y purpose. In fact, all of these judgments, my lords, are on sale deeds. They were parties to those documents. None of these judgments concern third parties. And what my learned friend said about illiterate person cannot be equated. This is also something the courts have gone into in the second judgment, where they say that now it has been extended. Earlier, the jurisprudence started with illiterate persons who did not know the law.
Court fee act.
If I may take page 15 of my compilation, the courts have said this has now been extended. Doctrine has been extended to cases other than those of illiteracy into other contracts and writing.
My submission is all that would arise only if a proper valuation slip is placed.
No, but was this examination at the stage of,
Before the hearing, in fact, at the very initial stage of having filed the plaint.
you come to section 11 first.
Please, my lords. Let me read.
Please read section 11.
Please, ma'am. In every suit instituted in any court, the court shall, before ordering the plaint to be registered, decide on the materials and allegations contained in the plaint and on the materials contained in the statement, if any filed under section 10, the proper fee payable thereon, the decision being however subject to review, further review and correction in the manner specified in the succeeding subsection. Number 2, any defendant may, by his written statement, file before the first hearing of the suit or before evidence is recorded. This is not relevant to the, they have filed a written statement, but we are already before this court, my lords, at 11:1. Or succeeding subsection, not later plead that the subject matter of the suit has not been properly valued or that the fee paid is not sufficient. All questions arising on such plea shall be heard and decided before evidence is recorded affecting such defendant on the merits of the claim. If the court decides that the subject matter of the suit has not been properly valued or that the fee paid is not sufficient, the court shall fix a date before which the plaint shall be amended in accordance with the court's decision, and the deficit fee shall be paid. If the plaint be not amended or if the deficit fee be not paid within the time allowed, the plaint shall be rejected and the court shall pass such order as it deems just regarding cost of the suit. A defendant added after issues have been framed on the merits may also similar rights have been extended to defendant added. My lords, would me continue to read?
Yes.
4A, whenever a case comes up before a court of appeal, it shall be lawful for the court either on its own motion or on the application of any of the parties to consider the correctness of any order passed by the lower court affecting the fee payable on the plaint or in any other proceeding in the lower court and determine the proper fee payable thereon. Explanation. A case shall be deemed to come before a court of appeal even if the appeal relates only to a part of the subject matter of the suit. If the Court of Appeal decides that the fee paid in the lower court is not sufficient, the court shall require the party liable to pay the deficit fee within such time as may be fixed by it. If the deficit fee is not paid within the time fixed, and the default is in respect of a relief which has been dismissed.
Now the defendant has raised a dispute regarding valuation in the
They
written
have not.
statement.
This happened prior to this writ petition, my lord, says prior to the defendant coming on record. Subsequent to them coming on record, they have filed.
So this is still at the 11:1 stage.
Still at 11:1 stage. In fact, my lords, interestingly, my lords may know under 11:3, the jurisprudence of this court is that the defendant's role in this is only to the extent of assisting the court in arriving at the right value. The defendant has no independent right to challenge. If an order is passed under 11:3, the defendant cannot file a challenge to that order.
Yes.
And in fact, my lords, they have filed an IA to vacate stay. I'm not going to go on whether they had the right to file a vacate stay in a matter as this or seek for stay of the suit, etc.
Yes.
But be that as it may, the limited extent they have, I will admit that subsequent to coming on record, they have raised this in their pleadings, but we are still at the stage of 11:1.
Yes.
In fact, in page 58, impugned order, my lord, court indicates there was an order for orders on court fee and the matter is reserved.
Because the registry had.
There was an office objection raised, so therefore very much it is at 11.
Again is under section
11:1
only.
11:1.
Only on 11.
And by then, before, as my learned friend said, before no summons are ordered, they'll one stay ತಗೊಂಡಿದ್ದಾರೆ on that
Where
order.
is the discussion? Where is the discussion about their case? Court simply says applies 38 months.
No, but there is a reason. Where valuation is, they have not indicated anything. They've not indicated
Let
it.
them file a fresh.
Yes,
valuation
that's all I
slip.
submitted.
Let
That's
the
what even I
court to
submitted.
consider whether it fits into section 38 or
Absolutely,
not.
absolutely. Let that be heard and decided.
My lords, my only submission to that extent is the court
Will
seems to
direct
have
the
come to a
trial
conclusion.
court, will direct the trial court to reconsider after you file a fresh.
Fresh valuations.
valuation slip.
That's
For this small thing, you have virtually moved an army.
My lords, there was some urgent relief sought
but I'm
Right, but-
because receivables are.
But
Hypothetical.
avoid filing these voluminous papers
Please.
for innocuous relief. Because these many papers means these many papers will have to be scrutinized
Indeed.
by the office. So much time is wasted. The plaintiffs in commercial voice 163 of 2020 on the file of so and so are before this court, challenging an order dated 2/3/24, by which the plaintiffs were directed to file a fresh valuation slip and pay the court fee. Next para. The suit in OS number so and so was filed for the following reliefs. Page number 980, sorry, 785. Red pencil mark. Stop. The registry of the trial court raised an objection that court fee of rupees 300 was paid and no valuation slip was filed. Meaning, full stop. The trial court therefore passed the impugned order holding that the petitioners had sought for cancellation of a hypothecation deed, which is referable to section 38 of the Karnataka Court Fees and Suits Violation Act 1958, and therefore called upon the plaintiffs to file a fresh valuation slip, and also pay the court fee. Full stop. Being agreed with the said order, the plaintiffs are before this court. Next para. The learned counsel for the plaintiffs vehemently contended that the plaintiffs are not sought for cancellation, but have merely sought for a declaration that the hypothecation deed and other documents are not binding upon them. He therefore contends that the trial court committed an error in requiring the plaintiffs to pay court fee under section 38 of the Karnataka Court Fees and Suits Violation Act. In support of her contentions, she has relied upon a bunch of judgments, reference to which is wholly unnecessary. Next para. The learned senior counsel for the respondents submit that the court has merely, that the trial court has
only for
merely-
R1.
For the respondent number 1. Submits that the court has merely directed the plaintiffs to file a valuation slip, though referring to section 38 of the Court Fee Act. He contends that the court can exercise jurisdiction to verify whether the relief sought for by the plaintiffs fall within section 38(1) or under section 24D only after a valuation slip is filed. Full stop. Anything else?
But yes, only that,
What about the others?
only that, also that 38, if the court feels that is to be recorded here.
That let the court
Please,
decide.
let the court
Why
decide.
should we preempt the?
Please.
No, my submission that the suit, there are some urgent interim relief sought in the
Stop.
suit. It may
Next
not
one.
be held up for this. I will file the necessary valuation can be decided
there are-
outside.
There are
Does not
applications
get
which is being
registered
filed.
Official of the impugned order shows that the trial court was taking note of the office objections raised by the office that that a valuation slip was not filed and the suit was for declaration.
Lords, it was filed. It's not clear in the valuation slip what
So
it
it
is.
says it was not filed.
It does not disclose anything.
Does not
I just
disclose-
passed on a copy, my lord, to your lordship.
What the,
Adರಲ್ಲಿ there is no reference to the prayers.
it's not proper.
It's a compilation, my lord.
Yes.
My
It is apart from the petition file.
The court says nothing, only 300 rupees is paid.
My lord, there is a
I think
valuation
this
slip
pass
which
was
is
just a
filed.
loose sheet, my lords.
The plaintiff has not made any valuation of the subject matter and only has arrived at the court fee of rupees 300.
My lords, that is the valuation slip that has been
Yes.
filed. It's just very unclear. that there are
ಏನ್
no
ಬರ್ದಿಲ್ಲ
details and
ಅದು.
no particular. It appears this is what was filed.
ಏನಾಯ್ತು ಮೇಡಮ್? By the registry, that the valuation slip filed did not conform to section 10 of the Karnataka Court Fees and Suits Valuation Act. And that only a nominal rupees 300 was paid on the plaint. So, the trial court therefore, while considering the objections, held that section 38 of the Act 1958 would apply for cancellation of a document, and hence called upon the plaintiffs to file a fresh valuation slip and also pay the court fee. Full stop. If the plaintiffs have not filed an appropriate valuation slip, comma, there is nothing wrong in the trial court directing the plaintiffs to file a fresh valuation slip and pay the court fee as calculated by the plaintiffs. Full stop. It is for the plaintiffs to establish before the court that the valuation made by them is proper and correct. And the court can exercise jurisdiction under section 11(1) of the Karnataka Court Fees and Suits Valuation Act 1958 to determine the proper duty payable. 11(1) or 11(2) to determine the proper stamp duty payable, so court fee payable, sorry. In that view of the matter, comma, without going into the correctness of the impugned order, it is appropriate to dispose of this writ petition, directing the plaintiffs to file a fresh valuation slip and also pay the court fee, which according to them is just, which according to them is proper. It is for the trial court to decide that the court fee so paid or the valuation so made is just and proper. Stop. It is also open for the, if it is not possible for the trial court to decide the question of valuation immediately, comma, it may consider framing an appropriate issue regarding the valuation of the suit as made by the plaintiffs and proceed in accordance with law.
Great.
Number 27, copy. Number 27.
Mr. Mukunda P.
Sir, map produce ಮಾಡಕ್ಕೆ.
Huh?
Sir, map produce ಮಾಡಕ್ಕೆ.
Learn consequences of taking advantage of block to enter into existence. Yes, very survey 4641 and 4640.
The survey sketch was ordered to be produced. It appears to be
The village map.
village.
This is the village map. Hissa survey ಇಲ್ಲಿ.
ಇದೆ, list ಇದೆ. List ಇದೆ, page number 4.
Then ಏನು ಗೊತ್ತಾ? But I have a
Pictorial representation.
pictorial representation, my lord, obtained in the Google map.
46 ಅಲ್ಲಿ ಹಿಸ್ಸಾ ಆಗಿದೆಯಲ್ಲ. So there are two compact blocks.
Two compact blocks, my lord.
ನಿಮ್ದು ಯಾವುದು? What is your survey number?
46/1, man.
46/1.
In fact, for 46/2, there is a direct approach. The road, my lord, directly leads to 46/2. On the last day, submission was made. I was blocking the way. In fact, I have produced Google map, my lord. In fact, a crossroad has a direct approach to his land. In fact, I have to.
ಕೊಡಿ.
Sorry. If your lordship sees that L shape, this thing is the fencing. And the abutting land is
So L
46/2.
shape is 46/1.
46/1. And 46/2. And if your lordship sees that road, my lord, on the right side, that black, this thing, representation, it's a road which directly leads to 46/2. That is his land. There's no question of me blocking his way. In fact, to reach, one nimsha, sir. In fact, to reach my land, my lord, I have to go through his land.
An ancestral property though.
And 46/2 and 46/1, ಎರಡಕ್ಕೂ partition suit ಹಾಕಿದ್ದಾರೆ.
This black thing that you have shown in the map, is it a asphalted road or?
No.
Asphalted road, ಕಾಲ್ದಾರಿ. So the representation,
ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಕಾಲ್ದಾರಿ ಬಂದು ಇಲ್ಲಿಂದ ಬರುತ್ತೆ ಸ್ವಾಮಿ, ರೆಡ್ ಲೈನ್ ಅಲ್ಲಿ ಇದೆ, 2 ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಪಾಸ್ ಆಗುತ್ತೆ.
ಎಲ್ಲಿದೆ ಇದು ಸರ್ವೆ ಇದ್ರಲ್ಲಿ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
46 ಮೇಲೆ ಕ್ರಾಸ್ ಆಗಿ 46 ಒಂದ್ ಮೇಲೆ ಕ್ರಾಸ್ ಆಗಿ 42 ಹೋಗುತ್ತೆ. ಅದು ಕಾಲ್ದಾರಿ ಅದು.
46 ಎಲ್ಲಿದೆ ಇಷ್ಟು ದೊಡ್ಡ ಮ್ಯಾಪ್ ಅಲ್ಲಿ?
ಲಾಸ್ಟ್ ಕಲರಿಂಗ್ ಮಾಡಿ
ಇಲ್ಲಿದೆ ಕೊಡಿ.
ಇಲ್ಲಿ ರೋಡ್ ಇಲ್ಲಿ.
ಬಾಟಮ್ ಲಾಸ್ಟ್ ಬಾಟಮ್
41, 42
ಲಾಸ್ಟ್ ಬಾಟಮ್ ಇನ್ ರೈಟ್ ಸೈಡ್ ಮಾಡಿ.
No way.
47 and 46.
There's some road alla, some footpath.
This is the only road, my lord, in the pictorial
In the
representation. what I have-
village map, there appears some foot track.
Food track ಅದೇ.
ಕಾಲ್ದಾರಿ.
But
ದಾರಿ.
we are not blocking any way, my lord. The client, my lord, I spoken to the client today also. We are not blocking any way. Now, to reach.
ನಿಮ್ಗೆ ದಾರಿ ಇಲ್ವೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಪಾಯಿಂಟ್ ಮಾಡಿದೀನಿ ಕಮಿಷನರ್.
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಇದು 47 ನಮ್ದೇ ಪ್ರಾಪರ್ಟಿ, ಅದು ಅದರ್ ಟ್ರೆಡಿಷನ್ ಪ್ರಾಪರ್ಟಿ.
ಯಾವ್ದು?
47 ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ ಮಲಾಡ್ಸಿ.
ಆಯ್ತು, ನಿಮ್ ಜಮೀನ್ ದಾರಿ ಇಲ್ವಾ?
ದಾರಿ ಇಲ್ಲ, ಕಾಲ್ದಾರಿ ಇದೆ, ಹೋಗ್ಬೇಕು. ಲೈನ್ ಏನಿದೆ ಇದ್ರಲ್ಲಿ?
ಲೈನ್ 1909 ಇಸ್ವಿ ಮಾಡಿರೋದು ಇದು. ಇವಾಗ ಹೇಳಿ.
ಇಲ್ಲ, ಇದು ನಂಗೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಅಟ್ಯಾಚ್ ಆಗಿರೋದು ಪ್ರಾಪರ್ಟಿ ನಿಮಗೆ. ಪಾರ್ಟ್ 1 ಮತ್ತು ಪಾರ್ಟ್ 2.
1911 ಇಸ್ವಿ ಮ್ಯಾಪ್ ಇದು. 11 ಇಸ್ವಿದ್ ಹಂಗೆ ಇರ್ತದ ಮ್ಯಾಪ್ ಅದು.
ಅಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಇದು 47 ನಿಮ್ಗೆ ಹೋಗಿ ಕ್ರಾಸಿಂಗ್ ಆದ್ರೂ ಬೇಕಲ್ಲ.
Latest this thing, my lord. Google Maps.
ಹೇಳಿ, whoever, if you dispute, we'll have to appoint a commissioner.
ಶೂಟ್ ಪೆಂಡಿಂಗ್ ಇರ್ಬೇಕಾ? ಸಿ ಆಲ್ಸೋ ಅಡ್ಮಿಟೆಡ್ ಇನ್
Dispute is.
ನೋಡಿ, ಇವಾಗ ದಾರಿ ಇಲ್ಲ ಅಂತ ನೀವ್ ಹೇಳ್ತಿದ್ರಿ.
ಮಾಡಿ.
We'll appoint a commissioner at your cost. If the commissioner comes and says there's a dari, then you will have to pay the entire
In fact, my
expense.
lord, the charge sheet is filed by the police, my lord.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಬ್ರು ಡಿಸೈಡ್ ಅರ್ಧ ಕೊಡ್ಬೇಕು. ದಾರಿ ಇದ್ರೆ ಇಬ್ರು ಅರ್ಧ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಕಮಿಷನರ್ ಫೀ.
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ನೋಡಿ ಎಲ್ಲಿದೆ, ಇಲ್ಲಿ ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಜಾಗ ಇದೆ, ಇಲ್ಲಿಂದ ನಮ್ಗೆ ಎಂಟ್ರೆನ್ಸ್ ಆಗ್ತಾರ ನಮ್ಗೆ. ನಮ್ಮ ಹೇಳಿದ ಕ್ಲೈಂಟ್ ಎಲ್ಲ ಪ್ರಕಾರ.
We do not know. 46/1 ಹಿಸ್ಸಾ ಸರ್ವೆ ನಲ್ಲಿ ದಾರಿ ಕಾಣ್ತಾ ಇಲ್ಲ. ಹಿಸ್ಸಾ ಸರ್ವೆ ನಂಬರ್ ದಾರಿ ಕಾಣ್ತಾ ಇಲ್ಲ, ಕಾಲ್ದಾರಿನೂ ಇಲ್ಲ ಹಿಸ್ಸಾ ಒಳಗೆ. So therefore, if your pathway is blocked, and if you don't have any other way.
After this honorable court granted entry ಮಾಡ ಅವ್ರ ಪೆನ್ಸ್ ಮಾಡಿ.
ಆಯ್ತಪ್ಪ, ನಾನು ಅದೇ ಹೇಳ್ತಿರೋದು. ನಿಮಗೆ ದಾರಿ ಇದ್ರೆ ಅವ್ರು ದುಡ್ಡು ಕೊಡ್ಬೇಕು. ಇಬ್ರು ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಡು
ಆಗ್ಬೋದು ಮಲ್ಲ. ಅದಾದ್ರು ಅವ್ರು ಹೇಳ್ತಾರೆ
ದಾರಿ ಇದ್ರೆ ನೀವು ಕೊಡ್ಬೇಕು ಫುಲ್ಲು. ದಾರಿ ಇದ್ರೆ ಕಮಿಷನರ್ ಫೀಸ್ ನೀವು ಕೊಡ್ಬೇಕು. ದಾರಿ ಇಲ್ಲ ಅಂದ್ರೆ ಇಬ್ರು ಕೊಡ್ಬೇಕು. ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಡು.
ದಾರಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಹೆಂಗ್ ಕೊಡಕ್ ಬರ್ತೀನಿ? ದಾರಿ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ನಾನು
ದಾರಿ ಇಲ್ಲ ಅಂದ್ರೆ ವಿ ಕ್ಯಾನ್ ಪಾಸ್ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಆರ್ಡರ್ಸ್ ಇನ್ ದಿಸ್
ಕಮಿಷನ್ ಫೀಸ್ ನಾನು ಕಳ್ಕೊಂಡ್ಬಿಡ. ಅಲ್ಲ, ಅವ್ರು ಆಫ್ಟರ್ ಎಂಟ್ರಿ ಮಾಡೋ ಪೆನ್ಸ್ ಹಾಕಿ ಬ್ಲಾಕ್ ಮಾಡಿ ನನ್ಗೆ ಆಕ್ಸೆಸ್ ಮಾಡಕ್ಕೆ ಇಲ್ಲ.
ಅದಕ್ಕೆ ಹೇಳಿ, ಅವ್ರ ಪ್ರಕಾರ ದಾರಿ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ. ದಾರಿ ಇದ್ರೆ ನೀವು ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಕಮಿಷನರ್ಗೆ. ದಾರಿ ಇದ್ರೆ ಅಕಾರ್ಡಿಂಗ್ ಅವ್ರು ಹೇಳ್ದಂಗೆ ದಾರಿ ಇದ್ರೆ ನೀವು ಕಮಿಷನರ್ ಫೀಸ್ ಎಂಟೈರ್ ನೀವೇ ಬೇರ್ ಮಾಡ್ಬೇಕು. ದಾರಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ವಿಲ್ ಆಸ್ಕ್ ಹಿಮ್ ಟು ಬೇರ್.
ಆಗ್ಬೋದು.
ಎಷ್ಟು ಹೇಳಿ, ನೀವೇ ಹೇಳಿ.
ಅಲ್ಲ, he has to pay because if there is a road, he has to pay.
ಆಯ್ತು, ಎಷ್ಟು ಹೇಳಿ, ನೀವ್ ಹೇಳಿ. ಎಲ್ಲಿರೋದು ಪ್ರಾಪರ್ಟಿ ಇದು?
ಕುಣಿಗಲ್ ತಾಲೂಕು.
ಎನಿ ಅಡ್ವೊಕೇಟ್ ಫ್ರಮ್ ಕುಣಿಗಲ್? ಯಾರು ಯಾರು ಲಾಯರ್ಸ್ ಹೇಳಿ, ಯಾರಾದ್ರು ಇದ್ರೆ.
ವೈಲೇಟೆಡ್ ದಿಸ್ ಆರ್ಡರ್ ಕೊಟ್ಟು ಆರ್ಡರ್ ಮಾಡಿ. ಆರ್ಡರ್ ಇರ್ಬೇಕಾದ್ರೆ ನಾನು ಪೆನ್ಸ್ ಹಾಕ್ಬಿಟ್ಟು ಈಗ ದಾರಿ ಇದೆ ಅಂತ ಹೇಳಿ.
ಯಾರು ಅಡ್ವೊಕೇಟ್ ಯಾರು ಬರ್ತಾನೆ ಇಲ್ಲ ಮುಂದಕ್ಕೆ. The one standing at the door, ಅಲ್ಲಿ ನೀವೇ the bearded one. Can you go as a commissioner? Will not be able to go. Is anybody? ಹೋಗ್ತೀರಾ? ಎಷ್ಟು ಹೇಳಿ.
Lordship may fix. The lordship may fix.
50,000 ರೂಪಾಯಿ.
ಆಗ್ಲಿ.
50,000 ರೂಪಾಯಿ ನಾನು ಕಳ್ಸೋದಿಲ್ಲ. 50,000 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು.
ಅಷ್ಟು ಅಗ್ರಿಕಲ್ಚರ್ ಇಷ್ಟ, 50,000 ಕಷ್ಟ ಆಗತ್ತೆ.
ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ?
10,000.
10,000 ಗ್ಯಾರಂಟಿ ಮಾಡ್ತಾರೆ. ಒಂದ್ ದಿನದ ಕೆಲಸ ಒಂದ್ ದಿನದ ಕೆಲಸ ಹೋಗ್ ಬರ್ಬೇಕಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರೆ ಪೆನ್ಸ್ ಆಗ್ಬಿಟ್ಟು ನನ್ಗೆ ಇವಾಗ ನಾನ್ ಕಮಿಷನ್ ಅಪಾಯಿಂಟ್
ಆಯ್ತಪ್ಪ.
ಮಾಡ್ಕೊಂಡು ನಾನು ಮಾಡಿ
ಹೋಗೋದು ಬರೋದು ನಿಮ್ ಖರ್ಚು. ಕರ್ಕೊಂಡ್ ಹೋಗ್ಬೇಕು, ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಕಾರಲ್ಲಿ. ಊಟ ತಿಂಡಿ ಕೊಡಿಸ್ಬೇಕು ಕಮಿಷನರ್ಗೆ. ಅದ್ರ ಮೇಲೆ 25,000 ಕೊಡಿ, ಆಗ್ಬೋದಾ?
25 ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಮಿಲಾಡ್ ಸರ್.
ನೋಡ್
ನಮ್ ಕ್ಲೈಂಟ್ ಅಂತ ಕನ್ಫರ್ಮ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಸರ್.
ಅವತ್ತಿಂದ ಅದೇ ಹೇಳ್ತಿದ್ರಲ್ರಿ, ಅವತ್ತು 50,000 ಯಾರ ಕಮಿಷನ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಪಾಪ ಅವ್ರು ಬಂದು ಮುಂದೆ ನಿಂತ್ಕೊಂಡ್ರು.
ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳಿದ್ದು, ನಾವಿರ್ಲಿಲ್ಲ, ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ.
ಇವಾಗ ಆಯ್ತಲ್ಲ, ಬಂದಿದಲ್ಲ ಕಮಿಷನರ್.
ಅಲ್ಲ ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳಿ ನಾನು ಇವಾಗ ನನ್ಗೆ ಇವಾಗ ಇದು ಮಾಡ್ಬೇಕು, ನಾನು ಕೇಳ್ತೀನಿ.
25,000 ಬರ್ಕೊಡಿ.
ಅಲ್ಲ ಕೇಳ್ತೀನಿ ಸರ್, ಒಂದ್ ಶಾರ್ಟ್ ಡೇಟ್ ನನಗೆ, ನಾನು ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ.
ಮಿಸ್ಟರ್, ಒಂದ್ ದಾರಿಗೆ 25,000 ಕೊಡಕ್ಕಾಗಲ್ವಾ?
ಅದೇನ್ ಕ್ಲೈಮ್ ಕೇಳ್ಬೇಕು ಮನೆ ನೋಡಿ, 25,000 ಅಂದ್ರೆ
ಪಾಸ್ ಓವರ್ ಹೇಳಿ.
ಇನ್ಫ್ಯಾಕ್ಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್
Can you go? 25,000 ಪ್ಲಸ್ ಊಟ ತಿಂಡಿ.
In fact, charge sheet is also filed by the police, my lord. in
Charge sheet
okay,
ಹಾಕ್ಲಿ
man.
sir.
See, if he doesn't have a way to go reach his property,
Let the commissioner
you
report.
can't close it.
I'm not closing, my lord. That is his
We'll see
allegation.
what is the reality.
Let-
Uh.
28, Rajashekharappa, DR.
in this matter, ರಾಜಶೇಖರ್ ಅವರ ಬ್ರದರ್ ತುಂಬಾ ಸೀರಿಯಸ್ ಆಗಿ ಊರಿಗೆ ಹೋಗಿದ್ರು ಸ್ವಾಮಿ. 2 ವಾರ ಟೈಮ್ ಕೊಡಿ.
The land
ಅಪೋಸಿಟ್ ಸೈಡ್ ಕೌನ್ಸಿಲ್ ನಾನು ಹೇಳಿದ್ದೀನಿ.
Land
ಸಂಗಮೇಶ್
council for
ಅವರು
the petitioner
ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
seeks time on the ground that the arguing council is indisposed.
12ನೇ ತಾರೀಕು ಹಾಕೊಳ್ಳಿ. 12th of
List on 12th. Yes. Nagaraj RC. RC Nagaraj.
Serial number 29, Nagaraj RC.
Hindu Sri.
They filed a vacating application.
ಏನು ಸೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿ?
19 matters.
Huh?
2019 matter.
ಹಾ.
Partition suit compromise ಆಗಿ
Compromise
decree
ಆಗಿದೆ. Without consent of the defendants.
ಏನು whatever challenge, the compromise is challenged.
ಹೌದು, compromise challenge. Without consent, blood.
The matter requires to be heard.
ಮಾಡ್ತೀನಿ sir.
Vacating ಹಾಕೊಂಡ್ರೆ ಹೆಂಗಾಗುತ್ತೆ ಇದು?
Here ಮಾಡ್ತೀನಿ sir.
Huh?
ದಯವಿಟ್ಟು ಇಂಪೌಂಡ್ ಆರ್ಡರ್ 19/6
ಇದು
2000.
vacating stay ಹಾಕಿದ್ದೀರಾ?
ಹೌದು
Petition
ಸ್ವಾಮಿ,
needs to be heard ಅಂತ ಹೇಳಿದ್ರು. Petition needs to be heard. He says compromise is challenged.
ಅವರು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಗ್ರೌಂಡ್ಸ್ ತಗೊಂಡಿರೋದು ವಿತೌಟ್ ನೋಟಿಸ್ IA 10 to 12 ಅಲೋ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
You are a party to the compromise.
Yes. All the parties have agreed to compromise.
ಏನು
Accordingly, the compromise has
ಹೇಳಿ ಏನು? What is this case?
the first respond plaintiff filed a suit lot 75/19
Hmm.
for partition and separate position.
Hmm.
The suit was referred to Lok Adalat. Ultimately, the parties have compromised. Order 23 Rule 3 application has been filed, application has been allowed. Kindly see the page number 35.
Hmm.
35.
Yes, please.
The plaintiff counsel present, argue on IA number 10 to 12, respond counsel Shakuntala for RV advocate present, submitted this court issued court notice to the defendant, but there is no any, oh, yes. Sorry.
Plaintiff counsel present argued on IA number
ಅದಾದ್ಮೇಲೆ
12.
compromise.
Respondent counsel Shakuntala for RV advocate present and submitted this court issued court notice to the defendants, but there is no any instruction from their clients and press to pass necessary order. Plaintiff counsel submitted as per IA number 10, plaintiff schedule IA.
ಈ ಆರ್ಡರ್ ಮೇಲೆ ಸ್ವಾಮಿ.
Page number 30 melody.
ಇದಾಯ್ತು
Look at
ಇದು amendment ಅಲ್ವಾ ಇದು?
the amendment,
ಹೌದು,
this is
Where is
30,
the order
page number 30.
Page number 30.
30. The plaintiff present, the plaintiff counsel present, defendant 1 to 6 are present, defendant counsel present, filed a compromise application under order 23 Rule 3 of the CPC. The plaintiff counsel filed a memo for vacating the injunction. Order passed by this court, amendment carried out on 12/8 to 22. Amendment plaintiff filed memo with 2 RTC filed compromise petition read over the and explained to the parties. They agreed the terms and conditions. The exist element of settlement between the parties. The compromise application is allowed. Suit of the plaintiff is decreed. The injunction granted by this court stands vacated as the parties amicably settled this case before the local. After 1 year, blood, the first, the plaintiff have filed a application. Amendment of plaint
amendment of compromise petition and correction of decree under section 152. How it is possible? They have, all the parties have agreed.
Yes, madam.
On submissions. Partition suit ಸ್ವಾಮಿ. Partition suit ಅಲ್ಲಿ
Clerical
suit
mistake
filed
and
ಮಾಡಿದ
arithmetical
ನಂತರ
mistakes can be.
ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ ನಂತರ ಅಪಿಯರೆನ್ಸ್ ಆದ ನಂತರ WS ಕೂಡ ಫೈಲ್ ಮಾಡಿಲ್ಲ. ಅವ್ರದೇ ಸಬ್ಮಿಷನ್ ಮೇರೆಗೆ ನಾವು ಲೋಕ ಅದಾಲತ್ಗೆ ಕಾಂಪ್ರಮೈಸ್ಗೆ ಸೂಟ್ ಪೋಸ್ಟ್ ಆಯ್ತು ಸ್ವಾಮಿ. ಆ ನಂತರ ಡಿಪೆಂಡೆಂಟ್ ಕೌನ್ಸಿಲು ಡಿಪೆಂಡೆಂಟ್ಸು ಶೇರ್ ಯಾವುದೇ ರೀತಿ ಐಟಮ್ ನಂಬರ್ 1 to 20.
ರೈಸ್ ಮಾಡಿರೋದೇನು ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು.
ಹೌದು ಸ್ವಾಮಿ.
ಕಾಂಪ್ರಮೈಸ್ ಆದ್ಮೇಲೆ ಕೋರ್ಟ್ ಬಿಕೇಮ್ ಫಂಕ್ಟಸ್ ಒಫಿಷಿಯೋ. ಏನ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಬೋದು? ಕ್ಲರಿಕಲ್ ಮಿಸ್ಟೇಕ್ಸ್ ಕರೆಕ್ಟ್ ಮಾಡಿ, ಟೈಪಿಂಗ್ ಮಿಸ್ಟೇಕ್, ಕ್ಯಾಲ್ಕುಲೇಟಿಂಗ್
ಕಾಂಪ್ರಮೈಸ್ ದಿನ ಸ್ವಾಮಿ ಇವರು ರಿಸ್ಪೆಂಡೆನ್ಸ್ ಆಗಿ ಐಟಮ್ ನಂಬರ್ 1 and 2 ನ ಸೇಲ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿರೋದು ರೈಸ್ ಮಾಡ್ತಿದ್ದು ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಒಂದ್ಸತಿ ಡಿಸ್ಪೋಸ್ ಆಗೋದ್ಮೇಲೆ ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ತಿರ್ಗಾ ಅದನ್ನ ಆ ಸೂಟಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಎಂಟರ್ಟೈನ್ ಮಾಡಕ್ ಪವರ್ ಇಲ್ಲ ಎಕ್ಸೆಪ್ಟ್ ಫಾರ್ 152.
ಬಟ್ ಅವ್ರು ಕಾಂಪ್ರಮೈಸ್ ದಿನ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ.
IA 1 of 24 is filed by the learned counsel for
On submission, sir.
to vacate the order of stay granted by this court. After hearing the learned counsel for the petitioner and the learned counsel for the respondent number 1.
Execution ಅಲ್ಲಿ payment
This
stop
court
ಆಗ್ಬಿಟ್ಟಿದೆ.
is of the opinion that the matter requires to be heard extensively as the trial court, after accepting the compromise, has entertained an application to amend the decree and amend the decree, full stop. Hence, IA 1 of 24 is rejected. List the petition for preliminary hearing in B group on date code.
ಒಂದು ಸಬ್ಮಿಷನ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ ಒಪ್ಕೊಂಡಾಗ ಸ್ವಾಮಿ ಅವರು 13,50,000 ಪ್ಲೈಂಟಿಫ್ ಶೇರ್ ಕೊಡ್ಬೇಕಿತ್ತು. ಅವರು 2 months ಟೈಮ್ ಕೇಳಿ ಕಾಂಪ್ರಮೈಸ್ಗೆ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ದು ಪ್ಲೈಂಟಿಫ್ ಕೂಡ ಸ್ವಾಮಿ. ಅದಾದ್ಮೇಲೆ ನಾವು ಅಮೌಂಟ್ ಕೇಳಿದಾಗ ಅವರು 2 months ಟೈಮ್ ಕೇಳಿನೇ ಫಾರ್ವರ್ಡ್ ಮಾಡ್ತಾ ಇದ್ರು. ಸೊ ನಾವು ಲೀಗಲ್ ನೋಟಿಸ್ ಕೂಡ ಇಶ್ಯೂ ಮಾಡಿದೀವಿ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ 2,80,000 ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಕಾಂಪ್ರಮೈಸ್ ಇಷ್ಟ ಆಗದೆ ಇದ್ರೆ, ಅದು ನಿಮ್ಗೆ ಒಪ್ಪಿಗೆ ಆಗದಿದ್ರೆ ಅದಕ್ಕೆ ಬೇರೆ ಮಾರ್ಗ ಇದೆ. ನೀವಾಗಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವರು
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನೋಟಿಸ್ ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ.
But court cannot do it is what I am trying to tell you. Court cannot do it. ಅದನ್ನ ಬೇಕಿದ್ರೆ execution ಹಾಕೊಳ್ಳಿ, ಏನಾದ್ರು ಮಾಡಿ ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿನ. You can't, court cannot amend the decree.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ಡ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಸೆಂಟೆನ್ಸ್ ಕೂಡ ಇಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬಗ್ಗೆ.
Tomorrow's extent to the next state of.
Number 2 for hearing on serial number 29.
Abhinay.
Vide.
Is what happened?
No, they have to report, my lord. If they are willing, then we are also willing. Don't seem to be here. I have not
Abhinay
seen him
Vide.
since morning.
You ಮಾತಾಡಿಲ್ವಾ? You didn't speak to him?
No, I did not see him since morning. No, he's my instructing counsel. Then your lordship may have it on Monday, my lord. We will speak to him.
Monday.
Monday,
List on Monday.
Monday.
Serial
Public.
number 30. Girish Baldare.
Case, my lords. My request may be, my lords, 11th, have it 11th, my lords.
ಗಿರೀಶ್ ಬಲ್ದಾರೆ.
Please,
ನಾವು ಗಲಾಟೆ ಮಾಡ್ತಿದ್ರಲ್ಲ ಓಸತಿ.
please, my lords. Order 39 rule not application, my lords.
ಎಷ್ಟನೇ ಸೂಟು?
22, my lords.
ಸೂಟ್ ನಡೀತಾ ಇದೆಯಾ ಇಲ್ವಾ?
ಸೂಟ್ ನಡೀತಾ ಇದೆ. ಸೂಟಿಗೆ ಸ್ಟೇ ಇಲ್ಲ, ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ, my lords.
ಸೂಟ್ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ನೋಟಿಸ್ ಸ್ಟೇಜ್ LRS ಅವರು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್
ಸೂಟ್ ನಡೀತಾ ಇದೆ, ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೀತಾ ಇದೆ.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನ್ ಸ್ಟೇ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಸ್ಟೇಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಪ್ರಾಪರ್ಟಿ ಸ್ಟೇ.
Counsel for the petition seeks time list on Kavita Damodaran.
Interim order may be extended.
Interim order is extended to the next.
Much.
13 December. HV Devaraju.
Defendant's petition on an application rejecting my application under 711
Ah.
that the claim is hopelessly barred.
Barred by time.
Barred by time. This is that I was a contractor under BESCOM. BESCOM has filed a suit. I was the order, impugned order is at page 25. At page 29, if the facts may be seen, page 29.
Ah,
Present suit filed by the plaintiff for recovery of certain amount of liquidated damages with interest from the defendant. Defendant has now filed present application under 711 for rejection of the plaint. According to plaintiff, work contract as mentioned in the plaint itself given to the defendant in 2011 in respect of 2 talukas so and so. And according to the plaintiff, there is an alleged breach of the work contract by the defendant in September 2013. And according to the plaintiff has short closed the work contract in December 2013 in respect of one taluka on 27th and 28th January 2014 for another taluka. And thereafter, plaintiff has re-allotted terminated work to other contractors between 18th July 2014 and 8th April 2015. According to the defendant, on these dates, the plaintiff would have got cause of action to claim the liquidated damages, but the present suit is filed in 2021, and therefore the defendant contends that the suit is barred by limitation and the plaint is liable to be rejected. Plaintiff has opposed the application and stated that in the termination order itself, plaintiff has stated that the liquidated damages to be recovered is to be assessed, and this would be claimed. Therefore, the plaintiff contends that at the time of termination order, the plaintiff had reserved its right to claim liquidated damages at the subsequent date after assessing the loss. The plaintiff has stated that after terminating the work contract, the work was given to another contractor, and after they completing the work report, assessing the liquidated damages was prepared and sent for approval by internal audit, and then by following procedure, suit is filed. In the plaint, my lord, they say that the contract came to an end in 2014. The balance work given to the other contractor in 2015. That got over in 2015. Their internal assessment went on till 2018. Approval came in 2020, and so suit was filed in 2021. In fact, my contract, there's no question of assessment also.
Devaraj?
At that,
These are all admitted facts.
That's
2015 in the 2021 or go. What is the justification?
at that I will make my submission.
Time beka. Non-counsel.
My lord, at the time of filing the, I don't mind, at the time of filing the petition, there were some talks going on between us. Therefore, an application for stay was not filed. Now I filed an application for stay. If my learned friend is taking time, let him not escalate the matter in the trial court. That's all.
So what is the stage of the suit?
Lord, now I believe the
Set
trial
down
is
for
going.
cross-examination.
Trial has commenced.
Cross-examination.
Yes.
Let him not escalate it till.
Till the next stage will stay the proceedings.
At that.
So the non-counsel for the respondent seeks time. Since the petitioner has raised a substantial point for consideration, the further proceedings before the consideration, it's a substantial point for consideration. The further proceedings before the trial court has to be stayed. In that view of the matter, the further proceedings before the trial court in OS number so-and-so is stayed till the next date of hearing. List on yavat ಬೇಕು?
And the 10 days.
Date ಕೊಡಿ. Shivananda DS.
19 December.
Grateful, man.
Number 32, Shivanand D.
Other day, my lord,
Ah,
you heard my regarding passage, my lord, interim order is already granted by this court, my lord.
Yeah.
Let the interim order may be continued, trial court may direct to dispose of the suit, my lord.
Till disposal of the suit, not to.
Already ತಾವೇ modify ಮಾಡಿದ್ವಿ.
ಅದೇ construction ಮಾಡಂಗಿಲ್ಲ. Nobody shall.
ಅಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇರಲ್ಲ.
ದಾರಿ ಹೋಗ್ಲಿಕ್ಕೆ ನನಗೆ
ಅಲ್ಲ.
ಜಮೀನಿಗೆ ದಾರಿ ಹೋಗ್ಲಿಕ್ಕೆ ಅಷ್ಟೇ. Till disposal, my lord, since 1989 I am using.
ಅಲ್ಲ.
Last.
So he says till dispose of the suit, this interim order can be granted ಅಂತ.
ತಮ್ಮದೇ ಆರ್ಡರ್ ಇದೆ. ಅದೇ.
ಅಲ್ಲಲ್ಲ, it was modified, not to change ಅಂತ ಮಾಡಿದ್ದೀರಾ. ನನಗೆ ದಿನ ಹೋಗ್ಲಿಕ್ಕೆ ಜಮೀನಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ತೊಂದರೆ ಆಗ್ಲಿದ್ರೆ it may be disposal.
ಜಮೀನು ಹೋಗ್ಲಿಕ್ಕೆ ಅಂತ ನಾಮ್ ಬರೆಯಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಫೋಟೋ ಕಾಪಿ.
It is made clear that neither the petitioner nor the respondent shall change the nature of the suit shall property.
Yes.
Or passage or beaten track, if any, till the next date of hearing ಅಂತ ಹೇಳಿ.
Yes.
ಇದನ್ನ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡ್ಕೊಂಡು ಹೋಗ್ಬೋದಲ್ಲ.
ಅಷ್ಟೇ.
ಈಗ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ there was the pathway, my lord, in favor of the, my lord, to reach the B schedule property by the, my lord, this respondent. Now, my lord, from 2021, my lord, is disturbing.
ಆಯ್ತು ಬೇಕಿಂದ then will come at 2:30.
My lordship on submission.
ಏನಾಯ್ತು?
ಏಳುವರೆ ಲಕ್ಷ ಕ್ಯಾಶ್ ಇಟ್ಕೊಂಡ್ 7.5 ಲಕ್ಷ ಕ್ಯಾಶ್ ಇಟ್ಕೊಂಡ್ ಬಂದಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಅವ್ರು ಏನ್ ಹೇಳೋಕೆ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ. ಇಲ್ಲ ಮೇಕ್ ಒಂದು ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ 7.5 ಲಕ್ಷ ಕ್ಯಾಶ್ ಇದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಸೋಮವಾರ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿ ಟೆರಲ್ ಕೊಟ್ಟು ಕಟ್ಬಿಡ್ಲಿ, ಇಲ್ಲಿ ಮಂಗಳವಾರ ಹಾಕೊಂಡ್ಬಿಡಿ ಸ್ವಾಮಿ.
ನಾಳೆ ಬ್ಯಾಂಕ್ ರಜೆ ಇರ್ತದೆ, ಸೋಮವಾರ ಡಿಡಿ ತಗೊಂಡು
ನಾ ಸೋಮವಾರ ಹೇಳಿದ್ದೆ
ಎಷ್ಟು ಕಟ್ಟಬೇಕಾಗಿದೆ? 15
7 ಲಕ್ಷ
7 ಲಕ್ಷದ
7,60,000 ಕಟ್ಟಿದ್ದಾರೆ. ಇನ್ 7,40,000 ತಮ್ಮ 15 ಲಕ್ಷದ ಪ್ರಕಾರ 7,40,000 ಕಟ್ಟಬೇಕಿತ್ತು.
ಅದು
ಕ್ಯಾಶ್
ಕ್ಯಾಶ್ ತಂದಿದೀವಿ, ಅವರು ಕ್ಯಾಶ್ ಬೇಡ ಅಂತಾರೆ.
ಅಲ್ಲ ಕ್ಯಾಶ್ ಏನ್ ಮಾತಾಡ್ತಾರ? 7.5
ಅವರು
ಲಕ್ಷ
ಬಸ್ಸಲ್ಲಿ ಏನೋ ತಗೊಂಡ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ಏನೋ ಆಗ್ಬಿಡ್ತೈತೆ ಅಂತ.
ಹೌದು, ಆಮೇಲೆ ಹೆಚ್ಚು ಕಡಿಮೆ ಅದು.
ನಾವು ಕಷ್ಟಪಟ್ಟು ನಾವು ತಗೊಂಬಂದಿದೀವಿ, ಎಲ್ಲೆಲ್ಲೋ ಒಂಚಿ ತಗೊಂಡ್.
ಅಂಬಲ್ ಸಬ್ಮಿಷನ್
ಇಲ್ಲ, ನೀವು ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ಳಿ, ಸೋಮವಾರ ಡಿಡಿ ತಗೊಂಡು ಮಂಗಳವಾರ ಡಿಡಿ ಕೊಡ್ತೀವಿ ಸರ್.
ಇಲ್ಲೇ ಡಿಡಿ ಕೊಡ್ತಾರ್ರಿ ಕೆಳಗಡೆ ನಮ್ಮ ನ್ಯಾಯ ಮಿತ್ರ.
ಅದು ಅಕೌಂಟಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಅಕೌಂಟಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿ
ಹಂಗ್ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅವ್ರ ಅಕೌಂಟಿಗೆ. ಪ್ಯಾನ್ ನಂಬರ್
ನಂಬರು ಇದೆಲ್ಲ ಕೊಡಿ.
ಯಾರು ಡೆಪಾಸಿಟ್ ಅವ್ರ ಪ್ಯಾನ್ ನಂಬರ್ ಎಲ್ಲ ಬೇಕು.
ಪ್ಯಾನ್ ನಂಬರ್ ಕೊಡ್ತಾರಲ್ಲ, ಇಲ್ವಾ? ಪ್ಯಾನ್ ಇಲ್ವಾ?
ಇಲ್ಲಿ ನಂದು ಇಲ್ಲ ಅಕೌಂಟ್.
ಇವ್ರ ಪ್ಯಾನ್ ನಂಬರ್ ಇಲ್ಲ.
ಕೇಳಿ ಅವ್ರು ಟ್ಯೂಸ್ಡೇ ಮೇಲೆ
ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ನೋಡಿದ್ರ 7.5 ಲಕ್ಷ ಇದೆಯಾ?
ಇದೆ ತಂದಿದೀವಿ.
ತೋರಿಸಿ ಬರೀ ಪೇಪರ್ ತಂದಿದ್ರಿ?
ಇಲ್ಲ
ಬ್ಯಾಂಕ್ ತೋರಿಸ್ತೇವೆ ಸ್ವಾಮಿ ಅವಾಗಿಂದ ಈ ತರ ಇಟ್ಕೊಂಡ್ ಬಂದಿರ್ತದೆ.
ತೋರಿಸಿ ಇದೇನ್ರಿ? 7.5 ಲಕ್ಷ ನೋಡ್ರಿ, ಇದೇನು
ಒಂಥರ ಕಸ ಇದ್ದಂಗಿದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು ನೋಡ್ರಿ, 7.5 ಲಕ್ಷ ಇದೇನೋ?
ಇದೆ ಸ್ವಾಮಿ, 7 ಲಕ್ಷ ತರ ಇದೆ
ನೋಡಿ. ಎಷ್ಟು? 500 ರೂಪಾಯಿ ಬಂಡ್ಲ, 2,000 ಬಂಡ್ಲ?
ಅಲ್ಲ, 500 ರೂಪಾಯಿ ನೋಡಿ.
500 ರೂಪಾಯಿ ಅಂದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ?
500 ರೂಪಾಯಿ
6 ಲಕ್ಷ ಬರ್ತಾ ಇರ್ತದೆ.
6 ಲಕ್ಷ ಇದೆಯಾ?
6 ಲಕ್ಷ ಬರ್ತದೆ.
ಇಲ್ಲ 7 ಇದೆ.
ಅದಲ್ಲ ಅಂದಾಜ್ ಬಂಡ್ ಲೆಕ್ಕ ಹಾಕಂದಲ್ಲ 6 ಲಕ್ಷದ ಮೇಲೆ
ಇದೆ ನೋಡಿ. ಇಲ್ಲಿ ಎಷ್ಟು ಇರ್ಬೇಕಲ್ಲ?
ಇದು 5 ಲಕ್ಷ ಇದೆ ಸ್ವಾಮಿ. ಒಳ್ಳೆ ಸ್ವಾಮಿ ನೀವು 100 ರೂಪಾಯಿ ಬಂಡ್ಲಿ ಇಟ್ಟಿರಿ ಸ್ವಾಮಿ. ಕ್ಷಮಿಸ್ಬಿಡಿ ಮತ್ತೆ. ಸಾರಿ, 100 ರೂಪಾಯಿ ಬಂಡ್ಲಿ ಇಟ್ಟಿರಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇದೆ
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ನೋಡಿ ಮಧ್ಯದಲ್ಲಿ 1 ರೂಪಾಯಿ ಇದೇನೋ?
ಇಲ್ಲ ನೀವೇ ಕಟ್ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಕ್ಯಾಶ್ ಬೇಡ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೆದರಿಕೆ ಆಗುತ್ತೆ.
ಆಮೇಲೆ ಕಮ್ ಬ್ಯಾಕ್ ಟು 230 ನೋಡಿ. ಇನ್ನೊಂದು 10,000 ರೂಪಾಯಿ ಬರುತ್ತಲ್ಲ.
ಅವ್ರು ಎಣಿಸ್ಕೊಬೇಕಲ್ಲ. 740 ಇದೆಯಲ್ಲ, ಕರೆಕ್ಟ್ ಇದೆ.
440 ಇದೆ, 460 ಇದೆ, 460 ಆಮೇಲೆ ಇಲ್ಲಿ ಇದೆ. ಇಲ್ಲಿ ಇದೆ, ನಮ್ಗೂ ಇದೆ, 80 ಇದೆ,
ಸರ್
240 ಇದೆ.
ಇಲ್ಲಿ ನೋಡಿ, ಇಲ್ಲಿ ಬೇರೆ ಇದೆ.
ಇಲ್ಲಿ ಬೇರೆ ಇದೆ, ಅದೇ ಅಷ್ಟೇ ಅಲ್ಲ, ಇದು ಇದೆ 240 ಸರ್. ಅದೇ ತರ 80.
ಸರ್ ಇದು
ಎಣಿಸ್ಕೊಡಿ.
100 ರೂಪಾಯಿ ಬೇರೆ ಕಡೆ ಇಡ್ರಿ ಸರ್. ಪಾಸ್ಪೋರ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಹೇಳ್ತಾರೆ ಸಾಹೇಬ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 58 ಅಡ್ಜನ್ ಆಗಿಲ್ವಲ್ಲ?
Court officer, Court officer?
Hello, yes,
Court
madam.
officer?
Yes, madam.
Sir, ಇದು ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಹಾಕ್ತಿದ್ನಲ್ಲ 1 ಯಾವಾಗ ಕರೀತೀರಾ ಸರ್?
What, madam?
ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1.
Ah,
Will it be after cost list number 2?
yes, madam. Call list number 2, hearing and after hearing an IA, we will go to the list number 1 for fresh matters.
Okay, sir, because cost list number 2 contains 71 matters.
We don't know anything, madam. After that, his lordship come now, we will ask the permission and we will continue, madam.
Okay, sir, okay. Thank you so much.
I'm sorry, ಯಾವ್ದೋ ಫಂಕ್ಷನ್ ಕರೆದಿದ್ರು ಲೇಟ್ ಆಗೋಯ್ತು. I'm sorry.
My lord,
dictating
orders.
Hmm?
Dictating orders.
Is that Prithvi Wadiyar? That other matter was you were supposed to file some objections. What happened?
ಅದು special order.
ಆ writ petition ಬಂತ? Follow up ಮಾಡ್ಬೇಕು.
My lord, that can be held separately because election is going to end on 4th December, my lord. That can be held separately.
Because whatever order that I am going to pass will have a bearing on that writ petition.
It could be having a bearing on that, but that can be held separately. The election is going to end it on 4th, my lord.
ಅದೇನು ನಾಳೆಗೆ ಆಗುತ್ತಾ? ಚೆಕ್ ಮಾಡಿ ನೋಡಿ. ಇವತ್ತು
ನಾಳೆ
sitting
sitting
ಬರೆಯಲ್ವಾ?
ಇದೆಯಾ? Sitting ಇದೆಯಾ?
ಚೆಕ್ ಮಾಡಿ. Please wait, let me see.
Number 2 for serial number 32, Shivanand DS.
Serial number? 42. Learned counsel for the petition, Kalyana. Learned counsel for the petition seeks time list on date.
Serial number. Serial number 10 December. Monday.
ಎಷ್ಟೇ ಇಸಿ ಸೂಟು?
ಸೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿದಂತೆ?
ಆಗೋಗಿದೆಯಲ್ಲ, ಮುಗ್ದೋಗಿದೆ.
Proper service of notice. ಇಲ್ಲ ಸರ್, ಹೊಸದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಲಿಸ್ಟ್ 2. 16 ಆಗೋ ಶರತ್ ಕುಮಾರ್. Maintainability of writ petition. So it has become infructuous. ಆಯ್ತು, ಒಂದು ಸ್ವಲ್ಪ ತಳ್ಕೊಳ್ರಿ.
I am up here for respondent.
Please wait, please wait. Yes, correct.
ಸೀರಿಯಲ್ ನಂಬರ್ ಅದು ದುಡ್ಡು ಎಣಿಸ್ಕೊಂಡ್ರು.
7,40,000 ಇದೆ ಅದು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೋಮವಾರ ಕಟ್ಬಿಡ್ಲಿ ಅವರು. ಬುಧವಾರ.
The petitioner has today brought in cash of rupees 7,40,000.
Yes, ma'am.
So the learned counsel for the respondent submits that the petitioner may be directed to deposit the amount before the trial court.
Execution
on Monday.
ಮಂಡೇ ಬೇಡ ಬೇಡ, ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಲಿ ಸರ್. ಅಲ್ಲೇ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಅಡ್ವೊಕೇಟ್
counsel for the petitioner is directed to deposit the amount before the trial court. Trial court or executing court?
ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್.
The executing court on Monday.
ಮಂಡೇ ಬೇಡ, ಟ್ಯೂಸ್ಡೇಗೆ ಇದು ಮಾಡಿ ಸರ್.
On Tuesday, list on Wednesday.
ಪ್ಲೀಸ್ ಮ್ಯಾಮ್.
My lords, serial number 65.
ಎಂಟ್ರಿ ಮಾಡಿಟ್ಟು ಕಂಟಿನ್ಯೂ.
Entry model is extended till the next day.
My lords, serial number 65, appearing for respondent number 1 to 7, my lords, on behalf of Nagendra Nayak, sir, my lords. My lords, it is a suit for declaration.
What do you want?
My lords, request 2 weeks of time for filing the statement of objections and the.
Learned counsel for the response 1 to 7 seeks time list on date. Correct.
17 December.
Much obliged.
Serial number 32, Shivanand DS.
DS Shivanand. Shivanand DS. ಅದೇನೋ ಹೇಳಿದ್ರಲ್ಲ.
Yes, my lord, it may be disposed of along with the status by observing the.
Same order?
Yes.
ಬರ್ಕೊಳ್ಳಿ. The defendant number 1 in OS number so and so on the file of so and so has filed this petition challenging the grant of interim injunction,
Yes, my lord.
grant of interim injunction by the trial court restraining him and others. Restraining him and the defendant number 2 from interfering with the peaceful usage of the pathway to reach the Asian property. So this court, in terms of the order dated 19/11/2024, had directed the parties to maintain status quo and had clarified that neither the petitioner / defendant number 1 nor the respondents / plaintiff, defendant number 2 shall change the nature of the suit shall property or the passage or the beaten track, if any, till the next date of hearing. Full stop. Learned counsel for the petitioner and the learned counsel for the respondent number 1, huh?
Yes.
Submits that the writ petition could be disposed of, directing the continuing the aforesaid order till the disposal of the suit. Full stop. In view of the aforesaid submission, comma, this writ petition is disposed of, directing both the parties to maintain status quo in respect of the B shell property, and neither the petitioner nor the respondents shall change the nature of the suit shell property or the passage or the beaten track, if any, till the disposal of the suit before the trial court. Yes.
Suit may be disposed of.
Suit ಎಷ್ಟನೇ ಇದು?
2022.
22 ತಾನೆ, yes, next.
Serial number 33 urgent, serial number 34, Venkatesh Somreddy.
Mr. Venkatesh.
Appearing for the petitioner lordships. Kindly pray for a short accommodation.
Learned counsel for the Sachin.
Thursday or Friday.
Learned counsel for the petitioner seeks time list on date. Pavan Javali.
Interim order, your
Serial
lordship.
number
Was
35,
extended to the next.
I appeal to the respondent.
Mohan R. Jolly.
I'm handing over the DD of around 15 lakhs.
Yeah.
Lord, 15 lakhs is 2 months rent, my lord. What time this court had granted them to pay the balance?
What do you want?
2 crore 54 lakhs is due, my lord. 50 lakhs they paid last time. 4 weeks time was granted, my lords, may kindly
So
see.
there's some order on the last day there was some order.
ಆಗ್ಲೇ 6 ವಾರ ಆಗೋಗಿದೆ.
Petitioner is permitted to take the prospective purchasers to inspect the machineries installed in suit provision and the purchaser willing to purchase also. Yes, Mr.
The prospective buyers are coming here, due to that attachment which is there before the trial court, they are hesitating to.
Allah, this
deposit
order is there, my lord.
Lordship, if that attachment is waived off, there, I'm still ready to get those buyers and pay the whole
Lord, they-
amount.
Mr. This court has passed a clear order. If the purchasers are willing to purchase the machineries and willing to deposit the value of the machines before the court, petitioners are at liberty to dispose of the machineries. What more?
Yes, because of that attachment, your lordship, the Adrinda, they
Then
are.
will permit them to proceed in accordance with law.
My lord, not only that,
I request.
ಇವಾಗ suit decree ಆಗೋಗಿದೆ. There is an execution we have filed for taking possession. It's a suit for ejectment and arrears of rent. There also they say there is an order of stay in this court.
Yes,
So
what do you
therefore
want?
they should.
And I'm giving a.
Not 15 lakhs, Mr. Not 15 lakhs. Don't throw breadcrumbs.
I'm trying to arrange even more, your lordship. I
Our
just
ಒಪ್ಪೋದಾದ್ರೆ,
need,
if he is willing to accept.
1 month's time, and I'll try to dispose of those machineries and give them,
My lord,
at least. this
What do you want?
vacation.
Are you willing to accept it or not?
my lord, I'll accept, but I am ready to argue the application. What money they are going to give, it is due to me, my lord.
I will add some more also during this month of December, your lordship.
My lord, 4 weeks
Sir,
time has
this-
been granted.
That time.
4 weeks,
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
6 ವಾರದಲ್ಲಿ rent.
What do you want to do? You want the matter to be heard?
My lord, that interim order that has been passed, I have sought for vacating that. My lord, that interim order, there is a false submission made before the court, stating that the immovable property that we sought for attachment has already been attached. There is no attachment, earlier attachment anywhere. My learned friend can, this thing is.
It
There's
has
no
been
attachment.
mortgaged to the bank, I mean, it is not
ಇಲ್ಲ,
attached
but
to your
ಅವ್ರು
lordship.
ಹೇಳಿರೋದು ಹಾಗೇನೆ.
It's been mortgaged to the bank and it is one of
Yes.
the conditions of that
Yes,
company.
when will you pay the money? When will you get the purchasers?
Purchasers
this
are
is only a
already
li-
ready, your lordship. The only thing is
Mr.
due to that.
Please give the names of the purchasers at least.
I'll-
Give the names tomorrow, Monday. List on Monday, Barcode. The learned counsel for the petitioner submits. What do you hand over, madam? The learned counsel for the petitioner has today handed over a sum of rupees 15 lakhs by demand draft bearing number so and so, dated so and so, drawn from so and so.
State Bank of India.
Towards the liability, towards part of the liability. Full stop. The learned counsel for the petitioner submits that he has confirmed buyers who have expressed interest to purchase the machineries. Full stop. The learned counsel is directed to place on record the names and particulars of the buyers before the court on the
As well as the price they are offering.
and the price before the next next date of hearing. List on Monday.
Great.
A week here on
Details ಕೊಡಿ.
interim order maybe.
Interim order extend to the next date.
Number 36.
Okay, for petitioner, my lord, the amendment application, my lord, there is a small typographical error. In the names of coffee and pepper, my lord, it was at a error. And ragi and jover, the names of crops was typographically mistakenly entered. Hence, I filed
On
that
the
application.
petition to be amended.
I petition to be only on two areas. The trial court, my lord, I have served the
That
copy of
notice we
the.
showed, list after service of notice to
I
respond.
served the the
Where is the
trial court
trial
appearing
court?
on the
Trial
trial.
court,
1511 ಗೆ ಮಾಡಿದೀನಿ.
Where is the trial court?
Arkalgod.
Huh?
Arkalgod.
But Arkalgod liar ಬರಲ್ವಲ್ಲ ಇಲ್ಲಿ. Yes, next, list after service of notice to the response 1 to 6.
My lord, date may be granted because the status quo order, my lord, my difficulty is the trial court has passed an erroneous order. Even though records, all the RTC entries are in my name.
List number 1 for fresh matter, serial number 30, Harsha D. Joshi.
Petition. My lord, the other connected matters, my lord, that serial number 1 and 4, kindly have it on next week, my lord. Filed by the same petitioner, my lord. Serial number 1 and 4, my lord. Today, the latest, my lord. Serial number 1 and 4.
List this petition along with WP number 31993 of 24 and 32026 of 24 on date. Yes. Manjula Devi.
Grateful, my
Number 31, Kamadoli Manjula Devi.
My lord, the petitioner filed a suit for declaration and permanent injunction against the respondents, my lord. That came to be dismissed, my lord. Thereafter, my lord, he filed a regular appeal, and in the appeal, my lord, he filed EA number 4, my lord, for amendment of the plaint. That insertion of instead of suit for a permanent injunction, he wants to add possession, my lord. Because my lord,
Take out notice, man. Issue emergent notice.
Right.
In addition, the learned.
Stay of the RA, my lord, because it is coming up for hearing, my lord.
In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represents the respondent before the trial court. Till the next date of hearing, the further proceedings in RA number so and so is state.
Please.
List on date. Mr. Vishwajit Rai.
Serial number 32, Vishwajit Rai, M.
K. Ravishankar.
I appear for the petitioner. This matter was heard by your lordship the other day, my lord, with regard to the joint memo filed by both the parties, my lord. Now, there was a suit for money suit, my lord, in the said suit, my lord, a compromise was entered between the parties, my lord. As per the compromise, my lord.
Yes, kindly take, what I say is, kindly turn to page number 30. According to him,
page number?
Page number 30, the prayer of the suit. According to him, directing the defendant to pay so and so, 18% per annum from the date it's due till its realization. Therefore, he says the joint memo is filed to decree the suit as claimed. But kindly turn to ink page number para 6 of the plaint, 27. It is submitted that the defendant firm earlier used to make payments promptly by way of check and committed defaults in making the payments, and the total amount due is so and so, 100 rupees, as on today. Kindly mark. Therefore, the suit claim itself, it is paid for 1,01,95 lakhs, so and so. Kindly turn to para 14, 12, page 30. It is submitted that the cause of action arose so and so when the defendant made the last payment and running bill so and so. For this milord, he has not paid. It is not been adjudged. No court fees have been paid. Even according to the execution petition, how we arrived at, kindly see, according to the decree.
So it is 1,01,95 lakhs.
As on today. Kindly turn to the execution petition itself. Kindly turn to execution petition, ink page number 42. 40 starts, 41, annexure E. The lordship's got it. Next page, 42, G. Amount with interest due upon the decree or any other relief granted by together with the particulars of so and so. As per the compromise decree, the respondent herein agreed to pay the petitioner suit claim RS so and so with the 14%. With the period 5 months of so and so, it starts from the date of the decree. Even not from the, he has not claimed in the execution petition from the date of the suit. Therefore, my lord, I have filed a writ petition connected to this, that is WP 18225. Challenging where the court has granted from the date of the suit. I am saying even according to the execution petition and even according to that, my lord, he has claimed from the date of the decree.
Yes.
Therefore, my lord, even for earlier suit, let's kindly have a look at, it has to be adjudged under section 34 to claim. Under section 34, my lord, interest, where in so far as a decree for the payment of money, the court may in the decree order interest as such rate as the court deems reasonable to be paid on the principal sum adjudged from the date of the suit and the date of decree, in addition to any interest adjudged on the principal sum and so and so. Therefore, the adjudication must have been done. If the adjudication is not being done under clause 2, it is deemed to be have been waived. That is my second limb of argument. Because now he has specifically stated in para 6 of his plaint that it is as on today that much, and even according to the execution petition, it is from the date of the decree.
Now, your lordship may kindly see the joint memo, my lord. That is part of the decree.
That is why I asked you whether
Yes.
this 1,95 lakhs
Yes, yes.
includes the interest as on that date.
It doesn't include my.
But you
Para
say
six.
that in the plaint.
No. Kindly see the decree passed, my lord. Kindly see the decree passed. As per the compromise petition, my lord. Compromise petition is at page 40, my lord.
Yes.
Yes, kindly see the plaintiff and the defendant, namely above, respectfully submit as follows. It is submitted that the plaintiff has filed the above suit for recovery of so and so along with 14% interest per annum against the defendant. The plaintiff and defendant have discussed the issues arising out of the dispute and has arrived at a settlement. The terms of the settlement as hereunder. The defendant agrees to pay the suit claim amount within a period of 5 months from today to the plaintiff. Now, second, B, the defendants have no objection in decreeing the suit of the plaintiff as prayed for. This is important one. He had no objections. And C, in view of the settlement arrived at between the parties, the plaintiff is entitled for refund of court fee in accordance with law. In the event of failure of the defendants to pay the decretal amount with the interest within a period of 5 months from today, the plaintiff shall be entitled to execute the award passed in pursuance of this settlement in accordance with law. Now, as per this, my lord, the court has passed the order. It
What
is
order?
to pay the decretal amount, my lord, from the date of the suit. It's
How is
perfectly
it possible from the date of the suit is what I am asking. How is it possible to pass from the date of the suit?
No, there is a form, admittedly, my lord, parties have agreed for the settlement, and this is part of the record, my lord. This is part of the award. He has agreed, my lord. He has agreed in the joint petition. Now, kindly see the judgment passed by the court, my lord. It acts upon this joint memo filed by the parties. It is very clear, my lord. There is no ambiguity in this thing. They have agreed, my lord. Parties, he has also deposited certain amount pursuant to the judgment passed by my lord. Now he can't come and say, my lord, that I have not agreed to the joint memo. Joint memo is clear. Joint memo is part of the decree, my lord. It is part of the decree. And decree is very clear, my lord. Because the award passed in the Lok Adalat, it amounts to a decree.
Correct.
He can't go beyond the terms of the decree, my lord. He can't go beyond the terms of the decree. He has agreed. He has deposited certain money, my lord.
Settlement idea.
Alla settlementally, he has deposited certain amount. Only
from-
this. Just 1 minute. Only dispute is, it is with regard to the plaint, date of the suit or from the date of the decree, my lord. In the first 2 cases, my lord, court has passed the order saying that it is from the date of the suit. In the other 3 cases filed by me, it is from the decree. So totally inconsistent orders, my lord.
No,
Actually, they have agreed, my lord. Only the limited point is with regard to the rate of interest, actually.
You do not know what is agreed, what is not agreed.
ಅಲ್ಲ ಡೇಟ್ ಆಫ್ ದಿ ಸೂಟ್ ಆದ್ರೆ ಅವ್ರು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಇಲ್ಲ.
ನಿಮ್ಮ ಸೂಟ್ ಹಾಕಿದ್ ಯಾವತ್ತು?
But it is filed on
yes
18th March 2018.
17.
18th March 2017.
Correct.
And it is settled on what date?
22/4/2018. A joint memo is filed. Decree has been drawn on the very same day.
Yes.
Therefore,
it is
he
as
filed
per
an
the settlement, my lord. It is as per the-
execution
No,
petition.
no, 1 minute, 1 minute. It is as per the same joint memo is filed, agreed by both the parties. He has signed, they have signed the joint memo. They have said that we'll pay the amount within 5 months, not paid, my lord. Thereafter, when the execution petition is filed, my lord, these contents are taken.
Yes.
In respect,
ಕೊಡಿ ಇನ್ನೆಲ್ಲ ಮಿಕ್ಕಿದ ಕೇಸ್
Alla, may I submit, my lord? This writ petition, that is the first and the second writ petitions are with regard to the, from the date of the suit anta.
ಸೂಟ್ ಆದ್ರೆ ಅವ್ರು ಯಾಕೆ ರಿಟ್ ಹಾಕಿದ್ರು ನನಗೆ ಗೊತ್ತಾಗ್ತಿಲ್ಲ.
From the date of suit.
Yes, finding is from the date of the suit you have to pay. In the other three writ petitions filed by me, my lord, it says from the date of the decree, which is totally, it cannot be from the date of the decree, it is from the date of the suit.
All these execution petitions were before the same court?
No, the last three were before some other court, my lord.
Is what have you challenged?
But I have challenged where it has been ordered from the date of the suit. I am saying it is from the date of the decree, not from, because in the execution petition, it's an unequivocal term he has stated. And under section 21, it's a local decree, is part of decree.
Execution petition, I have not stated.
No,
anything.
you have stated para 12.
Yes,
Para page 42.
Yes, para 42, you read, kindly read it. As per the compromise decree, the defendant respondent herein agreed to pay the petitioner suit claim of rupees so and so with interest at 14% within a period of 5 months from 22.
That is the date of the decree.
Wait, yes, principal amount is so and so.
He sought itself from the date of the decree.
That is payment, my lord. He had to make the payment within 5 months. He cannot interpret it in such a way. He was granted 5 months time to pay the amount. He didn't pay that amount, my lord.
ಕೊಡಿ ಮಿಕ್ಕಿದಲ್ಲ ಕೊಡಿ. All the.
No, all the 5, my lord, against the same parties, my lord, except 1 and 2 is.
All the 5 cases.
Yes.
The terms of joint member.
Same.
Remains the same.
Same.
But the orders are little bit
Different because it came before some other court, my lord.
What is the suit claim?
Suit claim is one.
The first case, it is for 1 lakh.
ಬೇಕಿದ್ರೆ ಇದರಲ್ಲಿ ಒಂದರಲ್ಲಿ ಬೇಕಿದ್ರೆ ನಾವು
Claim
ಚಾರ್ಟ್ ಬೇರೆ ಬೇರೆದಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಇದೆ.
Suit claim one case ಅಲ್ಲಿ ಹೇಳಿ.
One case ನಲ್ಲಿ 21680, that is the first case. First case ನಲ್ಲಿ suit claim is
195,51,563.
1,95,51,463.
So you are bound to pay interest from the date of the suit.
Yes.
But
If not from the date of its due,
Yeah.
you are bound to pay interest from the date of the
But
suit.
what I would submit before this court is, from it is joint memo is filed, part of the decree, from 5 months given, he filed an execution petition. Even for awarding the interest from the date of the suit, there must be an adjudication under section 34. If the adjudication is not done, the waiver will be there, Millet, under section
Will not
34
apply to that. Section 34 will not apply to that because it is agreed between the parties.
Agreed between it's like a contract.
It is agreed between the parties.
Yes,
There's a
between the
question of
parties.
Invoking 34.
Millet, the 34 also says, Millet,
If it's a decree passed by it, what you say is right.
Correct.
This is not a decree passed by it, it's a decree by consent.
Correct.
Compromise.
Therefore, where's the question of ನೀವು from the date of suit ಅಂತ ಕೊಟ್ಟಿದ್ರೆ ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ?
ಅವರು earlier date ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Probably, my
Date
lord.
of realization.
Realization ಅಂತ
We should not have. I
So
agree.
32 and 32.1 will have to be dismissed.
Yes, ma'am, it has to be confirming the order passed by the.
Millet, my submission for that is, when the decree, Millet, is under section 34, if the decree is silent with regard to so and so, it has to be deemed to be weighed.
Yes.
That is my submission.
It is not a decree passed by the court.
And one more submission, but even in the entire execution petition, they have claimed only the amount which have been from the date of the decree, not from the date of the suit. Therefore, they are precluded from claiming any interest which has been sought in the execution
From the
petition.
date of suit ಕೇಳಿದ್ರೆ from the.
ಕೇಳಲಿಲ್ಲ ಅವರು ಎಲ್ಲ from the decree ಕೇಳಿದ್ದಾರೆ.
Kindly see the execution petition file. It's very clear. It's very clear.
Millet, no. Kindly have a look at Millet execution petition.
Yes.
The Millet, the executing court cannot travel beyond the what is sought.
As per the compromise decree,
Within
within 5 months, within 5 months.
Page
This 5 months,
42. Once again, I will read.
This 5 months he has not complied with.
Annexure, clause G, amount with interest due upon the decree or any other reliefs granted thereby together with the particulars of any cross decree, whether passed or so and so. As per the compromise decree, the defendant respondent herein agreed to pay the petitioner the suit claim of rupees so and so with interest at 14% within a period of 5 months from, that is the date of the decree, my lord. They have calculated for 5 months from the principal amount so and so, interest per rate from 2019 so and so. Therefore, he has sought itself, it is from the date of the decree, not from the date of the suit.
With interest at 14% within a period of 5 months from 22.
Aదే 5 months ಅಂತ ಹೇಳಿದ್ರೆ, because not under the joint memo, kindly similar to, there is a clause, it has to be paid from the within 5 months.
Yes.
Therefore, it has been not been paid. He calculated interest for a period of 5 months, then defaulted, then file execution petition from the
ಈಗ 1 lakh, sorry, 2,93,000.
kindly see the clause A. The defendant agrees to suit claim of the amount within a period of 5 months.
ಈ 29 ಲಕ್ಷ ಎಷ್ಟೇ ಆಗುತ್ತೆ?
Yes, sir.
This 29 lakhs is for what period?
It is for 5 months from the date of the decree till the execution is filed. That is what he contends. That 5 months, because there is a default clause, clause A, defendant hereby pays so and so within 5 months. That is from 22/4. Kindly see the date. 22/4/2018.
You know what is the amount? 2,93,81,650.
ಅಲ್ಲ, 1,95,51,000
Principal ಆಯ್ತು.
That's principal.
ಅದು principal ಆಯ್ತು.
Principal ಆಯ್ತು.
Interest ಎಷ್ಟು ನೋಡಿ? It is not 29 lakhs, it is 2
2
crores
crores,
93
2
lakhs.
crore.
ಹಾ, ಮತ್ತೆ?
2,93 lakhs so and so.
ಹಾ, ಮತ್ತೆ?
That is from 22/4/2018, the execution
20
petition is filed on 2009.
No, up to 21/4.
From the date of the suit calculate
Yes,
ಮಾಡೋದಿಲ್ಲ.
sir,
ಒಂದು
yes.
ವರ್ಷಕ್ಕೆ 22 ಕೋಟಿ ಹೆಂಗ 3 ಕೋಟಿ ಹೆಂಗ? But 14%, how does it become to double? It is 2 crores, you are under the impression it is 29 lakhs, it is 2 crores.
93 lakhs 81,000.
For that, my submission is decree is silent, therefore it cannot be done. And even the
If there's any mistake in calculation, you can work it out
ನನಗೂ
before.
ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
It's
I
all
don't
part
know.
of record.
ನನಗೂ ಲಾಯರ್ಸ್ ಮ್ಯಾಥ್ಸ್ ನಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ವೀಕ್, ನಾನು ವೀಕ್ ಇದ್ದೀನಿ.
Maths ಅಲ್ಲಿ weak, but figures ಅಲ್ಲಿ ಹೆಂಗ್ ಮಿಸ್ ಆಗುತ್ತೆ?
That I don't.
ಅಲ್ಲಿ ಎಲ್ಲ ವೀಕ್ ಇರ್ತಾರೆ. 2,93 lakhs ಅಲ್ವಾ ಅದು?
ಅದೇನ್ ನಾನು ಬೇಕಾದ್ರೆ ಕೇಳ್ತೀನಿ. If at all he want to negotiation, memo of calculation, what had happened? After that, memo of calculation filed, thereafter no orders have been passed. Then we approached before this court. This court passed an order to pass orders on the memo of calculation. Thereafter, this has.
What you want to do? You want to settle it or I want to dispose it?
It could be settled there, let this order be confirmed, my lord, because they are all in
ಏನ್ ಮಾಡ್ತೀರಾ?
speaking terms, my lord. Because
ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಂತ
ಎಲ್ಲ ದುಡ್ಡು ಇಲ್ಲಿ ಕೊಟ್ಟು ಏನೋ ಸ್ವಲ್ಪ ಡಿಸ್ಕೌಂಟ್ ತಗೊಂಡು ಎಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡಿ ಹೋಗ್ಬಿಡಿ.
ಅದಕ್ಕೆ ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆನೆಸ್ಡೇ
any date, let him take.
ಹೇಳ್ತೀನಿ.
You will get some discount if you
ಆಯ್ತು, I understand.
pay it up in one shot.
He is one of the top builders in man.
ಇರ್ಲಿ.
ದುಡ್ಡಿರೋರೆ ಕೊಡೋದಿಲ್ಲ.
ಕೊಡೋದಿಲ್ಲ ಅಷ್ಟೇ, ನಾವು small time business.
ವೆನೆಸ್ಡೇ ಆರ್ ಥರ್ಸ್ಡೇ.
Then counsel for the petitioners in 32.5 and 32.6 seeks for time. List on
ವೆನೆಸ್ಡೇ ಆರ್ ಥರ್ಸ್ಡೇ.
Wednesday to explore the possibility of a settlement. Yes.
If it's not so, you try.
To explore a settlement, sorry.
All the matters, my lord.
ಹೌದು.
The matters. Yes.
33, C. Shankar Reddy.
Shankar Reddy. There is no representation for the petitioner. List on it. Ravi Shankar,
Serial number 34, urgent serial number 35, P. N. Harish.
P. N. Harish.
Plaintiff's writ petition will questioning the orders on order 1 rule 10. That suit for mandatory injunction and recovery of damages. Contained to the plaintiff is the owner of the A schedule property and B schedule property is in permissive possession of the first respondent, that is the defendant. At the time of evidence, my lord, one person claiming to be, because the first defendant is an institution, one person claiming to be a donor to that institution want to implicate himself as one of the party to the suit. That application came to be allowed. Then, my lord, another two person claiming to be in possession of the property have also filed an application. under R1 Rule 10. That is also came to be allowed. My lord, it is suit for mandatory injunction between two parties, wherein the defendant has clearly admitted I am the owner and they have set up a plea of adverse possession. Now both the applications have been allowed. My lord, the scope of the suit has been widened.
Issue emergent notice. In addition, the learned counsel for the petition is permitted to serve the learned counsel who represented the respondents before the trial court. Interim stay of the impugned order till the next date of hearing.
Obliged.
Number 36, Ganesh G.
List after service of notice to the respondents.
The trial court advocate is not available because we
Who
went and make,
paid?
and we have process paid, Your Honor.
Serial number 37,
Let service be effected. Let us
Krishnamurthy and
mention after the service is effected.
Please, Your Honor.
Hearing for
Krishnamurthy.
petitioner, my giving a citation,
Yes, what is this case, madam?
my
What have you
lord,
challenged?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎರರ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರು, ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಮಾರ್ಕ್ ದ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ. ಸೊ ಐ ಆಮ್ ಗಿವಿಂಗ್ ಅ ಸೈಟೇಷನ್ ಟು ದಟ್. My lords, kindly see page 10, para 13. So it says, nature and character of the possession could be considered collateral purpose, but that was not the point which was directly in list before this court. In our opinion, nature and character of the possession containing flawed document being unregistered in terms of section 107 of the 1882 Act and the section 17 and 49 of the Registration Act can be form collateral purpose when the nature and character of the possession is not the main term of the lease and does not constitute the main dispute of adjudication by the court. In this case, the nature and character of the possession constitute the primary dispute, and hence the court is excluded by the law from examining unregistered deed for that purpose. In respect of suit of which this appeal arises, purpose of lease is the main list, not for a collateral incident. So my only submission is that, my lord, evidence ಅಲ್ಲಿ produce ಮಾಡಬಹುದು unregistered document, even though it is unregistered, only to prove the nature and character of the possession.
Take out
It can
notice,
be
issue emergent notice. In addition, the learned counsel for the petition director serves sponsors also. Yes.
serial number 38, KV Narasimhan.
38, my lord, is the petition filed by the defendant. My lord, a suit for permanent injunction, my lord, came to be filed concerning an agricultural property in 77/2, measuring 19 guntas. My lord, the trial court has granted the injunction and the appeal filed by me, my lord, has been dismissed by the appellate court. My very contention has been this, that the very suit property, my lord, has been sold by the mother of the plaintiffs in favor of my mother. My lord, it is evidenced by a registered sale deed, my lord, at Annexure G, which is dated 4/3/1988. 77/2, my lord, the subject matter of the suit. My lord, is the subject matter of the said sale deed. 19 guntas is the extent. Page number 58, my lord, is the relevant portion of it.
This was not brought to the notice.
It was brought to the notice of the court. The court, my lord, now says, now thereafter, only one thing that had not happened then is, well, the khata was not changed in the name of my mother. Now, even that is ordered now and the khata has been changed. Even that has been, my lord, rectified. Now, very interestingly, what the court below says is, my lord, page number 31.
Now, where is the reference to the sale deed in your statement?
Yes, I have stated so. My lord, page number 15, my lord. ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ಮೂಲತಃ ಒಂದನೇ ವಾದಿಯಾದ ನೂರ್ಜಾನ್ ರವರ ತಾಯಿ ಸಕೇನಾಬಿ ಅಮ್ಮ ಮತ್ತು ಆಕೆಯ ಗಂಡ ಅಬ್ದುಲ್ ಖಾದರ್ ಸಾಬ್ ಅವರು ದಿನಾಂಕ 24/6/54ರಲ್ಲಿ ನೋಂದಾಯಿತ ಕ್ರಯಪತ್ರದ ಮೂಲಕ ಪಡೆದು ಸದರಿ ಇವರ ಪೈಕಿ ಅಬ್ದುಲ್ ಖಾದರ್ ಸಾಬ್ ರವರು ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ. ಇವರ ಮರಣಾನಂತರ ಒಂದನೇ ವಾದಿಯರ ತಾಯಿ ಸಕಿನಾ ಬಿ ಅಮ್ಮ ತನಗಾಗಿಯೂ ಮತ್ತು ತನ್ನ ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಮಗನಾದ ನಿಸಾರ್ ಅಹಮದ್ ರವರ ಪರವಾಗಿಯೂ ದಿನಾಂಕ 4/3/88ರಂದು ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ತಾಯಿ ಜಮೀಲು ನಿಸಾ ಬೇಗಂ ಕೋಮ್ ಲೇಟ್ ಸೈಯದ್ ಗುಲಾಂ ಮೊಹಮ್ಮದ್ ಮಸ್ಕಿನ್ ರವರಿಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ಕ್ರಯ ಪತ್ರವು ಅರ್ಕುಲ್ಗುಡ್ ನಂಬರ್ so and so.
Suit is for injunction, is it?
Suit is for injunction. Now, injunction, my lord, is granted against the true owner. Now, khata stands in my name, encumbrance certificate I have produced.
Issue emergent notice. In addition, the learned counsel for the petition is directed to serve the learned counsel for the respondents. Parties are directed to maintain status quo in respect of the suit shall property. Neither the petitioner nor the respondent shall damage, demolish, destroy or change the nature of the suit shall property till the next date of hearing.
Great.
Serial number 39.
Kevin, this rises out of my suit, my lord. I have filed this declaration suit. Same property, same parties.
Issue emergent notice.
Serial number 40, Girish NR. Serial number
Girish
40.
NR.
My lords, in this matter, the last date, I was directed to produce the IA, dismissal of earlier IA.
Oh, is good. What are the earlier application filed for?
It was for amendment of the plain to include a property.
Then?
The same property was sought to be included in the earlier IA, which was rejected.
Then how can you file another application?
That is my contention. So they have filed again a IA to include a property, same property with a similar application. So it has been allowed by the trial court. On that impugned order, I have filed this writ petition.
What is the stage of the suit?
Suit is now, it is for evidence.
Whose evidence?
It has been remanded and it is for plaintiff evidence. But the reason accorded by the trial court, my lords may take page 14. Therefore, it may lead to multiplicity of, that's the plaintiff has made out grounds to allow application. There is no reason for
Emergent
allowing this.
notice in addition, so on, so on, so stay of the further proceedings before the trial court. Stay of the impugned order, sorry. Stay of the impugned order. Till the next date of hearing, list on sounds. Yes.
Serial number 41, urgent. Serial number 42, Fortress.
May Lordship, impugned order passed by the Kollegala senior civil judge execution petition. So in this case, the petitioner not ignored the
petition not?
Only filed wakalat.
Oh, who are you? You are the judgment debtor?
Yes.
What happened?
Because of government allotted one site in favor of the petitioners. They are not executed, but the respondent ration card ಮಾಡ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕರ್ಕೊಂಡು ಹೋಗಿ ಅವ್ರು ಮಾಡಿಸಿದ್ದಾರೆ.
ಆಯ್ತು, ಇವಾಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಏನಕ್ಕೆ ಹಾಕಿದ್ರು? ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಸೂಟಾ?
ಅಲ್ಲ ಸರ್, ಅದು ಇದು ಪ್ರಾಮಿಸರ್ ನೋಟ್ ಮೇಲೆ ಇದು ಮಾಡಿರೋದು. ಸೇಲ್ಡಿಡ್ ಮಾಡ್ಕೊಂಡಿರೋದು.
ಸೂಟ್ ಏನಕ್ಕೆ ಹಾಕಿರೋದು?
ಸೇಲ್ಡಿಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಇದು ಮಾಡಂತ ದುಡ್ಡು ಕಟ್ಟಿ ಕೊಡಂತ ಹಾಕಿರೋದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್.
ದಯವಿಟ್ಟು ಪ್ಲೈಂಟ್ ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ಪ್ಲೈಂಟ್ ಕಾಪಿ ಹಾಕಿಲ್ವಾ?
ಪ್ಲೈಂಟ್ ಹಾಕಿಲ್ಲ. ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ
ಎಲ್ಲಿದೆ?
ಅನಗ್ಯರ್ ಅನಗ್ಯರ್ ಸಿಂಗ್
5,02,500 ರೂಪಾಯಿ ಕಟ್ಕೊಡಕ್ ಹೇಳಿದ್ದಾರೆ.
5,92,872 ಇದೆ ಇಪಿ ಪಿಟಿಷನ್. ಬಟ್ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿ ಬೇರೆ ದುಡ್ಡು ತಿನ್ನಕ್ ಹೋಗಿದ್ದಾರೆ ಅವರೆಲ್ಲ. ಅದು ಡಿಕ್ರಿ ಆಗ್ಬಿಟ್ಟಿದೆ. ಈಗ ಎಜುಕೇಶನ್ ಪಿಟಿಷನ್ ಬಂದು
ಏನ್ ಮಾಡ್ತೀರಾ ಅದಕ್ಕೆ? ಈಗ
40,000 ಕಟ್ಟಿದ್ದಾರೆ. ಆದ್ರ ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿ ಅರೆಸ್ಟ್ ವಾರಂಟ್ ಹೋಗಿ ಕಟ್ಟಿದ್ದಾರೆ. ಅವ್ರಿಗೆ ಆರಾಮಿಲ್ಲ ಸ್ವಲ್ಪ ಕೋರ್ಟ್ ಮೇ ಬಿ ಇಂಟ್ರಿಮ್.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ? ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಸುಮ್ನೆ ಸ್ಟೇ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಅದೇ 50% ಕಟ್ತೀರಾ?
25%
ಬರ್ಕೊಡಿ.
30% ಮೇಲಾಡ್ಸಿ.
50% ಆದ್ರೆ ಸ್ಟೇ ಕೊಡ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
40,000 ಕಟ್ಟಿದಾರೆ ಆಲ್ರೆಡಿ.
50% ಇನ್ಕ್ಲೂಡಿಂಗ್ ವಾಟರ್ ಯು ಆಲ್ರೆಡಿ ಪೇಯ್ಡ್. 50% ನೀವೇನ್ ಕಟ್ಟಿದ್ ಸೇರ್ಕೊಂಡು 50% ಕೊಡಿ. ಬರ್ಕೊಳ್ಳಿ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ in an additional learn so on so till the next date of hearing, the proceedings in EP number EP number 11/2020 on the file of the senior civil judge at Kollegala is stayed subject to the petitioner depositing 50% of the amount, including the amount already deposited.
Reduce the percent
of the amount claim made in execution, including the amount already deposited within a period of 2 weeks from today.
6 weeks. 4
weeks from today. Yes.
please,
It
please.
is it made clear that if the deposit is not made, the proceedings in the
6
execution
week,
shall.
my lordship, 6 week.
Next.
Serial number 43, R. Gopal.
But I appear for the petitioner. In this case, my lord, I am challenging the order passed in the MA, granting my lord injunction by reversing the judgment of the trial court, my lord. Injunction is granted restraining me from putting up the construction, my lord. Suit is filed for declaration and for mandatory injunction for removal of the structure, my lord, put up in B and C schedule properties, which according to him forms part of A schedule. My lord, I am having title, my lord. I have produced documents. Trial court, my lord, considering my documents has said, my lord, there is no encroachment. Encroachment is not proved. And I am putting up the construction, my lord. Therefore, injunction can't be granted. Balance of convenience will work out against me. Greater hardship will be on me. The appellate court, my lord, at page 31, reverses, my lord. Now, I put up the construction except plastering
I called
and
the PP
flooring
in
and
to
my lord,
I messaged him,
Photograph.
but you tell him the same thing. That we sought for.
that there is absolutely no encroachment. I am putting up construction, my lord, in my plastering and fixing, my lord, shutters to the doors, my lord, and
What is the order granted by the appellate court?
appellate court is, my lord, directing, restraining me from putting up construction. For the first time, the appellate court granted. By that time, my lord, I had already put up construction.
Oh, memo kudi then.
Yes. And my lord, in the suit itself, he has sought for mandatory injunction for demolition of the structures in B and C schedule property.
Memo kudi. The learned counsel for the petitioner has filed a memo enclosing therewith a photograph of the building as it exists today.
Today.
Full
As
stop.
it exists on the date of the order, my lord, on the date of the order of the appellate court, my lord.
Change ಆಗಿಲ್ವಲ್ಲ ಅವತ್ತಿಂದ.
ಅವತ್ತಿಂದ change ಮಾಡಿಲ್ಲ. ಅದ್ರ ಮೇಲೆ ನಾನು ಏನು ಮಾಡಿಲ್ಲ.
So as it exists today. Full stop. Since the plaintiff has sought for mandatory injunction. But ಅವ್ರು ನೋಟಿಸ್ ಕೊಡದೆ ಈ ತರ ಆರ್ಡರ್ ಮಾಡಿ ತಪ್ಪಾಗುತ್ತಲ್ವಾ? ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ, ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿ. ನಿಮಗೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಕೊಳಕ್ ಪರ್ಮಿಷನ್ ಕೊಡಕ್ ಮುಂಚೆ ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕಲ್ವಾ? ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್.
Serial number 44, Santosh S. Gogi.
That I will place the photograph.
Pretty good.
I appear for petition.
This is my notes against my notes in allowing amendment application, my notes. Beyond 120 days, my notes in 34 procedure arbitration proceeding.
Allowing what?
Allowing amendment application, my notes. Beyond my notes, 120 days, my notes. And also my notes, a new ground is taken.
What do you mean by that? Allowing an amendment application beyond 120 days andre?
Beyond 120 days where the 34 minutes, 3 provides for minutes, filing 34 petition is 90 days minutes and discretion.
34 is 120 days, but what is this amendment within 120 days andre?
Well, beyond 120 days of minutes.
Appeal is filed beyond 120 days.
No, appeal is filed in minutes in time.
In time.
But minutes, new ground minutes urged in by amendment application minutes, that application is filed beyond 120 days.
Where is the time? Where is the time prescribed?
Minutes, that minutes, when minutes initially when matter got gone up to Supreme Court minutes, lordships have directed.
This amendment application is filed to introduce additional grounds.
Yes, ma'am.
Beyond 120 days.
Please.
What is the law on that?
That minutes may permit minutes, that issue has been kept open minutes while this very matter minutes went into up to Supreme Court in minutes earlier round minutes. That minutes in order would find minutes annexure F minutes.
Earlier, they have not filed objection to that application matter. Straight away, that application has been allowed. That's right.
Annexure F minutes in page 93 and relevant para is at 94 minutes. Minutes para 5 minutes. The issue as to whether the application for amendment could have been entertained beyond the period prescribed for filing an arbitration petition under section 34 of arbitration. is expressly kept open. Hence, it would be open to petitioner to oppose the amendment on the ground beyond this limitation. Therefore, my lords, in view of
What
that
is
issue being kept
Sir,
open.
beyond the period of limitation then,
My lord, the very, my lords, new ground, my lords, is nothing but, my lords, are filing a fresh petition, my lords, of a 34, my lords, where the limitation prescribed for filing a petition at 34, my lords.
Ashtena?
And, my lords, a new ground, my lord, which is not as a lead foundation, my lords, in the petition, my lord, that is one more. In that regard, my lords, I would like to rely upon one judgment.
Is there any judgment which says that after 34 petition is filed, there can't be any application for amendment? No, because that would amount to filing a fresh appeal.
So far as new ground, my lords, it's not permissible, my lords.
Yeah, those,
My lords, page number 32 of my lords, judgment, my lords.
page number 32.
32. Head note B, my lords. Application seeking to add absolutely new grounds in a memo of appeal for which no foundation had been laid in application for setting aside award, held rightly rejected by the appellate court. More so when the amendment of application under section 34 had not been sought either before court of first instance or before the appellate court, and only a memo of appeal was sought to be amended. So, my lords, there's one new ground, my lords, which is they wanted to.
Yes, what is that new ground?
That, my lords.
Page 90, my lord.
Yes.
10A. Earlier on the same application, the matter has come before this honorable court.
Who is this man?
This honorable court already rejected their application.
Huh?
This matter has already come before this honorable court on the same application, my lord. So
Application is rejected or allowed?
their application, petition rejected.
That
Amendment
in fact-
application is allowed
in
and
fact, that went to the
direct
lords.
them to file objection to the amended petition. ma'am. Sorry.
Where is the impugned order?
Annexure A, my lords, in page, relevant page at my lords, 40, my lords.
Yes.
My lord, this, my lords, a new ground, which is, my lords, not raised before the learned arbitrator. my lords.
Where is the appeal under section 40, 34? Petition 34.
34 petition, my lords.
Interest ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Annexure C, my lords. Page number 67, my lords.
Yes. Impugned order. Impugned order is at page number 40, my lord.
Yes, Mr. He has already made a ground, urged a ground.
No, my lord, that is, my lords, related to future interest, my lords. So far as the contention, what is read in 10A, my lords, is that, my lord, they today,
Not
my
10A,
lord, for
please
first
come to para 10,
10 of, my lords.
page 74. Honorable arbitrator, the first respondent herein, without considering the same, allowed the claim petition filed with the respondent awarding exorbitant interest at the rate
Yes,
of
ma'am.
24% per annum which is against to MSME Act. And say, basis idiyalla.
No, my lord, this is, my lord, allowed the petition filed by respondent awarding exorbitant interest at 24%, which is against the MSMD. That is, my lord, the future interest is related because that is what they extracted by.
So what now he says is that you are not registered. The entitlement to claim interest under the MSME Act would arise after you get registered.
Yes, my lord, he is, my lords, now want to insert, my lords, where, my lord, before registration, the interest portion which has been, my lords, claimed, he want to register that for the first time before, my lords, in 34, in the amendment application, not before that, my lords.
There is some basis for seeking an amendment.
My lord, that is related to, my lords, of future interest, my lords. Kindly see issue number 4, my lord, that was, my lords, which was answered, my lord. In regard to that, my lord, it has been raised. Kindly see, my lords, the impugned order. Where, my lords, page number 49.
Yes.
Issue number 4 was extracted by the commercial court, my lords. Whether the claimant proves that they are entitled to future interest at the rate of 24% per annum or as prescribed under MSME Act 2006. It is not, my lords, related to, my lords, which now he wanted to contend. I cannot claim, my lords, an interest related back to, my lords, before registration of MSM. Otherwise, I would have an opportunity before learned arbitrator to, my lords, it's nothing but, my lords, reopening the entire proceedings of the arbitration itself, my lords.
What is the arbitrator awarded?
Arbitrated awarded, my lords, is a 24% rate of interest, my lords.
From the date of the claim petition?
From date, my lords, entitled, because in MSME, my lords.
From the date of registration?
Yes,
No,
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 my lords.
No,
From
no,
date
even
of the
earlier,
amount
even earlier.
due, my lords. From date of amount due, my lords.
From the date of amount due?
Yes, my lords.
Yes.
Because when claim petition is submitted along with the calculation of, my lords, in a rate of 24%, because that was agreed rate of interest under the invoice, as well as, my lords, MSME provides for that, my lords, in the that 24%. And under invoice also, my lords, in 30 days, if failed to pay, my lords, it is agreed rate of interest is 24%.
Yes. So this obviously relates to future interest.
No, my lord,
This amendment that
there,
is.
my lords, in amendment is not related to future interest.
Both
He's
is-
asking,
both-
he is, my lord, saying that before registration interest claimed, I'm not entitled for 24% as per the MSME Act, my lords. He's talking about, my lords, an interest related before registration. That was not raised before, my lords, in learned arbitrator. And not even in 34 petition. Only for first time in the petition, my lords, in the amendment petition, he wanted to contend. Therefore, my lords, considering that aspect of the matter, my lords, Honorable Supreme Court, while, my lords, referring back, my lords, kept open that issue, my lords, whether they are permitted to file that in beyond 120 days also, my lord, that was also one consideration which was kept open by the Honorable Supreme Court.
How did this matter reach the Supreme Court?
My lords, against the amendment order, my lords, amendment was allowed, saying that it is a typographical error, my lord, against which I came before this Honorable Court. And this Honorable Court directed me to, my lords, giving liberty to file, contend all this, my lords, in the statement of objection. Then, my lords, it went to Honorable Supreme Court, my lord. There, my lords, court, having noticed that, my lords, it is beyond 120 days, my lord, keeping that issue open, my lords, had sent it back. Then we filed a statement of objection because we had not filed a statement of objection to the amendment application.
Where is order passed in 11/463?
This is
Told you then.
earlier.
There are two matters, my lords. Another is listed in serial number 39, list 2, my lords.
No, but where were you supposed to oppose this amendment?
I filed objection, my lord. After remand from the Honorable Supreme Court, I filed a statement of objection. That is at, my lords, page number.
As per the direction of the Supreme Court, they have filed an objection. This Honorable Court directed to straight away file amended petition.
So you filed objections to this?
Thereafter, on merit, this application has been allowed.
Yes.
Annexure G is my statement.
Yes, Mr. What is the basis for this amendment?
My lord, even my lord, issues has been raised even before the arbitrator. Whether the claimant proves that they are entitled for future interest, the rate of 24%, Your Honor, as per the MSME. But only thing is, my lord, is a question of law.
Where is the issue? Where is the issue?
49, man. It has been stated so in the
Page 56 minutes of award.
impugned order, it has been stated. Award also it has been stated.
Whether the claimant proves that they are entitled to future interest at the rate of 24% per annum or as prescribed under MSME Act.
This issues is already raised before the trial, arbitrator, my lord. But only thing is, elaborately we have stated before this honorable court, that's all, my lord.
No, you are saying pendenti lite interest.
No.
Pendenti lite, you are saying that they are entitled to interest from the date they were registered under the MSME.
Yes, it is a question of law, my lord.
Question of law, but what prevented you from urging that?
So every issues in respect of MSME Act itself before the court, my lord. Only
Not
thing
the
is, that's why, my lord, the trial court.
Now, have you raised any contention before the arbitrator that the petitioner was not entitled to interest at 24% per annum under the MSME Act unless he was registered on
Not
the
specifically stated, my lord, but as per the MSME Act, he is not entitled for the interest.
ಫ್ಯೂಚರ್ ಇಂಟ್ರೆಸ್ಟ್ ಬಗ್ಗೆ ಹೇಳಿದಿರಪ್ಪ ಪೆಂಡೆಂಟಿಲಿಟಿ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ ಅಂತ ಕೇಳೋದು.
Overall, he is not entitled for 20% for interest as per the MSME Act we have stated somewhere.
ನೀವು ದಯವಿಟ್ಟು ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿ. Please go to your statement. Come to page number 87.
87. $87. $87, my lord, that is
my lord's
their
my
objection.
objection before.
This is the petition before the
Commercial court, my lords.
commercial court, my lord.
ಅದೇ ನಾನು ಕೇಳ್ತಿದ್ದೆ.
In fact, my lords, statement of objection, statement of objection to claim before learned arbitrator, my lords, may permit to produce.
ಅದರಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
Nothing in this.
Please go through it, mister. ನೀವು ಇಲ್ಲಿ ಬಂದು ಹುಡುಕಿದ್ರೆ ಹೆಂಗೆ? Have you raised this contention in the objections?
No, my lord.
ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ನೀವು.
My lord.
ಮೈಲಾಡ್ ಅಂದ್ರೆ ಏನು ಉಪಯೋಗ?
No, my lord.
ನೀವು ನೋಡ್ಕೊಂಡ್ ಬರ್ರಿ ಹಿಂದೆ ಆ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. Have you ever anywhere during the proceedings claimed that they are not entitled to pendenti lite interest at the rate of 24%? ಎಲ್ಲಾದ್ರೂ ಹೇಳಿದ್ರೆ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. Don't search for the file here.
Matter is coming up on 30th, my lords.
Let it come. ಯಾವತ್ತು ಬೇಕು?
30th.
ಸೋಮವಾರ. List on Monday.
Let them not proceed because they are ready with the argument on day before yesterday.
No, I will
opposing
not. I
that,
will not
despite I saying that petition.
No, I will not further proceed with it.
The learned counsel for the respondent undertakes not to press for hearing the commercial appeal before the trial court. The submission is noted. Yes.
Hello.
The learned counsel for the petition has filed a
One request, the serial number second list 39, my lords, is also connected, my lords.
39.
Please, my lords.
Arising out of the same proceedings?
Same, both are went together, my lords, at same transaction, my lords, but only that their company and proprietorship, my lords.
See number 13 and the same order.
And both may be connected, my lords.
Say MS Vishwanath.
Yes, ma'am. Same.
Same.
Both may be connected.
Our office is directed to list both these petitions together. Yes. Mr. Yugandhar. Memo is filed by the learned counsel for the petitioner. But the writ petition has become infructuous since the petitioners already delivered possession of the suit property.
Yes.
In view of the memo, the petition is dismissed as having become infructuous.
List number 2 for fresh matter, serial number 37.
Petitioner in this matter, my lord.
37, no?
So the impugned order is the land trial court passed order. Accept, please. Accepting the commissioner report, my lord. The suit is for the Schedule A property for declaration, my lord. Out of which Schedule C, B and C is regarding encroachment made by the respondent number 1 and 2, my lord. That is 13 and 27 guntas respectively. Commissioner appointed, my lord, the memo of instruction filed. The commission work is done, my lord. Wherein the report is submitted very contrary to the memo of instruction, my lord, as well as in fact, we filed objection for that commission report. That is been considered by the learned trial court, my lord. The learned trial court, without recording proper reasoning, my lord, it is simply said that the commission, my title has to be proved independently. So it will not have any effect, my lord. Lordship, kindly see the page number 17, my lord. Impugned order.
No, but let the trial court decide whether the.
No, my lord, it is a vital piece of evidence, my lord. It shall form the records of the suit papers, my lord. The lordship kindly see page number 17, my lord. The first line in the commission report itself is not a document to prove the case of the plaintiff. The plaintiff has to prove his case independently. He cannot rely on the commission report to prove his title over the suit schedule property. To prove the case of the plaintiff, he cannot depend upon the report of the court commissioner. Since it is a title suit, the burden is on the plaintiff to prove his title to the so and so, my lord. The very purpose of appointing the court commissioner is in relating to the encroachment, my lord. It is the very vital, this, my lord, the report may kindly be perused, my lord, at page 66. It's also, my lord, the very, this very partition deed, that is a title document, my lord. Without referring into my partition deed. And he, in deposition also, he admits that, my lord.
For what purpose the commission was appointed?
Only regarding encroachment, my lord, so far as Schedule C and B and C properties are concerned.
Yes. What does the commission say?
Deposition may kindly be.
What does the commissioner say?
The commissioner says that, my lord, there is no encroachment. And he shows that there is a little encroachment. It is 4 guntas. It's by the defendant number 1.
Have you filed objections? Have you filed objections?
Objection I have filed, my lord.
Really there?
Lordship, kindly see the objection annexure R, my lord, page 78. May I read, my lord? Page 78. By order dated 29/11/2023, ADLR Mudugere has been appointed as court commissioner. But the court commission work has been carried out by some other person. And the ADLR has merely signed the report and all other annexes, including sketch as if he himself is the author of those documents records. As the said commission work cannot be delegated by ADLR Mudugere. The execution of the commission warrant itself is without jurisdiction, and on this count alone, the report said to have been submitted by the court commissioner is liable to be rejected. Then second point, my lord, the taking advantage of the directions of this honorable court, the ADLR need not wait for the service of notice to the parties and being on over by the defendants, and in order to help them, the defendants have been made to stay away from the proceedings of the commission work. The person who has executed the commission warrant has not at all followed the letter and spirit of the memo of instructions of the plaintiff, and therefore the report submitted by him is liable to be rejected. Then, my lord, the next paragraph, the court commissioner has not at all visited the plaintiff's scheduled property and carried out the commission work as per the commission warrant, a memo of instructions as submitted by the plaintiff. The deposition.
One day condition. He has not visited this A property.
Yes, my lord, that is one aspect.
How do you justify that?
Lordship, kindly see the.
Where is the report of the commissioner?
Page number 66, my lord.
What does he say?
Annexure Q.
What does he say?
Typed portion, page number 67, my lord. ಅಳತೆ ಮಾಡುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯದಿಂದ ನೇರವಾಗಿ ದಿನಾಂಕ ನಿಗದಿಯಾಗಿ ಆದೇಶವಾದ ಅಳತೆಗೆ ಹಾಜರಾಗಿದೆ. ವಾದಿಯವರ ಶೆಡ್ಯೂಲ್ ಎ ಸ್ವತ್ತನ್ನು ಪರಿಶೀಲಿಸಿ ಅಳತೆ ಮಾಡಿ ಸ್ಕೆಚ್ನಲ್ಲಿ ತೋರಿಸಿದೆ ಮತ್ತು ಶೆಡ್ಯೂಲ್ BC ಯನ್ನು ಅಳತೆಯಿಂದ ಸ್ಕೆಚ್ ತಯಾರಿಸಿ ಒತ್ತುವರಿ ಬಗ್ಗೆ ತೋರಿಸಿದೆ. ಅಳತೆಯಿಂದ ಪರಿಶೀಲಿಸಲಾಗಿ ವಾದಿಯವರು ಸ್ವಾಧೀನಾನುಭವದ ಉತ್ತರ ಭಾಗದಲ್ಲಿ ಸ್ಕೆಚ್ ತೋರಿಸುವ ಬ್ಲಾಕ್ 4 ಗುಂಟೆಯನ್ನು 1ನೇ ಪ್ರತಿವಾದಿಯು ಮತ್ತು ಬ್ಲಾಕ್ 4 ಪ್ರದೇಶವನ್ನು ವಾದಿಯವರ ಹೆಸರಿನಲ್ಲಿ ತಿಳಿಸಿರುವ ಪ್ರಕಾರ ಬೇರೊಬ್ಬರಾದ ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಎಂಬುವರು ಒತ್ತುವರಿ ಮಾಡಿರುವ ಬಗ್ಗೆ ಶೆಡ್ಯೂಲ್ B ಸ್ವತ್ತು ಆಗಿರುತ್ತದೆ ಹಾಗೂ ಸಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಾಗಿರುವ ಸ್ಕೆಚ್ ನಲ್ಲಿ ತೋರಿಸಿರುವ ಬ್ಲಾಕ್ 3 1 ಎಕರ್ 12 ಗುಂಟಾ ವಿಸ್ತೀರ್ಣವನ್ನು ಸರ್ವೆ ನಂಬರ್ 163 ಹಿಡುವಳಿದಾರರಾದ ಶ್ರೀಮತಿ ದೀಪ್ತಿ ಕೋಮ್ ಉಮೇಶ್ ಎಂಬುವರು ಒತ್ತುವರಿ ಮಾಡಿರುತ್ತಾರೆ. ದೀಪ್ತಿ ಕೋಮ್ ಉಮೇಶ್ is my lord, she is not a neighborer. Her land is situated somewhere else, my lord. That is been also shown. Lordship, deposition may kindly be permitted, have not produced, wherein he admits several defects and lapses committed by him. Lordship, kindly.
Only take out notice.
Lordship, it is for final arguments, my lord, Monday ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮಾಡಿ serve ಮಾಡ್ಕೊಂಡು.
ಅಲ್ಲ, deposition he admits several things, my lord. This
Serve
Monday,
and come back.
Monday is for final arguments.
Counsel for the petitioner seeks issue emergent notice. It is open for the petitioner to
This
serve
is
the
the next date of
non-counsel for
hearing.
the respondent before the trial court. List on ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
In Monday ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ.
Stay.
Any interim order, my lord.
No
ಅಲ್ಲ, ಅಲ್ಲಿ
stay.
ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ arguments ಗೆ
No
final
stay, please
argument.
argue the matter. Yes, next ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
38.
ಯಾವತ್ತು ಬೇಕು.
Any Wednesday,
ಅಷ್ಟೊಳಗೆ ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೀರಾ?
local advocate. But they said no objection for commission.
On Wednesday, yes, next.
Serial number 38, Chandrasekhar GM.
This is the judgment debtor's petition and suit filed by the decree holder for a money recovery suit. And the suit was decreed, against which I preferred an RA, that also dismissed, confirming the suit judgment, against which both the judgments I challenged before this honorable court in RSA in the last week, Marat. It is in time, Marat. And that is also one streamline. On the other hand, during the pendency of the RA, the decree holder filed an execution petition for executing the judgment and decree passed in this suit, Marat. So that was because of stay granted in RA, that was goes on for further orders. On the one fine day, that is on 25/9/2024, and after disposal of the RA, he has brought it to the notice of the executing court by furnishing the said judgment for taking on record. That was on 25/9/24. It is at Annexure C. That is running page 67. Typed copy is at relevant portion is at money recovery and all. Anyway, it has been exhausted. Straight away, the next page of the order sheet, very next day, he has advanced the said execution petition by filing an application for advancement as well as application under Order 21 Rule 65 for sale of the suit scheduled property. Your Lordship may kindly have a look into that order sheet also in the next page. 26/9/2024. Sri decree holder advocate filed an advancement application to take some urgent orders. Next, in the order sheet, case advanced advocate for decree holder filed an application under Order 21 Rule 65. CPC also not along with the verifying affidavit by memorandum of facts of the advocates. And office is hereby direct to issue sale notice to the IA scheduled property, call on regular date.
Have you appealed before the executing court?
Previously, prior to advancement application, I filed my wakalat. And subsequently, on the advancement application, it was part of the duty of the decree holder advocate to serve the copy of the advancement, as well as IA under 21 Rule 65 also. However, the learned executing judge, without affording an opportunity to file my objections to the said IA, he has proceeded with the matter and ordered for sale of the
deposit matter.
notice.
Which will you deposit?
And your lords may kindly notice, I will come to that matter. Kindly subsequent next date of order, your lords may have a look into. On the next regular date minute, that has been not been heard and not given an opportunity. And the next regular date minute on
But please tell us
23/10.
how much will you deposit?
Let's say,
Sorry.
in the next sale proclamation also, you have not given an opportunity. Direct straight away passed an order of
Take,
sale proclamation.
You want to deposit?
Yes, my lord, I will deposit. I have paid the court fee also in the RSC 1,19,000. I am right now, he is an agriculturist. On the other hand, he is an harvested the maize. I'm fairly submitting that one more 1 lakh rupees I will deposit.
No, no. Then issue notice.
And my lords, your lords may kindly decide.
1 lakh, no, sorry.
Kindly decide that amount.
50%.
My lord, your lords may kindly notice that 9 lakh is there. 3 lakh I will fairly.
9 lakh ಅಲ್ಲ 13 ಲಕ್ಷ ಇರೋದು.
ಅಲ್ಲ, interest ಇದೆ. Main principal amount is 9 lakh.
13 lakhs is the execution.
Yes,
claim.
yes. My lord,
emergent notice.
utter procedural lapse, my lord, by the executing
I'm
court.
staying that.
Yes.
I'm accepting your case. I'm staying that.
And 3 lakhs I am submitting.
No, sorry. Issue emergent notice.
And
petition
kindly
for the
express
petition is
your
submitted
lordship's opinion for that.
To,
3 lakhs, my lord.
3 lakhs ಇಲ್ಲ. No, no.
Allah is an agriculturist, my lord, not a businessman. Otherwise, I would have myself.
Bad ಅಂದ್ರೆ bad.
Allah,
Don't want, I'll
kindly decide that.
issue emergent notice. It is open for the petitioner to serve the loan counsel for the respondent before the trial court. Yes,
How
next.
much I have to pay? My lord?
50%. 50% of the execution claim.
Anyway, 6 weeks maybe correct.
ಅವ್ರಿಗೆ ಯಾರಿಗೊಬ್ರು 4 weeks ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಅವ್ನು ಈ ಹಾರ್ವೆಸ್ಟ್ ಮಾಡಿದಾನೆ, ಎಷ್ಟು ಸೇಲ್ ದಿ ಮೇಜ್ ಅಂಡ್ ಆಲ್ ಡೂ ಇಟ್. ಅಗ್ರಿಕಲ್ಚರ್, ಅದರ್ವೈಸ್ ಬಿಸ್ನೆಸ್ ಮ್ಯಾನ್ ಅದಾಗಿದ್ರೆ
ಏನ್ ಮಾಡಿದೆ? ಬಿಸ್ನೆಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇಟ್ ಇಸ್ ಎ ಪ್ರೊಸೀಜರಲ್ ಲ್ಯಾಪ್ಸ್ ಕಮಿಟೆಡ್ ಬೈ ದಿ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ my lord and all.
Is there a procedure lapse in passing a decree?
Yes, my lord, he has also not getting any money lenders act. 5 business he has also admitted in the.
ಸಾಲ ತಗೋ ಕೇಳ್ಬೇಕಾಯ್ತು ಲೈಸೆನ್ಸ್ ಇದೆಯಾ ಅಂತ. Why did you take the
ಎಲ್ಲ
loan?
ಕೇಳಿದೀವಿ ಸ್ವಾಮಿ ಅದನ್ನ.
ತಗೋ ಕೇಳ್ಬೇಕಾಯ್ತು.
He himself admitted.
After taking the loan, you will have all kinds of defenses.
ಅಲ್ಲ,
Taken the loan, you're bound to repay it.
ಅಲ್ಲ,
50% within 4 weeks.
Please.
Yes. It is made clear that if the amount is not deposited, the execution court shall proceed in accordance with law.
Serial number 39, urgent, serial number 40, Mohan BK.
BK Mohan.
My lord, I represent for the appellant in this case, my lords. My lord, in this case, what has happened is the plaintiff, who is the respondent herein, has filed a suit for recovery before the trial court, my lord. During the pendency of the suit, the plaintiff dies. In fact, the plaintiff was a proprietrix of the hospital, my lords. Thereafter, instead of the legal heirs of the plaintiff coming on record, a partnership firm files directly an impleading application, an amendment application, seeking permission to bring themselves on record, my lords, without wakalat, without impleading application also, claiming that the hospital was taken over by them earlier. And the trial court, without even permitting me to file my objections to the amendment application on the same day, it is allowed, and even the plaintiff is allowed to be amended, my lord. Now, if at all the partnership firm cannot be the legal heir of the plaintiff, my lord. If at all the partners are the children of the original plaintiff, they should have come as the legal heirs.
Yes, Mr. Mohan.
My lord, sir, am I audible now, my lords?
Yes, yes.
My lord, in this case, what has happened is, originally a suit was filed for recovery by an hospital, my lord, represented by its proprietrix.
No, represented by partner ಅಂತಿದೆಯಲ್ಲ.
First, originally it was a proprietrix of the hospital, my lord. And during the pendency of the suit, the said proprietrix dies. And a partnership firm where the partners claim that they are the children of the original proprietrix, they directly files an amendment application to amend the petition and bring their partnership or to substitute their partnership firm as the plaintiff. Instead of coming as the legal heirs of the original plaintiff, they directly file an amendment application, and even that too without even wakalat being given, my lords.
Yes.
The trial court, even without permitting to file objection the same day,
Please take out notice, issue emergency
my lords,
notice.
in the meantime, the further proceedings may be stayed, my lord, because it is posted for cross-examination.
Cross-examination of?
Cross-examination of the plaintiffs, my lord. They
Huh.
cannot become a party unless they file the wakalat and get them implemented as the legal heirs, my lords.
But they're not brought on record as of
They are
now.
not, High Court has, I mean, the trial court has allowed the, this thing, my lord, amendment application.
Issue emergency notice. In addition, learned counsel for the petition is permitted to serve the learned counsel who represents the respondent before the trial court till the next date of hearing. The impugned order is state list on date put. Om Shri Krishna.
19th December.
Creative
Number
blessing.
41. Om Shri Krishna.
My lords, I appear for the petitioner, my lords. My lords, if this matter can be passed over, my lords.
Learned counsel for the petitioner seeks time list on.
3rd December.
Yes.
Serial number 42 urgent, serial number 43.
Latif.
Latif B.
Lord, two applications were filed, Lord, in FTP after drawing the final decree proceedings. Lord, the one is to carry out the amendment of the western side of the schedule of the property. And another application, Lord, on the basis of the survey report, the sketch was drawn, Lord, in that also there is a correction of the western boundary of the property, item number 2 property. One application was allowed, Lord, and consequently the trial court has held that since the application for amendment of decree was allowed, consequently the other, the correction in the sketch has to be, we have to take.
Notice, issue
Please.
emergency notice.
Serial number 44. Sudhindra S.A.
I'll take hand summons.
In addition, learned counsel for the petition is permitted to serve the learned counsel who represented the respondents before the trial court.
Please.
I appeal for the respondent caveat on this matter.
Sudhindra S.A.
Petitioner, my lord. Kindly pass over.
Pass or yellow, naku.
Monday.
My lords, Monday I have some difficulty.
Any date,
List on date put.
Lords, may I request for after 10th of December, man?
please.
List on after 10th December.
11th December.
Mustaq Ahmad.
Very well.
Serial number 45. Mustaq Ahmad.
The respondent has filed the suit for specific performance. The suit was decreed, my lord, and execution is filed. After service of the notice, the matter was settled for sum of rupees 13,50,000. Exhibit annexure G, my lord, page 104.
Yes.
In the said agreement, the petitioners have paid rupees 7 lakhs by way of cash by arranging, and they issued check for 2,70,000.
Yes.
Check is also passed. Thereafter, what happened? He has filed the draft of the sale deed, and it is registered, madam. Amount tagoltare now you kodbekagirodu you have to pay rupees only 3,50,000, madam.
Registering agutte?
Through sub-registrar office. Yeah, through court is registered agide. After decree, he has filed execution.
Where is the decree? Decree illide.
Jai. Malade. Page number 53, malad. Decree to execute the sale deed anta agide. He has filed execution after judgment and decree. Malad, with the intervention of the friends and well-wishers, matter is settled for 13,50,000.
If you have settled it outside the court, can't help.
Like he undertakes, he will not move the case. Agreement he has executed. He himself has executed. Page 104, annexure G, malad. ಹಣ ಸಂದಾಯ ಕರಾರು ಪತ್ರ ತುಮಕೂರು ನಗರ KR ಬಡಾವಣೆ ಹೆಬ್ಬಾರ್ ಬಿಲ್ಡಿಂಗ್ ಮಾಲೀಕರಾದ್ರ ಇವನ್ ರಮಾನಂದ ಅವರ ಮಗ ಸುಮಾರು 46 ವರ್ಷವುಳ್ಳ ಅರುಣ್ ಹೆಬ್ಬಾರ್ ಅದ ನಾನು ಬರಾರು
Any settlement has to be before the court. A decree ಹೋಗ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ಆಮೇಲೆ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ಹೇಳಿ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಹಾಕ್ಬೇಕಂತ ಹೇಳಿ ಆಗಿತ್ತು. ರಿಮೈನಿಂಗ್ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ಕೊಡಬೇಕಾಗಿತ್ತು. ಬೈ ದಟ್ ಟೈಮ್ ಸೇಲ್ ಡೀಡ್ ಆಲ್ಸೋ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Emergency notice.
ಸ್ಟೇ ಮೇಲೆ ಪೊಸಿಷನ್ ತಗೊಂಡ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
Sorry. Yes, next. Show emergency notice in addition so and so. Yes, next.
Number 46.
ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಮೇಲೆ ಪೊಸಿಷನ್ ತಗೊಂಡ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಸರ್.
ಏನ್ ಮಾಡೋದು?
Till next date of hearing.
Mister, there's a suit for specific performance, decree, execution ಆಗ್ತಾರೆ. ನೀವು outside the court settlement ಮಾಡ್ಕೊಂಡ್ರೆ what can be done?
Till then,
No.
otherwise he may, if he taken the
You should have
position.
gone before the executing court and said that. Why did you not go?
We are staying in the residential house, my lord. The
Sir
parties,
ಮಾಡ್ಕೊಂಡ್ ಬೇಗ ಸರ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
la, till then, my lord,
sorry.
at least status come, my lord.
ನೀವು ಸರ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, I'll consider.
I am permitted to serve the copy to the council who is appearing.
ಹೇಳಿದೆ.
Serial number 46, Sarath S. Bogi.
Sharath is Gogi.
Appearing for petitioner, your lordship. I am the defendant number 4 in the suit, your lordship, wherein the suit is challenging the fresh general body meeting and to conduct the fresh general body meeting, your lordship. Wherein the plaintiffs has filed a memo for deletion of defendant 1-4 to 18, your lordship. The trial court without the proper application has accepted the memo and deleted, your lordship.
He doesn't want to proceed against you.
Your lordship, respondents, defendants in that suit are club and the president of that club, your lordship.
Who are you?
I am the member of the club, your
So he
lordship.
doesn't want to pursue the suit against you.
They want to proceed with the collusive decree, your lordship, wherein,
Then you file an application, come on record if you want to.
yes, your lordship.
ಬರ್ಕೊಳ್ಳಿ. The defendant number 4 in OS number so and so on the file of so and so has filed this petition challenging an order dated so and so by which a memo filed by the plaintiffs to delete the names of the defendant number 4 from the array of parties was allowed. Next para.
4 to 18, your lordship.
Yeah?
4 to 18.
4 to 18 was allowed. Next para. The plaintiff filed OS number so and so for following reliefs, copy mount. The defendant number 4 in the suit was also a member against whom no specific relief was sought for. Full stop. Later, the plaintiffs filed a memo to withdraw the suit, to delete the defendant number 4 to 18 from the array of parties. The said memo was entertained by the trial court and the defendants 4 to 18 were ordered to be deleted. Being agreed with the said order, the plaintiff, the defendant number 4 is before this court. The law and counsel for the plaintiff, defendant number 4 contends suit was originally filed against the defendant number 4 to 18, and therefore the plaintiff cannot unilaterally delete them from the array of parties. Full stop. Next para. The plaintiffs have sought for the reliefs mentioned above. It is clear that the plaintiffs did not seek for any relief against the respondent, defendant number 4 to 18. Full stop. Therefore, the plaintiffs were well within their limits to delete the defendants from the array of parties. There is no error committed by the trial court in allowing the memo filed by the plaintiff and allowing defendant number 4 to 18 to be deleted from the array of parties. Hence, the petition lacks merit and is dismissed. If, however, the defendant number 4 is interested to participate in the proceedings, he may file appropriate application and the trial court shall consider the same in accordance with law. Yes.
Serial number 47, Krishna Swamy S.
Please, my lords, I appear for the petition in this case.
Ah.
The granddaughter files a suit against the grandmother for partition of the suit properties, alleging that they are all ancestral. Well, after closure of her evidence and after examining the one witness as PW2, your lordship will get it the entire evidence which I have produced before this honorable court. She files an application, the another 2 properties will have to be included to the schedule, but without producing any document thereto to say they are ancestral properties of the But I objected,
This can be done even in final decree.
yes.
This can also be done in final decree.
No, my lord, the point is, no document has been produced to establish that these are the ancestral properties of the grandmother's husband, or even otherwise. The one property which is likely to be included is a property which belongs to the second defendant, who it is an apartment.
Can take advantage of it, sir. Petition is dismissed, yes.
Grateful.
My lord, my lord,
Yeah, final decree include ಮಾಡ್ಬೋದಲ್ಲ sir, properties na.
finally, my lord, unless it is established that the properties belongs to the.
They will establish it. They will
evidence.
establish. Evidence ಮಾಡ್ತಾರೆ. ಮಾಡದೇ ಇದ್ರೆ take advantage.
My lord, your lordship may kindly see the IA that has been filed in support of it. The IA doesn't say what is the boundary, etc.
Yes, yes.
Whether such an application can be allowed, my lord.
Yes.
That's the, your lordship may kindly turn to page. No, kindly turn to page.
Description which is sufficient enough to identify the
No,
properties.
it is not sufficient. It is not sufficient, my lord.
ಏನ್ ಕೊಡ್ರಿ?
My lord, page 42.
Good.
Page 42. In page 7 of the plaint, after B schedule, boundaries, property boundary to be included as C schedule property. Plot number A 1206 Daffodil Satwa Salarpuria apartment Yeshwanthpur, which is included in subsequently as C schedule. This is how they want to describe. There is no clarity in this application. No document has been produced to say that this belongs to them.
The preceding paragraph would show, my lord, as to why I am including those properties.
No, but that the entire affidavit cannot be included as a part and parcel of the plaint, my lord. It will have to be very specific to say what is the boundary, what is the extent of the property, what is the khata number. Those things will have to be mentioned.
Yes.
They can't simply say that I am going to include this property also.
Yeah, plot number 1206 ಅಂತ ಇದೆ ಯಶವಂತ್
This one, plot all of that, it is totally incorrect.
Apartments and
Salarpuria apartments, Daffodil have even given the block number, my lord. Salarpuria is the
how
apartment.
many flats is it?
Plot A1206, my lord. A1206.
Plot number or flat? Is it flat or plot?
I'm not, I think it is flat, my lord. It is flat, my lord. Now that I stay nearby, my lords, I know Salarpuria is an apartment, and
I can't write that in
that's
the
right.
judgment.
I'm just saying. It's a, since your lordship asked me, it's a flat.
Then you please verify.
Yes.
Nobody. List on ಯಾವತ್ತು ಬೇಕು?
Any day.
Any day next week, my lords.
List on date.
6th December.
Please. My lords, could it be on
Okay.
7th instead of 6th?
7th
I'm sorry, the one day after that or preceding that.
December.
Grateful.
9th December.
Serial number 48, Murthy K.
Yes,
Murthy K.
I appear for petitioners, my lord. Lord, the petitioner is the first defendant in the suit for partition. The suit filed by, he is one of the daughter against the father, mother, and her brothers and sisters in respect of item number 1 to 18, Your Honor. The first defendant is the father of all the parties and wife of the fifth defendant. He consented to decree the suit for partition, my lord. The plaintiff is not appearing before the court. And further, the plaintiff sought for, so the first defendant, who is a father, elder member, senior member in the family, sought the permission of the trial court to cultivate the properties, my lord. By way of
to sell?
No, for it is he is an agriculturist. He sought the injunction restrain the defendant from cultivating the land, for which the trial court dismissed the application. Now, my lord, he appeared before the court and said no objection to decree the suit in respect of all the properties. The parties, the children, his children are not appearing before the court.
So what about the other defendants? What do they say?
Same, ಇವರೆಲ್ಲ ಮಕ್ಕಳು ಸೊ.
ಆಯ್ತು, ಶ್ರೀನಿವಾಸ, ಮಹೇಶ, ಗೋಪಾಲು,
children of Venkat Swami, there is a first defendant.
What do they say? Do they concede for a decree?
Yes, they are also, no, the first defendant, Shailama is the plaintiff. She is not appearing before the court.
First defendant Allah. GB
First-
Venkat Swamy is the first defendant.
First defendant, plaintiff, my lord. First respondent herein,
So Venkat Swamy is conceding.
conceding.
What about Srinivasa?
Srinivasa is son, now court ಮುಂದೆ ಬರ್ತಾ ಇಲ್ಲ. They are not appearing before the court.
Then the court has to decide the matter. ಇಲ್ಲ dismiss ಮಾಡಬೇಕು, ಇಲ್ಲ decide ಮಾಡಬೇಕು.
ಅಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ, because they are not allowing this person to do agricultural activities over this suit land.
Correct, Mr.
And
The
recently-
suit cannot be decreed on, see, on your say.
No,
If any of the defendants are not contesting and the plaintiff is not coming to the court can only dismiss it for non-prosecution.
not doing anything, and court also recently granted an order of TI restraining them from interfering with carrying out the agricultural activities over the suit property.
Correct, ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
So just I want notice on the parties and
No.
and I may be permitted to take out notice also. Maybe. Date
Issue
may be
emergent
fixed.
notice, it is open for the petitioner to serve the law and counsel represents the respondent number 1 before the trial court. This
Start.
on date. Sheikh Ismail.
Number 49, Sheikh Ismail.
I appear for the petitioner, Your Lordship. I seek for a short accommodation, Your Lordship. I humbly request for Monday.
Seeks time list on.
Huh?
ಆಯ್ತು, ಯಾವತ್ತು ಬೇಕು?
Monday, Your Lordship.
ಸಿದ್ದರಾಮಯ್ಯ.
I request for
Not Monday, mister.
any specific date in the next week, Your Lordship.
10th December.
Huh? 10th, 10th December. It's Siddaramaiah.
50, serial number 50, VB Siddaramaiah.
Obliged.
There's no representation for the list on date.
Serial number 51.
For the
Badri
petitioner,
Vishal.
cross-examination of the 90-year-old lady. Date may be fixed.
No, that, she is the commissioner.
Please, we had
ಯಾವತ್ತು ಹೇಳಿ?
we made a request.
ಇದರಲ್ಲಿ I'd like to bring to your kind notice. A very reasonable order was granted in their favor to go on that particular day. In fact, I bore half of the cost of the commissioner fee.
They have gone to the Supreme Court against this order.
They file a memo, I expect them, commissioner to consider the memo. And in the, what hurts is, in the Supreme Court, they make a statement, my lord, so kindly see the order of the Honorable Supreme Court. It's very clear that only in accordance with 7(2) of this Honorable Court's order, permission was granted.
Page 40.
Page
46.
46.
We are not, second paragraph, we are not inclined to interfere with the impugned order. However, clarify that it shall be open for the parties to read the respective evidence. The petition shall be granted opportunity in terms of paragraph 7(2) of the impugned order.
7(2) ಏನು?
It's very clear. On that
Page-
day, it should be done, otherwise it's closed. No
Page
further
30
opportunity.
38.
Page 38. And also one submission, if I'm permitted, in the first paragraph of page 46, it was submitted to the Supreme Court that the commissioner has deferred the matter. They're very wrong submissions. They cannot make a false submission.
Commissioner is
They're
commissioner
not
has
deferred.
even entered up.
Adjourned the matter.
She is not
What
adjourned the matter.
What happened was,
ಇಲ್ಲಿದೆ, where
page 46, first paragraph.
Commissioner has simply adjourned the matter.
Adjourned the matter.
Adjourned. She is not adjourned the matter. She is recorded clearly. They refuse to cross-examine.
How can you make?
On this, they have taken an order. How this can be entertained?
ಯಾವತ್ತು?
7th, my lords.
ಯಾವತ್ತು ಮಾಡ್ತೀರಿ ಹೇಳಿ?
Second Saturday, 7th.
I leave it to the court.
4 years they've not laid evidence.
7th, earlier the better, first, second ಯಾವತ್ತಿದೆ? 90-year-old lady, we can't.
6 years she's not laid evidence. 6 years.
ಹಂಗಂತ
Allah,
every day,
to
every
make
day,
that submission saying,
every day.
I can read the entire order sheet of conduct of this petitioner and making false statement in the Supreme Court.
2nd November.
December.
December.
2nd December, sorry.
10:30.
Which is the order challenge now?
Now, my lords, annexure A at page 20.
the defendant in the FDP 62 of 2010 on the file of the 10th Additional City Civil and Sessions Judge Bengaluru has filed this writ petition challenging the correctness of an order dated 25/11/2024. Next para. The facts in brief are that this court, facts in brief are that the respondent had initiated final decree proceedings in FDP 62 of 2010 to draw a final decree. This is only regarding mean profits.
Only mean profits.
Draw a final decree in pursuant to the preliminary decree passed in OS number 5110/2003 insofar as it relates to her claim for mean profits. Full stop. The okay, mean profits, full stop. The respondent was examined in support of her claim and thereafter was cross-examined on several dates. Full stop. In view of her advanced age, a commissioner was appointed to record the cross-examination. However, the commissioner could not execute the warrant which was returned. Full stop. Thereafter, since the respondent could not appear, her evidence was discarded. Full stop. The respondent then filed an application seeking permission of the court to recall the order dated 7/11/2022 discarding her evidence, which was again allowed in terms of the order dated 11/9/2024. Full stop. Another application filed by the respondent to lead evidence through her power of attorney was also allowed. This order was challenged by the petitioner herein in WP number 28224 of 2024. Full stop. This court, in terms of the order dated 6/11/2024, had permitted the respondent to be examined through a commissioner appointed by this court. It was made clear that the petitioner shall, it is made clear that the evidence of the respondent shall be recorded at her residence on 9/11/2024 at 11 AM. Full stop. This order was assailed by the petitioner herein before the Honorable Supreme Court in SLP Civil 27010/2024, which was dismissed on 19/11/2024. Full stop. The petitioner therefore made a request before the trial court for permission to cross-examine the respondent, which was turned down by the trial court in terms of the impugned order. The petitioner is therefore before this court challenging the said order. Next para. After hearing the learned counsel for the petitioner and the respondent, since the only issue is whether the petitioner should be granted further time to cross-examine the respondent, the same does not detain the court any further. To stop. It is appropriate that to meet the ends of justice, the petitioner is granted the last opportunity to go on with the to cross-examine the respondent. Full stop. Hence, the petition is allowed. The impugned order passed by the trial court is set aside. The petitioner is granted permission to cross-examine the respondent at her residence on 2/12/2024 at 11 AM. Full stop. It is made clear that the commissioner's fee of ₹50,000 shall be paid by the petitioner and the respondent in equal portions on 1/12/2024.
ನನಗೆ I am being saddled with the cost for the second file for no fault of mine. Let the
ಅವಾಗ
petitioner
ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
pay. ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ. Last time I paid half the money I paid.
ಏನ್ ಮಾಡ್ಬೇಕು?
Only the petitioner.
It is made, it is stated that the respondent has paid her part of the commissioner fee of rupees 25,000 and it is a petitioner who has yet to pay the commissioner fee. Therefore, the petitioner shall pay the commissioner fee on.
We
the
have
next
also
day.
paid.
Both have paid. Both have paid. Both have paid.
ನಾನು.
ಹಂಗಿದ್ರೆ ಹೊಡೆದಾಕಿದ್ದೀನಿ. Yes.
Only recording has.
Recording yours on 1st of December.
Second.
Second December. 2nd December.
Great.
End of the list ಬೇರೆ ಇದೆಯಾ? ಕೊಡಿ.
This matter for non-compliance serial number 1. Yes, Harish.
Three office objections, not, I am told. One is not regarding order sheet. Not I produced the e-courts website download, not annexure A, page 22.
Original photocopies. Annexure K1. Pins to be annexure. ಏನಿದು?
Not a suit, not a petitioner is the plaintiff before the trial court. Not a suit for permanent, suit for injunction, not in relation to not the landlord and tenant relationship between plaintiff and the defendants. Not annexure E series, annexure F series, not for a moment, if your lordship will see, annexure F3 at page 59. 6 months.
So is there some lease deed?
Yes, brother. Lease deed annexure A is there. Not that lease deed term has expired. Thereafter 6 months, not biannual invoice is raised. Not by way of not agreement between the parties under the invoice, not the tenancy is continuing. Not the last of the invoice is at annexure F3, page 59.
Yeah, what is there to show that you have paid the rent?
Not rent is paid. No amount is due. I have pleaded so in the plaint also. There is a termination notice. There is no mention about any amount pending. I have paid not in advance up to February 25.
Where's the termination notice?
Page 60. Annexure G. This is kindly see, this is dated 27/9/2024. This is not in relation to manufacturing lease. Para 7 is the para 7, para 6 is where they say 15 days. They are saying there is no mention about any amount being due. It is admitted that they are raising 6 monthly invoices.
Is issue emergent notice. It is open for the petitioner to serve the.
They are already removing everything there.
Emergent notice interim. The respondent is restrained from interfering with the possession of the petitioner until further orders.
Electric connection also they have removed. That also your lordship.
ಹಾಕೊಂಡು ಬನ್ನಿ ಅದು. Electric connection, move it.
ಅವರೆಲ್ಲ ಫಿಕ್ಸ್ ಮಾಡಿ ತೆಗೆದು ಬಿಡಿದ್ದಾರೆ.
ಏನ್ ತೆಗೆದಿದ್ದಾರೆ?
ಫ್ಯೂಸ್ ತೆಗೆದು ಬಿಡಿದ್ದಾರೆ.
ಫ್ಯೂಸ್ ಹಾಕೊಳ್ಳಿ ಎಷ್ಟು? ಫ್ಯೂಸ್ಗೆ
ಆಯ್ತು your lordship, would your lordship observe that?
ಆಯ್ತಲ್ಲ ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ಯಲ್ಲ.
Great.
ಫ್ಯೂಸ್ ತೆಗೆದು ಫ್ಯೂಸ್ ಹಾಕು.
Not hand delivery, I'll file memo.
Office objection will be complied within 1 week, failing which the petitioner shall not be entitled to the benefit of this order. Yes.
Number 2, fresh matter Narayan Sundar PM.
It is, Lordship. My lords, the subject matter is a building, my lords. We have title deeds from 1932 to this day. Now, my lords, what happened was,
how did you get to know that this petition is filed?
But they came and they served me a copy, informed that this honorable court has directed them to serve a copy
Okay,
and to bring it. Lord, it's been served, Lord. Otherwise, I wouldn't have
office,
come.
office.
Office, they
Office
served it
objection.
on the BDA and said that, Lord, 2:30 the matter would be taken. Lord, only to that extent I was informed, Lord.
Yes, what is this?
My lords, the 1932 is our original sale deed, my lords. Then 1966, there is a family registered partition. And then there was a 1971, there were 2 sale deeds in favor of my mother by 2 persons. And then, my lords, there was a release deed amongst us, and then the kata was amalgamated, and there is a plan approved, and we have put up construction. BBMP has put up, given all the records in our favor, my lords. Now they are trying to demolish the building. They are not issuing us any notice, and they are not telling why they want to interfere also. We moved the trial court, my lords.
Where are the photographs?
My lords, last page 135, my lords.
135.
44. 144 according to annexure P.
Change ಆಗಿದೆ ಸ್ವಾಮಿ 153 annexure P.
Constructing it newly.
ಹೌದು ಕಂಪ್ಲೀಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಆಮೇಲೆ ಖಾತಾ 133 ನಲ್ಲಿದೆ, 134 ಅಲ್ಲಿದೆ, ಟ್ಯಾಕ್ಸ್ ಪೇಡ್ ರಿಸಿಟ್ 132 ನಲ್ಲಿದೆ, ಕಮೆನ್ಸ್ಮೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ 135 ಅಲ್ಲಿದೆ. ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಡನ್. 1932 ಇಂದ ನಮ್ ಸೇಲ್ ಡೀಡ್ಸ್. 1966 is the next deed.
But they claim under one Nagama, who participates in the acquisition proceedings, files a 18.3 reference. Based on her application, the award amount is transferred to the land acquisition city civil court for disbursement. Compensation is deposited, possession is taken. All of a sudden, Lord, they start putting up a construction. And Lord, yes, Lord. And Lord, may kindly see this. Sorry.
Nagamma is not in the picture.
No. Lakshmi, kindly take this, Lord. They have their averments in the sale deed only. There are three persons. Sorry, Lord. Devamam, Lord. My
Devamma.
apologies. Devamam, Lord. She has participated. She files a 18.3 reference. According to it, they have.
Krishnas are the sons of Devamma.
Yes, Lord. They claim through her, Lord.
We claim through Devamma only.
There's a
There's absolutely no-
averment
no-
in the sale deed as well as the release deed.
So what is there to show that possession is taken?
Lord, possession is taken, Lord. I have a possession mahazar. And Lord, after 18.3, Lord, 18.3 was made after 12.2 notices were served. And possession is taken along with the reference, Lord. I have sent all these documents to the civil court. Lord, way back in the 1983, all these things have happened. And Lord, now all of a sudden they start trying to put up a construction. When we go there, Lord, this
Suit is filed for what?
suit is for bare injunction.
Bare injection we filed, Manas. 2019 is our construction. They have
And
given
the-
all the records.
Suit maintainable. How
Manas,
is the suit maintainable?
It was for injection, Manas. We did not
How
know.
is the suit maintainable
Manas-
against BDA?
Manas, against BDA Mellors, originally, ideally speaking, Mellors, we should have issued a notice. We moved an application under 64 because we don't know what is their claim. They suddenly come and try to demolish the building. And
Yes.
under those circumstances, we had no other alternative, Mellors. We had to move the court. And we filed an application for dispensation also. Now that the court has issued, emergent notice, Mellors, that's where we are before your lordship. All that I'm requesting, Mellors, is that if they have any valid, if they have taken the
But the
process.
suit is not maintainable against the BDA.
Bridges.
That is the law declared.
Bridges.
64-2 ನಲ್ಲಿ ನಾನು
Not 64 alla. Which is the judgment?
Bridges Reddy is
Brijesh Reddy.
Brijesh Reddy, if the possession has been taken, even that I don't know.
Saying that.
They are telling that, Mellors, still then, Mellors, let them inform us. When they have come all of a sudden, Mellors, after such a long time, if they say that what is the date of acquisition, that they have not told us. Now, Mellors, if it is there, Mellors, they have to notify us.
Notify ಇದೆಲ್ಲ ಹಳೇದಿದೆಲ್ಲನು.
ಹಳೇದು ಅಂದ್ರೆ ನಾಗಶೆಟ್ಟಿಹಳ್ಳಿನಲ್ಲಿ ಎಂಟೈರ್ ಯಾವ ಜಾಗನೂ ಖಾಲಿನೇ ಇಲ್ಲ. ಕಂಪ್ಲೀಟ್
ನಾಗಶೆಟ್ಟಿಹಳ್ಳಿ.
ನಾಗಶೆಟ್ಟಿಹಳ್ಳಿ ಅಷ್ಟು.
These are all 1976 acquisition.
Yes.
ಅಲ್ಲ.
Perhaps you were not even born then.
Mellors, 1970, maybe Mellors, the entire area, everything is jam packed. There is not even one
This is a
open
different
space
issue,
left
madam.
over.
That is a different if
ಅಲ್ಲ, I agree with
court
you.
ನೀವು illegal ಆಗಿ ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ, illegal ಆಗಿ ಅಂತಂದ್ರೆ ಇಡೀ ಲೇಔಟ್ ಅಲ್ಲಿ
Madam, I am a resident of that area. I know that.
selective discrimination.
Court ಬಂದ್ರೆ everything is should be as per law. ಹೊರಗಡೆ
Selective discrimination.
Everybody is doing so many things without coming to the court.
Give us something, Mellors, so that at least I can approach the court under the section 27 alla scheme lapse agidya ಏನು ಅಂತ ಅದನ್ನ ನೋಡಬಹುದು. That's where, Mellors, I'm requesting your lordship to kindly intervene. Till
1976 ಇವಾಗ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾ ಇದ್ರಲ್ಲ.
ಅಲ್ಲ, ನಮ್ಗೆ ಅವ್ರು ತೊಂದರೆನೇ ಮಾಡ್ಲಿಲ್ಲ. ನಮ್ಮ ಹತ್ರ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಸಿನ್ಸ್ ಸೋ ಲಾಂಗ್ 2019 ಇಂದ ನಮ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಮೆನ್ಸ್ಮೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ಎಲ್ಲ ಆಗಿದೆ.
ಸಾರಿ ಮೇಡಮ್.
ಏನಂದ್ರೆ ಲೆಟ್ ದೆಮ್ ನಾಟ್ ಪ್ರಿಸಿಪಿಟೇಟ್, ಲೆಟ್ ದೆಮ್ ಗಿವ್ ಅಸ್ ವಾಟ್ ಇಟ್ ಇಸ್ so that we will challenge it in accordance with law.
Yes. Don't put up any further construction.
We will not.
Yes, Mr.
Status quo maybe.
ನೋಡಿ photos ಇದೆ ಇದು. Will ensure that you don't put up any further construction. Yes.
Let them give us what are
Not
all
put
the
up any
information.
Further construction
Please.
till the trial court decides the application.
Please, my lords.
Could it-
Not, in the trial court, not they make a specific plea with regard to the survey number, not in the sale deeds which they have produced. But ultimately, Lord Lakshmi, kindly see how the suit schedule property has been described.
Can you produce all material, whatever that? ಏನಿದೆ ನಿಮ್ಮ ಪೊಸಿಷನ್ ಯಾವ ತಗೊಂಡಿದ್ದಾರೆ ಕೊಡಿ ಅದು.
Not, we have taken possession in 1982.
Produce the document. Produce ಮಾಡಿ. ಯಾವಾಗ ಮಾಡ್ತೀವಿ? Monday.
Lakshmi, I have to Tuesday, Lord, before the
Tuesday.
trial.
Don't do anything till then.
Let them also not.
ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the respondent seeks time to place on record documents to establish that the possession of the suit property was taken. Full stop. In that way of the matter, till the next date of hearing, the respondent is restrained from demolishing the existing construction as found in the photograph at page number 153. It is also made clear that the petitioner shall not put up any construction of whatsoever nature till the next date of hearing.
Grateful. If they serve the copy on us earlier. my lords,
I may,
we can give the,
let them serve a copy of the entire writ petition, Lord.
we will also serve, let them also give us documents so that we'll.
ನೀವು ಫಸ್ಟ್ ಕೊಡಿ, ನೀವು ಕೊಡ್ಬೇಕು.
Properties.
ಅರ್ಧಂಬರ್ಧ ಕೊಟ್ರೆ ಅದೇ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ತಗೊಳ್ಳಿ.
Grateful.
Hand delivery.
ನೋಟಿಸ್ ಬೇರೆಯವ್ರು ಇದ್ದಾರ? ಅವ್ರು ಇದಾರೆ, ಬಂದ್ರಲ್ಲ ಅವ್ರು. ಮಿಸ್ಟರ್ ಚರಾಟಿ,
Please.
MP ಅಲ್ಲ?
MV.
MV Charati accepts notice for the respondent. Office is directed to show his name in the cause list.
Please.
ಅದಾದ್ಮೇಲೆ ಇದು ಮಾಡಿ. Yes, ಪೃಥ್ವಿ ಒಡೆಯರ್. ಕರೀರಿ ಅದು ಯಾವ್ದು?
Past door matter, list number 1, serial number 10. Manamohan PN.
ಮನಮೋಹನ್. ಮನಮೋಹನ್. ಏನಾಯ್ತು? What happened?
Here only, yes. Kindly pass.
Where is your lawyer, madam?
In December.
Yes.
Until December. Tuesday.
Let's, we are agreeable not for that, what was said in the morning, but they again said they don't want to do that. They want to give a separate door, different dimension.
ಮಿಲಾಡ್ ಅವರು 6 ಅಡಿ ಡೋರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. 6 ಅಡಿ ಡೋರ್ ನಾವು ಮುಂಚೆನೂ ಕೊಟ್ಟಿಲ್ಲ. ಆಮೇಲೆ ಇಟ್ ವಿಲ್ ಬಿ ಎಫೆಕ್ಟ್ ಟು ದಿ ಸ್ಟ್ರಕ್ಚರ್ ಆಫ್ ದಿ ಬಿಲ್ಡಿಂಗ್. ಅಲ್ಲಿ ವಿಂಡೋ ಎಲ್ಲ ಇದೆ, ಅದನ್ನೆಲ್ಲ ಒಡಾಕ್ಬಿಟ್ಟು ಅದು ಟೋಟಲ್ ಇರೋದೇನೆ.
6 ಅಡಿ ಎಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಪ್ಲೀಸ್
ಒಂದು ಡೋರ್.
ಮಿಲಾಡ್ ಈಗಿರೋದು
cannot be 2 feet or 2.5 feet.
ಪ್ಲೀಸ್ ಮಿಲಾಡ್ ಈಗಿರೋದು 2.2 ಫೀಟ್ ಇದೆ, ಮತ್ತೆ ಪ್ಯಾಸೇಜ್ 2.5 ಫೀಟ್ ಇದೆ. ನಾವು 3.5 ಫೀಟ್ ಇಂದು ಹೊಸ ಡೋರ್ನ ಅದೇ ಜಾಗ ಅದನ್ನ ತೆಗೆದುಬಿಟ್ಟು 3.5 ಫೀಟ್ ಇಕ್ಕೊಡ್ತೀವಿ ಅಂತ
Seek
ಹೇಳಿದ್ವಿ.
instructions, not may have it on Monday, not because his proposal is giving it to me now.
3.5 feet. What is the area that you are occupying?
It's about 600 odd square feet, not. Although the only difficulty is not, the doors are not what he is proposing is next to another road. I can't not turn. That's the only difficulty. But can I make one request? Otherwise not.
First of all, I don't know, you're doing this sweet meat business in a residential area.
But it is only empowerment of women, Lord. People who are widows, not they are taken care of, not for this purpose. They are encouraged to become
How can you put in a
entrepreneurs.
residential area? ಎಷ್ಟು ವಾಸನೆ ಬರುತ್ತೆ, ಎಷ್ಟು
ಇಲ್ಲ ಅದೆಲ್ಲ ಏನು, they have taken care that none of it that happens. He says everything is taken care of, so that does not happen is what he says.
ಮನೇಲಿ ದೋಸೆ ಮಾಡಿದ್ರೆ ಇಡೀ ಏರಿಯಾ ಗೊತ್ತಾಗುತ್ತೆ. You're talking of sweet meat. You say you can contain the smell or the fragrance. How can you contain it?
He has done certain things, but it is done scientifically is what he tells me.
already ಬೇರೆ ಕಡೆ ಸಿಗುತ್ತೆ. ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋತೀರಿ ಏನಾದ್ರು some
ಮೂರೇ
money?
ತಿಂಗಳು ಅಂಡ್ ಅಗ್ರಿಮೆಂಟ್ ಇರೋದೇ ಇನ್ 3 ತಿಂಗಳು, ಮಾರ್ಚ್ ವರೆಗೂ ಅಷ್ಟೇ.
ಎಷ್ಟು?
ಮಾರ್ಚ್ಗೆ ಅಗ್ರಿಮೆಂಟ್, ಆಸ್ ಪರ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾರ್ಚಿಗೆ ಮುಗಿಯುತ್ತೆ.
That's a
ಈಗ ಅವರು
different issue
ಡೋರ್
because-
ಇಡ್ತೀವಿ 6 ಫೀಟ್ ಹೊಡೆದಾಗ.
Well, I will not get into it because that's a different issue because he says he is constructed. But can I not make another suggestion otherwise? Lord, till this is sorted out, let us not keep the door which was earlier open, that passage which was using, not as per the interim order.
No, this I think is a nuisance. It's not only you, there will be so many employees, workers coming in,
True.
going out. And it's a house. ನೀವೇನೋ ಏನೋ ಉದ್ದೇಶ ಹೇಳ್ಕೊಂಡು ಅವ್ರ ಮನೆ ಒಳಗೆ ಹೋಗಿದ್ದೀರಿ, ಏನೋ ಆಗಿದೆ.
No,
ಏನೋ
even she
ಮಾಡಿದ್ದೀರಿ.
was my employee. Even the respondent was my employee in the company. And not the building belongs
Looks
to
like
me.
all is not well
Yes,
between you and that respondent.
it is not well.
Ah.
Obviously, but it's some
ಬೇರೆ ಬೇರೆ
something
ಏನೇನೋ ಇದೆ ಅದು.
ಬೇರೆ
Looks like that. You know, for 600 feet, why will you hang on to this place?
No, he is only not saying that the building lot is constructed by him, and lot therefore.
ಆಯ್ತು ತಕೊಳ್ಳಿ, whatever you want to do. But this cannot stop her from lodging a complaint before the BBMP. Food inspector ಬರ್ತಾರೆ, ಚೆಕ್ ಮಾಡ್ತಾರೆ, ಎಲ್ಲ ಆಗ್ತದೆ. Nuisance will be manifold.
Even she is manufacturing. ಇನ್ನೊಂದು ಫ್ಲೋರ್ ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅವ್ರದ್ದು ಹೋಗುತ್ತೆ, ನಿಮ್ದು ಹೋಗುತ್ತೆ ಅಷ್ಟೇ. ಅವ್ರದ್ದು ನಂದು
I have the licenses, etc. Not I have taken. It's not.
But how can you do it in a residential area? You can't do manufacturing activity in a residential area.
It's cooking activity. ಬೇರೆ.
Cooking, is it not manufacturing? You're manufacturing sweets. ಎಣ್ಣೆ, fumes. And you say you're able to manage it. ನೋಡಿ ಯೋಚನೆ ಮಾಡಿ ಏನು. Or take some money, or if she's willing to give you some money, take some money and get out. Here, are you willing to pay him some money?
I don't.
Are you willing to pay him some money? Huh? ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಅವ್ರಿಗೆ?
ಅವ್ರು ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಸರ್?
ಎಷ್ಟು?
50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
50,000.
But it will not happen. Not.
Hmm.
It will not happen. Not. There is something.
ಮಾಡ್ಕೊಳ್ಳಿ.
Let's have it on Monday. Not.
List on Monday.
The earlier interim order would be extended.
Interim order granted is extended till the next date of it.
Please.
Prithvi Wadiyar.
Grateful.
Grateful.
I'll pronounce his judgment on Monday. In Mikkida matters, I will not wait for that. List on Monday for pronouncement on. Huh?
But since your lordships have referred the
Anyway,
thought for
it has not come. I will not wait.
In the register of judicial.
Today and
CJ will be aware of
yesterday
the
and
word itself, my lord.
yesterday and today, there he is
No,
not
by
sitting.
Monday ಬಂದ್ರೆ okay.
ಬರಲ್ಲ my lord. See, I have inquired in the register of judiciary. ಅಲ್ಲಿ ಹೇಳಿದ್ರು CJ will be available only on 3rd, after 3rd. Will come only on 3rd. ಅಷ್ಟು ತನಕ hold ಮಾಡಿದ್ರೆ by 4th election will be over.
But that is not the subject matter in this writ petition. Holding of election complete ಆಗುತ್ತೆ ಇನ್ನೊಂದು, that is not the subject matter. But that may not be a ground. But I will leave it to your lordships. I will leave it to your lordships.
Came before this.
Because that may not be proper because since
Monday ಬರುತ್ತಂತ. Monday ಬರುತ್ತಂತ ಅದು. Then we'll list it for dictation ಅಂತ ಹಾಕ್ಬಿಡಿ. 2:30 we'll take it up for dictation. Monday.
My lord, I may make a mention regarding a matter for dictation, my lord. This is the cause of action matter, my lord.
Serial 19 passed over matter Monday.
47 pass on.
My lord, serial number 60.
Please wait, madam. Lawyers waiting in the court, please wait. Yes.
Serial 19.
19, your lords. Be extended and have it up on any other.
Monday, my lords.
Monday also is no problem.
Monday. My lordships heard it in part. I just need to pass on a memo with the party. Yes.
One date ಕೊಡಿ ಅವರು.
Monday.
List on date ಕೊಡಿ. Monday ಬೇಡ. Monday.
5th December.
Lords, interim order may be extended.
Interim order.
serial number
27.
serial number 9.
27.
Second list.
7.
ಏನಾಯ್ತು? ಏನಾಯ್ತು?
They are unable to offer that amount.
25,000
ಆಗಲ್ಲ.
ಆಗಲ್ವಾ?
ಕಷ್ಟ ಆಗುತ್ತೆ.
ಆಯ್ತು.
My lord, serial number.
Serial number 9.
ಯಾವತ್ತೊಂದು ಡೇಟ್ ಕೊಡ್ರಿ.
Interim order.
My lord, serial number.
Serial number 8 pass over matter.
My lord. This one, serial number 46.
No, either one of you, all of you should wait patiently, otherwise I leave, my time is over. So all of you, please wait patiently. Yes, madam. ಯಾವತ್ತು ಬೇಕು ಹೇಳ್ರಿ ನಿಮ್ದು?
12th, sir.
12th.
Interim order.
Serial number 46, my lord, for dictating orders, list 1.
See number 46.
Yes, ma'am.
ಯಾವುದು?
This is that.
Aditya, which is this?
This COVID matter, my lord. That COVID, he was working at home, Malur matter, yes.
Cause of action.
Yes, my lord.
My lordship,
Tuesday, put it Tuesday. 46 Tuesday.
Maybe 2:30, my lord, if the court can accommodate.
List 2, serial number 16.
ತಪ್ಪಿಸ್ಕೊಂಬಿಟ್ಟಲ್ಲ ಇವತ್ತು.
Serial number 16. Next to 16.
Sharath Kumar.
Awesome. B7.
Argument ಮಾಡಿ.
Page number 6 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಏನಂತ?
Dash number 5 ಅಲ್ಲಿ.
ಒಂದು ಹೇಳ್ಬೇಕು.
It was held by the filing of the single petition challenge.
ಸ್ವಲ್ಪ but what is challenged here? ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ?
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ಅವರವರ ಇದಾಗ್ಬಿಟ್ಟು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅನ್ಸಿಸ್ಟಲ್ ಪ್ರಾಪರ್ಟಿ ಇದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ನಾವು
ಮೇಂಟೈನಬಿಲಿಟಿ ಯಾಕೆ ಇಶ್ಯೂ ಬಂದಿದೆ ಇಲ್ಲಿ?
ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕಂತ
ಏನ್ ಹಾಕಿದ್ರ?
I am appear for respondent your honor. ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಅದಕ್ಕೋಸ್ಕರ ಮೆಂಟಬಿಲಿಟಿ ಇದು ಮಾಡ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ. ಅವರು OS ಪೆಂಡಿಂಗ್ ಇರೋ ನಾಲೆಡ್ಜ್ ಇವ್ರಿಗೆ ಇತ್ತು ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
So what is challenged in this petition? ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು? ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ?
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ OS ಆಗಿದೆ.
27/11/23. 27/11/23. ಓದಿ ಆರ್ಡರ್ ಓದಿ.
Civil suit to challenging the award of the Lok Adalat by way.
ಸೊ ನೀವು OS ಡಿಗ್ರಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ನೀವು.
ಅದನ್ನೇ ಹಾಕಿದ್ದೀನಿ.
ಎಲ್ಲೇ ಇದೆ?
ಪೇಜ್ ನಂಬರ್ 8 ಸರ್.
Sir, you please come to
OS ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರದ್ದು.
ಅದು ರಿಲೀಫ್ ಬಂದ್ರು. Please come to the relief. ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಲ್ರಿ?
ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿದಾರಲ್ಲ. Office objections regarding maintainability are overruled. List the petition for preliminary hearing on date ಕೊಡಿ. ಯಾಕೆ ಸುಳ್ಳು ಇದು ನೋಡಲ್ವ ನೀವು ಪಿಟಿಷನ್?
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ ಯಾಕೆ ಸುಳ್ಳು ಹೇಳ್ತೀರಿ? Why you are so irresponsible, mister? List on date ಕೊಡಿ.
Cause list number 2, serial number, cause list number 2, serial number 59, my lord.
Cause list number 2 ಇರುತ್ತೆ. Still number 8. Filed IA for extension of time ಇರುತ್ತೆ.
Serial number 8. ಅದೇನಾಯ್ತು? What happened?
Rent which is due.
ಯಾವ ಕೊಡ್ತೀರಾ?
Responding withdraw the IA as
ಬರ್ಕೊಳ್ಳಿ. Learn counsel for the petitioner. Petitioner,
I'm for the respondent in this matter, Milno.
Learn counsel for the petitioner does not press IA 1/24. Hence the same is rejected.
Cause list number 2, serial number 59, my lord. Cause list number 2, serial number 59. Kind extend entry ಮಾಡಮ್ಮ.
ಆಯ್ತು, ಎಂಟ್ರಿ ಮಾಡ್ರಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ, ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಡಿ. Yes.
Serial number 57, my lord. Any date may in the first week of December.
ಶ್ರೀನಿವಾಸ.
No, ma'am. First list serial number 57.
ಕೊಡ್ತಾರೆ. Yes. ಏನಾಗ್ಬೇಕು? ಮಂಡೇ ಆಗಲ್ಲ. Some other day. Yes.
Any date, sir.
Yes. Yes, madam. Who are you? In which case? 58. ಆಯ್ತಲ್ಲ, ನಟರಾಜ್ ಅಪಿಯರ್ ಆದ್ರಲ್ಲ.
I'm for the petitioner. First list.
ಯಾವಾಗ ಕೊಡ್ತೀರಿ ದುಡ್ಡು? ಅದೇನು?
He has to pay, madam.
Who has to pay? You have to pay.
Please, madam.
Yes, madam. Will you pay the rent? They say that you're. Madam, you can't dodge the case like this. No, but then you deposit, show your bona fides by depositing the rent. List on ಯಾವತ್ತು ಬೇಕು? 12th, but please. Madam, then you engage a lawyer. But we will not postpone the case unduly. Just list on 12th. What is your name? Megha. Emmy Nega, N for Netherlands. And Miss Nega or Mrs. Nega? Mrs. Nega, who represents the respondent,
He's
has a-
14%.
has appeared. Antarang is a proprietary concern. Mrs. Nega, who is a proprietor of the respondent, has appeared in person and seeks time to file statement of objections. List on 12th as a last chance. 12th December as a last chance. Yes. ಏನಾಗ್ಬೇಕು? ಬರುತ್ತೆ ಮೇಡಮ್. ಯಾವತ್ತು ಬೇಕು ಡೇಟ್ ತಗೊಳ್ಳಿ. ಎಸ್ ಮೇಡಮ್. Date will be fixed by him, yes. ಏನಾಗ್ಬೇಕು? ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಎಲ್ಲ ಕೊಡ್ತಾರೆ. ಬೇರೆ ಏನಿದ್ರೆ ಹೇಳಿ.
List number 2, serial number 58, my lord.
List number 2, serial number 57, Srinivas.
58.
ಏನ್ ಬೇಕಪ್ಪ ಇವಾಗ?
I wanted to sell this property. Now the suit is for declaration position is pending. Recently, they have challenged they have converted the suit for declaration. Now they have responded to they have filed memo. I have served the trial court advocate, entire petition. Now the matter is before the trial court is argument go with. I have filed recall also.
ಯಾವತ್ತು ಬೇಕು ತಗೊಳಪ್ಪ? ಯಾವತ್ತು ಬೇಕು? Third, yes, next. No. Without hearing, I can't grant an interim. Yes, madam. List number, serial number 70. Rikab Chand. When do you want it? Date. Yes, they will give a date. Yes. What is so great about your case? That it should be taken up on a priority. Yes.
My lordship, list number 2, serial number.
List number 2?
15. Serial number 58, my lordship. Kindly be on 9th December, my lordship.
Yes.
Interim order may be extended.
ಯಾವ್ದಕ್ಕೆ ಹೋಗಿದ್ಯಾ?
Court officer, sir.
Serial number 47. B group matter serial number 47. List number 147.
I appear for respondent.
Yes, sir.
Date ಯಾವ್ದು ಕೊಡ್ತೀರಿ?
Date 11th December.
11th.
Serial number 40. Serial number 49. Last location ಕೊಟ್ಟಿನಿ. ನೀವು ಯಾರು? ಬೇಡವಾ? 19 December. Serial number 50. 11. Serial number 51. Wait, sir. 13 December. For 53. Madam. Bani. 46 photo ita. 46 3rd December, madam. Wait ಮಾಡ್ತೀರಿ ಇಲ್ಲಿ ಪಾಪ ಇಷ್ಟೊಂದು ಜನ ವೇಟ್ ಮಾಡ್ತಾರೆ, ನೀವು ವೇಟ್ ಮಾಡಿ ಸ್ವಲ್ಪ. ಸೀರಿಯಲ್ ನಂಬರ್ 53 ಹರೀಶ್ ಏನ್ ಹೇಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 54 13 December. Serial number 55. Serial number 56. 10th December. Serial number 57. ಆಯ್ತು ಸರ್ 6th 7th ಶನಿವಾರ 59.
Sir, first list or second list?
First list, madam. Serial number
Okay.
60. 60. 13 December. 61. Naveed Ahmad. Serial number 62. Serial number 64. Kashinath JD. 66. 9th. 67. Madam. 3rd December ಆಗಲ್ಲ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. 68. 9th. 68. Next week. 12th December. 69. 71. 70. 6th December. First week ಅಲ್ಲಿ ಕೊಡಿ ಅಂದ್ರು ಸಾಹೇಬ್ರು. 71. ಅದ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್ 5ನೇ ತಾರೀಕು. 72. ಇಲ್ವಾ? 18. ನೀವ್ಯಾರು ಸರ್? ಅದಕ್ಕೆ ಬ್ರಿಟಿಷ್ನರ್ ಕೇಳ್ಬೇಕಲ್ವಾ? ಆಯ್ತು ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. 12th December ಕೊಟ್ಟಿರ್ತೀನಿ. 73.
ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ 12th ಅಥವಾ 14th ಕೊಡಿ ಸರ್.
17th December ಸರ್.
ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
74. ಫಸ್ಟ್ ವೀಕ್ ಬೇಡ, ಸೆಕೆಂಡ್ ವೀಕ್ ತೊಗೊಳ್ಳಿ. 12 ತೊಗೊಳ್ಳಿ. 10 ಜಾಸ್ತಿ ಇದೆ ರೀ, 12th ಇರ್ಲಿ. 75. 12. 76 ಆಯ್ತು. 76 ಮಂಡೇಗೆ. ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಈ ಗ್ರೂಪ್ ಮ್ಯಾಟರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 52. ವಿಜಯಶೇಖರ್ ಗೌಡ. 10th ಸರ್. 10th. 8th ಸಂಡೇ. 53. 54. 55. 56. How Tuesday? Next Tuesday. ಸರಿ ಸರಿ. ಟ್ಯೂಸ್ಡೇಗೆ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಇವ್ರೆ. ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಾ? ಏನ್ ನಾವು ಅನ್ಕೊಂತೀವಿ, ಬಟ್ ಅವತ್ತು ಹೋಗಿಲ್ಲ, ಜಾಮ್ ಆಗುತ್ತೆ ಅಲ್ಲಿ. 57. 57 ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ವಾ? 57 ಯಾರು ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ರು? 6th December. 59. ಪ್ರಸಾದ್
ಸರ್ 58 9th December ಗೆ ದಯವಿಟ್ಟು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮೇ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
9th 19th ಮೇಡಮ್?
9th 9ನೇ ತಾರೀಕು.
19th ಅನ್ನಂಗಾಯ್ತು ನನಗೆ.
ಇಲ್ಲ 9 ಸರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದ.
ಆಯ್ತು ಮೇಡಮ್, ಆಯ್ತು ಮೇಡಮ್. 59.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಲ್ಲ ಸರ್?
ಆಗುತ್ತೆ ಮೇಡಮ್. 60.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಸರ್.
60 ಮೇಡಮ್. 9th December.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
61. ಮೇಡಮ್ 16 ತೊಗೊಳ್ಳಿ ಮೇಡಮ್. 16 ಮೇಡಮ್. 62. ಇಂಟಿಮೇಟ್ ಆಗುತ್ತೆ ಮೇಡಮ್. 62. 63. ನೆಕ್ಸ್ಟ್ ವೀಕ್ 12 ತೊಗೊಳ್ಳಿ ಮೇಡಮ್. 12. 64.
ಸರ್ 64 ಒಂದ್ ಮ್ಯಾಟರ್ ಆಲ್ರೆಡಿ 17th ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವತ್ತಿಗೆ ಕೊಟ್ಬಿಡಿ ಸರ್.
ಯಾವತ್ತು ಸರ್?
17-12 ಅಂತ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಒಂದು.
ಸರಿ ಸರ್, 17-12 ತೊಗೊಳ್ಳಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
65 17-12.
ಥ್ಯಾಂಕ್ ಯು.
68. 66 ಸಾರಿ. ಸರಿ ಮೇಡಮ್. 67.
ಸರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗೆ ಸರ್ 6th of December ಗೆ ಕೊಡಿ ಸರ್ ಪ್ಲೀಸ್.
ಇಲ್ಲ ಸರ್, 6th ಫುಲ್ ಇದೆ ಸರ್.
ಹೌದಾ? 7th of December ಸರ್.
12 7th ಸಾಟರ್ಡೆ 12 ಕೊಡ್ತೀನಿ.
9th ಆಗಲ್ವಾ?
9th ಫುಲ್ ಇದೆ, 12 ತಗೊಳ್ಳಿ.
12th ಓಕೆ ಸರ್, 12th December ಗೆ ಕೊಡಿ ಸರ್.
68.
ಥ್ಯಾಂಕ್ ಯು.
69. 70. December 2nd ನಾಳೆ ನಾಡಿದ್ದೆ ಆಗ್ಲೇ ಮ್ಯಾಟ್ರ್ ಲಿಸ್ಟ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ. ಫೋರ್ತ್ ಬೇಡ, 5th ತಗೊಳ್ಳಿ. 71. ಇಲ್ವಾ ಇಲ್ವಾ ಕರಿ ತಕೊಂಬ ಒಂದ್ ಯಾವ್ದಾರ
ಸರ್.
ಸರ್ ನಿಮ್ದೇನ್ ಸರ್ ದೀಪಕ್ ಸರ್?
ಸರ್ ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 28 ಏನಾಯ್ತು ಸರ್?
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 58 28 3rd December ಹೋಗಿದೆ ಸರ್.
3rd December ಸರ್. ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು ಸರ್? ಇಲ್ಲ
ಇಲ್ಲ, ಇಫ್ ಆಫೀಸ್